Please be seated. Opening the executive session now on House Bill 185 relative to the determination of parental rights and responsibilities based on shared parenting and shared access to the child's records. A lot of work has gone into this. You should be getting Amendment 758 coming around both ways. And if we run out of amendments before we run out of people, we probably have the opposite problem. So just make sure that you have 758 Representative Post's bill and her amendment. She got all her or many of her co-sponsors to sign on as well. And when you have had a chance to read it over, this purports to solve the problems that we saw with the original bill and some of the earlier amendments. This has been worked on quite extensively. I noticed my notes from the original hearing. I think Representative Post has tried to take them into account, and you can read it and see if you think that.
Mr. Chair, over here, are there any other amendments on this bill?
I think so.
Is it possible we could compare or?
You
Look at-
may if you wish.
Yeah, there's
They
another
should have
one I'd
been
like
handed
to.
out, or they've been withdrawn. That is to say, I got a copy, but the sponsor did not wish to proceed with it. There is an amendment 712, also by Representative Post. There is an amendment 551, also by Representative Post, and she has wished that this is her amendment to be considered.
Okay, that's all I want to see is what's being presented to the committee. So this is the total of what's being.
Yes, there
submitted
is
to committee.
no amendment to my knowledge that comes from any other party.
Okay,
Okay?
Good morning.
Guten Morgen.
I have a question related to the amendment, and it would be a question for Richard Head. Is that I'm just curious about
If it's a factual question,
joint-
it is possible. Counselor, would you mind coming up?
I'm
You may state your question. Once he's turned his mic on. Does that all the time. He's
good
good.
morning.
Good morning.
I'm just curious if joint parenting schedule, if that is a current term in the family courts.
You're referencing line 5?
Line 5 of the amendment.
Sure. So,
We had referenced equal parenting time, that there was a new definition, and now we have joint parenting schedule in this amendment. So I'm curious in terms of the family courts, if that is language that,
RSA 461A:1, which is definitions, has a definition of parenting schedule. And parenting schedule means a schedule of when the child is in the care of each parent. So I don't know that adding the word joint changes that
Okay.
definition.
okay, thank you.
Good question. Thank you. Anyone else? Yes. Do I see Representative Moulton?
Thank you, Mr. Chairman. Could you just repeat what you said, what the definition was for parenting time?
Sure. So parenting plan is defined in RSA 461A:1. Parenting plan, I'm sorry, what I read before was parenting schedule. Parenting schedule, which I read before, it means the schedule of which the child is in the care of each parent. And then parenting plan, which I think was your question, means a written plan describing each parent's rights and responsibilities. Sure.
Any discussion on the bill as amended before we entertain a motion? Representative Bizimone.
Thank you, Mr. Chair. I'm sorry, Mr. Head. Is it okay to ask him another question?
I think he's good for several.
Yay. Thank you both. I have a question concerning line 6
Of the amendment?
of the amendment. It says including overnights with the child by both fit parents. What determines fit? Or is there a determination in 461?
I don't know what that means.
Thank you. One more question, please.
You may ask another question.
On line 8, it continues from line 7. Responsibilities, best interest. What does the RSA say that means? Please.
Sure. Give me 1 second.
I think A2 grabs it.
Well, A6. There we go.
Okay, yeah, A6 too.
Yeah.
So let me go to a couple places. So RSA 461A:2 has a statement of purpose, which has as part 1E for because children do best when both parents have a stable and meaningful involvement in their lives. It's the policy of the state unless it is clearly shown in a particular case it is detrimental to a child too, and then it lists those things that identify the purpose that the legislature has identified. Consider both the best interests of the child in light of the factors listed in 461A6 and the safety of the parties in developing a parenting plan. And then 461A6 has the definition of what best interest is. And then in the section that you just pointed to in the amendment would add a new paragraph into A6, which is a list of those factors which go into what is the best interest of the child.
Thank you very much.
It would not replace the ones at present, as far as I can see.
I believe this is a new paragraph that is lines 10 into the next page is all a new paragraph.
It is an insertion after 1A, so I would say it keeps the rest in place.
Yes, I would
So
agree with that.
we could then presume that the court, in making a determination of what is best practices, has a definition with which they work.
I apologize. I didn't understand that question.
I didn't either.
Okay.
When we read the phrase best practices, that's not just something floating. It's
Best
defined.
interest,
and
best interest or best practice?
Yeah, the courts know what that means because it's here in the law.
The courts would apply the definitions that have been identified through this A6 and then as amended by this new paragraph. That's correct.
Thank you. Any other questions? Representative Nelson.
Thank you, Mr. Chairman. I wanted to point out on page 2, line 20, where it says limited to, I believe that's a typo. It should be TO and not TOO.
These things are cleaned up along the way. It does not
Okay.
put this in any jeopardy.
Okay.
When this goes to enrolled bills, they clean up the grammar and any inadvertent false references to the existing law.
Appreciate your clarification. Thank you.
Chair will entertain a motion if there's no other questions. Representative Bickford. Ought to pass with amendment 0758. That is the amendment you were just handed out. That is the amendment the prime sponsor wishes. Yep. Do I have a second? Representative Seidel, it's the first hand I saw. Any further discussion? Representative Raymond.
Hi, thank you. I want to thank Representative Post for really listening to the questions and the discussion that we had at our last hearing regarding this bill, because I think that they went back and they really looked at the previous amendment and the questions that the committee asked and tried to address quite a bit of it. And I appreciate how they have kind of expanded on this to make it a lot more understandable for the layperson. Having said that, I categorically oppose this amendment for the following reasons. One, the legal terms are a mess. The standard in family court is not clear and convincing evidence. That's a criminal court statute. So every other case that is heard in the family division is a preponderance of the evidence. So to suddenly, for parenting time, raise that bar to clear and convincing is completely irrational. I don't understand the logic there. And they've used clear and convincing multiple times. The second issue I have, again, is language. The word fit parents, that's not defined. Joint parenting schedule is not, again, consistent with current state law. It should be parenting plan. On page 1, line 22, it says, if one of the parents is convicted of child abuse or neglect, again, that is a criminal term. It specifically refers to being convicted in a criminal case. Now, is it in the best interest of children that we only restrict people from parenting time if they've been convicted criminally? Or is it okay to say, listen, if you have a finding of abuse or neglect under family court, maybe you shouldn't have unrestricted parenting time? So really, I feel like there was some effort, but this really needs a review by an attorney who's familiar with family division and familiar with the rules of evidence before we move forward with it.
Representative Moulton.
Thank you, Mr. Chairman. I have an issue with line 20 on the amendment, where it says, so leading up to it, it's talking about the joint parenting schedule, but it's saying that if one of the parents does not request sole, primary, or joint responsibility for the child, reasons may include, but are not limited to, one parent lives or works out of town. So what kind of radius are we talking about here? And just because someone commutes to work doesn't mean that they can't have joint parenting. That's not a reason to not do 50-50 parenting, you know, unless out of work was like across the country, then that's one thing. But if it's like, we have a ton of people in Manchester alone and Nashua as well that commute into Boston. That has nothing to do with their ability to parent, you know, 50-50. So I have a major issue with that. Thank you.
Excuse me, where were you reading
Yes,
from?
hand, Representative Bickford.
Oh, what, this one or that one?
Either one.
Okay.
Or both.
I was in the amendment,
Yeah.
point number so it's 2IB3.
Line 20.
Yeah, line 20 and onward, like 20 to 22.
Yeah, okay.
Any further comments, Representative DeSimone?
Thank you, Mr. Chairman. The way I'm reading line 20 is, I think the first few words are very important. It says, if one of the parties does not request sole, primary, or joint responsibility, it's whether the parent is requesting or not. It's not that the court is determining, it's whether the parent is requesting. Parents don't request joint for many, many, many reasons. That's their prerogative, I think. That's how I'm reading it.
Representative Moulton?
Thank you, Mr. Chairman, and thank you, Representative DeSimone, for that interpretation. I appreciate that. My concern is for the divorces that are contentious, what if the other party says, well, they work out of town and therefore I should have more parenting time? So whereas the person who's working out of town might be like, no, we can do joint parenting time and it should be fine. But if the parties are contentious among each other and one is trying to weaponize it against the other, then the judge would have to go back to what is in the law. And if this is written in the law, then that's a concern.
Representative Gregg?
Thank you, Mr. Chairman. So I think, let me move closer. I think that, you know, we have a tightrope in the state anyway when we're talking about abuse cases, we're talking about divorce cases that are often contested and whatnot. I think that on this, something like this, another thing to think about that I don't think was necessarily thought about in, you know, the perfect world where you have an amicable divorce, you're not going to disagree about these kind of things. However, even in that case, you have hurt feelings, you have other things happening. If we go in saying, okay, we have joint parenting, that's the standard, we're going to start with joint parenting, you're actually asking one parent to say, oh, actually, I don't want joint parenting, or I don't want, like, I can't do this particular. And even though that seems really benign, and I understand, I respect why this was all brought up, because there are parents who want their kids that cannot get their kids. And I think that that's honorable. I think that this is not the way, because I think we're then asking good parents to even say why they don't want joint custody, and to say to your kid, well, we didn't do joint when they come down the line. Why am I not with you half the time? Well, I had to say because I have to work, or we're putting that burden of responsibility rather than letting a judge look at the situation and say, well, this makes sense. Right? Because we're saying going into this, all right, there's joint. Now tell us why there's not joint custody. So I think that's just a further complication I think we need to think about. Thanks.
Representative Ball.
Thank you, Chairman Pearson. When I'm reading this, what I'm seeing is that we're trying to find a starting point, and that starting point would be at 50-50. And then we move away from 50-50 as the parents find necessary or the court finds necessary. It's just saying that having one person say that person can't do 50-50 parenting can't be the only reason. There's got to be other things. You can't just have an accusation that we can't co-parent. But there's many reasons why parents would step away that children would understand. It could be military commitments. It could be first responders. It could be medical professions where they can't do 50-50 if they're on call on the weekends. It's what we're looking for here is just an even starting point. And from there, the court and the parents can decide what is in the best interest. And I think it allows parents to start on a level ground, and they need to put their animosity away, and they need to put their children's best interest first. Thank you.
Representative Long.
Thank you, Mr. Chairman. Yeah, we certainly know what parents need to do. That doesn't always happen. That's why we're here. What I haven't found in here, for example, I would be one to say, yeah, I'm not about to turn down joint parenting. That's going to be embarrassing for me and to my child. So I got to get up at 4 a.m. to go to work. I'm going to drop my child off at my brother's house, who, by the way, my ex-wife hates. I just think we're looking for more conflict here. You know, we're setting up something that's going to create more conflict. Just the sole base of getting a starter point for joint parenting. Again, it's not reviewed through the whole line. It certainly begins the process. However, I'm afraid of the snowball effect that is going to happen when, I'm taken to court because I don't have joint parenting because I'm dropping my child off at my brother's house or what have you.
Seeing nothing further, the motion before us, first of all, is on the amendment.
I just wanted to comment. I respectfully disagree with Representative Long on the idea that it's going to cause more agony. I think it's going to be the opposite, as Representative Ball said. This is something that's needed to make it clear that parents are equal parents, and that's where they're starting from. And if they can't do it, that's fine. Or if they don't think they should do it, that's fine. But if the other parent wants to show and demonstrate that other parent shouldn't do it, there should be a high bar to say otherwise, because this really goes hand in hand, I think dovetails with the parenting plan position we have. In 2005, when we passed the comparable parenting bill, which is almost identical to this bill we have before us, it passed 14-0 from this committee. The only thing that held it up was the administrative judge of the courts asked us not to go forward with it yet because they were spending so much time reforming almost the courts, the family court system, particularly with the parenting plan. But it was quite popular, so it stalled only because of that. When I looked at Iowa back in 2004, because this has been around a long time. I originally filed this back in 2008, and it was a favorite of mine. That's why I jumped in and said, yeah, I'll go for it. Anyway, in Iowa, if the court denies the request for joint physical care, the determination shall be accompanied by specific findings of fact and conclusions of the law that the awarding of joint physical care is not in the best interest of the child. it's something that's been gathering over time, and I think it really works very well for society. And instead of, we've been seeing so many bills that just do a little incremental things within the court, this is something that I think will help society a great deal.
Thank you.
Mr. Chairman.
Representative Raymond.
Thank you, Mr. Chairman. I just want to be clear. I do not oppose the idea of having a neutral starting point for court for parenting time. I think that we can all agree that courts should be neutral going in there, and they should look at both parents on the same footing right from the get-go, and then let the evidence come in. My objection to both this amendment and the original bill is the inconsistencies with the language and the terminology for used in this for legal terms that are contrary to current standards in family division. This bill consistently uses terminology that is appropriate for criminal courts, not family division. And so, to me, I think it's lazy because we've been over this multiple times in this committee. But also, I just don't think it's in the best interests of children or families in the state to start confusing different standards of evidence between criminal and civil courts. So, should the sponsors at some point come back with language that matches what the standard of evidence is in family division, most of my objections would be relieved.
Anything else, provided you're not repeating what has been said? We have a lot of bills to get through. We've been kicking this one around for about 25 minutes now. If this is something new, put your hand up. If not, please don't. Give it a shot.
Thank you, Mr. Chairman. I'm one of the sponsors to the original bill, and I liked the original bill to begin with. I don't support this amendment. First of all, I don't know that I was talked to about this amendment before it came out. This is my first time reading it now. But also, I have issues that I already mentioned, so I'm not going to talk about again.
Good.
But I would move, maybe when we're done the vote on the amendment, I would move to maybe retain this so that we could keep it, and fix more issues.
Mr. Chair, I'm confused.
If we have a motion before us, first of all, on the amendment, then on the bill as amended. If the bill as amended passes, it passes. If it ties or therefore is defeated, we can entertain another motion. Seeing, I hope, nothing further. The motion before us is on Amendment 0758H to Bill 185. It was moved by Representative Bickford. It was seconded by Representative Seidel. On the amendment, would the clerk please call the roll?
Chairman Pearson,
Yes.
Representative Long,
No.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
No.
Representative Levesque.
No.
Representative Petrina will be voting no. Representative Perez.
No.
Representative Gregg.
No.
Representative Moulton.
No.
Representative Raymond.
No.
8-8.
The motion for the amendment fails. We are now back to the original motion of ought to pass, moved by Representative Bickford and seconded by Representative Seidel. This is on the original bill. And the clerk may call the roll, please.
Chairman Pearson.
Yes.
Representative Long.
No.
Representative DeSimone.
Yes.
Representative Bickford.
Excuse me, I missed what you said. was
This is
happening.
on the original bill.
Well, I thought we were going to have a motion to retain.
Not yet.
But we still can do it?
It is still on the table, on the floor to vote the original bill.
So if it fails, we can still do a retain.
This is correct.
Okay. Yes.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
No.
Representative Levesque.
No.
Representative Petrino will be voting no. Representative Perez.
No.
Representative Gregg.
No.
Representative Moulton.
No.
Representative Raymond.
No.
828.
Now the chair will entertain another motion.
I'll move to
Well,
retain,
I'll
Mr.
make-
Chairman.
Chair calls on Representative Long.
I'll move to retain.
The motion is to retain. Is there a second to that? Representative Bickford. You do have the right to discuss. You don't have to exercise it. Representative Moulton.
Thank you, Mr. Chairman. I would love to retain this. I like most of the things in it, most of them. I just would like to tweak it a little bit, and then we can present a new amendment. I'm one of the sponsors on this original bill, so obviously I liked it for most of it. I would personally rather talk to Representative Post and some of the whoever was the original sponsors and get my own input into this. We can address the issues and maybe we can bring it back like relatively soon. So I would personally like to retain this.
Seeing no other hands up, the motion before us is to retain. Moved by Representative Long, seconded by Representative Bickford on House Bill 185-FN. The clerk please call the roll.
Chairman Pearson.
Yes to retain.
Representative Long.
Yes.
Representative DeSimone.
Begrudgingly, yes.
Representative Bickford.
Yes.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Petrino will be voting yes. Representative Perez.
Yes.
Representative Gregg.
Yes.
Representative Moulton.
Yes.
Representative Raymond.
Yes.
16-0 to retain.
House Bill 185 is retained. This ends the exec session on House Bill 185. And those of you who have taken extensive notes on this may want to review them and funnel them through Representative Moulton, who will be the extensive note having been taken repository.
To be fair, I will do the work and I will reach out to Representative Post and work with, I don't even know who this person is, but I will do the work to make the amendment the way we think it should be.
Thank you very much. Okay. I have something to read before we go on to the next one. This comes from Paul Smith, Clerk of the House, regarding committee reports. If you're writing a committee report, and we do not need one on the previous bill, it's been retained. But going forward, if we don't retain something and a committee report or two needs to be written, please pay attention. If the bill we voted on and you are writing a report on has an amendment, it is such and such a bill as amended, the report must state what the amendment does. Okay? Secondly, this is not a problem with some who write half a page of report. This is for those who write one sentence or two. And he gave an example. The committee does not think that we need this bill. Why? Because there is a gang out there, he used a harder term, uh, of people who love to pull things off consent. And all they need is half an excuse to do so. So we want to make sure that we write as best a report as possible. So should the bill get pulled off consent, there is good reasoning behind how we voted as a committee. So be a little bit more forthcoming, those who write sparsely. Also, in your reports, do not say the Republicans voted this way and the Democrats voted that way, because sometimes it's mixed on both sides, but we do not identify the party, even if it's unanimous. The reports simply explain why this group or that group is for this or against it. That's what we do. We read a narrative, and somebody from outside the process might not necessarily be able to guess which party did one and which party did the other. Also, he said, do not state something as a fact that is an opinion. For example, if this bill passes, it will bankrupt the city of Atkinson. That's what you think. It may not, and I would simply fight hard with my colleague here if that ever took place. Just simply say, we believe that this would harm gopher tortoises or something, not it will. You will have to consult other things for facts. It is a report. It is pretty much an opinion. Also, we are coming up on deadline. Everything's got to be out of here by a week from Thursday, which now means if you're going to write a minority or majority report, the chair needs to know that at the end of execing the bill, and your report needs to be in mucho pronto, very quickly. Nicht langsam, right? Yeah, okay. So please work on those reports over the lunch hour. Also, hearings this afternoon, later this morning, maybe when we do hearings, they're informational. We do not debate with the person who's sitting before us. We can give our opinions in an exec session. We ask for clarifications of fact and so on. So I have now fulfilled my obligation to the clerk of the House. We're going to move on to 583 simply because that's the one I can find. Thought I could. Here it is. And this is, there is an amendment forthcoming. I opened the exec session on House Bill 583, which is relative to termination of child support. And there is an amendment from the prime sponsor, and I'll pass some down this way and that way. And this is Amendment 714. And the sponsor believes that this cleans up questions that we had during the original hearing. And if you have another amendment to this from Representative Spillane, toss it out, because he wants Amendment 714 to be the one he is going to present to us. Representative Long.
So Representative Swain doesn't present an amendment to the committee.
One of
It's a
us
committee
does.
member that,
Yeah, committee member does. I'll do it. Any one of us can do it. Can you do what? I really You may remember from the original hearing, there was a question about somebody turning a certain age and hadn't finished school yet, and so he trotted around and talked to some various people, and the amendment 714 is what you see before you.
Can we now look at the other amendments?
If they're by him, I'm not going to present any of them if they're by him. This is his amendment. This
But
is,
are there any others that have been presented to the committee? So we
I
can do,
don't know of any amendments that have been presented to this committee on this
I
bill.
thought Representative Ball had one coming.
If she does, maybe that's what she's going to get. I wasn't quite able to hear what she was trying
Oh,
to
okay.
tell
I
me.
just want to do a comparison of the amendments.
You can do
That are
that.
being presented to the committee.
Okay, thank you.
Mr. Chair, that's exactly what she went to do, is pick
Thank
up
you.
another amendment to this bill.
Whispering really doesn't work with my ears anymore.
Right.
If it's secret, I need to go out of the room to talk to somebody in my voice, because I just can't hear that right now.
I have a husband and a daughter who are hearing impaired. I get it.
There she is.
Coming both ways is Representative Ball's amendment on 583. And thank you, Representative Bickford, for reminding me there was another amendment coming. I'm afraid I dropped the ball on that.
My pleasure to remind you.
Dropped the ball on that.
Oh! Oh, yeah. I'm terrible at that stuff.
So we have side by side, and just a reminder to anyone leaving the room, you may, but once I call the question,
I know. Hopefully this will be.
well, I'll, yeah. So you get to look at the bill, Representative Spillane's amendment, and Representative Ball's amendment. Are there any other amendments? Okay, Chair calls on himself. I like on the Ball amendment lines 15 and 16 because in my understanding, age 21 is valid for most of the folks, but if there's a approved State Board of Education program, that goes to age 22. I think I remember that, Representative, from my work with the DD community, that's 22. So I think Representative Ball, certainly on lines 15 and 16, is a more accurate rendering of what we wish to do. Any other comments?
We should
on-
have Representative Ball speak to her amendment.
Representative Ball may indeed speak to her amendment.
Thank you, Chairman Pearson. When I did this amendment, I did some research on the Social Security for children that were receiving benefits, survivor benefits, and this wording is taken right from there, so it aligns with the same way the government decides when to terminate child support. And on the bottom, again, I looked at both the Board of Education with our extension of allowing children to now stay in their special education programs till age 22. And I also looked at, again, Social Security requirements, and that's where the wording came from. Thank you.
Representative Raymond's hand.
Thank you. Is this the sweet spot where I should put it from now on?
We'll see. One can hope.
Okay.
I am
just
educable, but to a point.
I just wanted to thank Representative Ball for the work that she did on this. I know Representative Gregg also had looked that up and sent it to Representative Spillane. And when I was reviewing this one over the weekend, I was like, oh, we're still missing that language about kids who are in programs until 22. So you have resolved my biggest issue, and I appreciate that. I know it's a lot of work to get this done and in so quickly.
Representative Perez.
Yes, I do have a question. These programs that it would include, for example, back in the days when I moved here, they make me go back and then go back into high school. And so when I graduated, I was like already past the 18 because, that English was the second language. This amendment would include those students that they come in with the programs with like English as a second language. Sometimes we have to go back and then take extra classes, or we have to go back a couple grades because the education from another country, it doesn't comply with the education here.
Thank you for the question. I'm sorry.
No, go ahead.
Sorry. Thank you for the question. I believe that it
Closer
does.
to the mic.
Sorry.
Thank you.
I believe that it does cover it because it would be under the special education that you're continuing your education in an special education program. And it does go to give that extra year of children who may have been retained a year or need an additional year in high school, so they don't graduate until they're 19. So it does go till 19 and 2 months if you're not in special education. There's also the provision that says that the judge can also say it's going to go beyond age 18 as well. And I would also like to mention that in 2021, there was a court case, and the determination was that home care services continue for children that are enrolled, special education children, disabled children, who are enrolled in home services and extra services. They don't lose that because they're a student where they did previously.
Would someone wish to make a motion on House Bill 583 and with the Amendment 0793, the chair recognizes Representative Ball, if you'd like to make that motion.
Thank you, Chairman Pearson. Yes, I would like to make a motion that we OTP the amendment. Is that the right
The
way?
bill
I'm
and
sorry,
the
the
amendment.
bill.
To move your amendment.
Yes, to move my amendment. I'm sorry. First time I'm doing this, so. To move the amendment number 0793H.
I'll second. For Mark.
Who was that? That was you. Now, any further discussion? Thank you. Seeing none, the motion before us is to move Amendment 0793H on House Bill 583 FN, moved by Representative Ball and seconded by Representative DeSimone. Would the clerk please call the roll? The motion is ought to pass. On the motion.
On the amendment.
On the amendment. Well, they moved the amendment, yeah. I just wondered if I said OTP or not. Everything I said before, OTP. Got it? We are moving the amendment right now.
Chairman Pearson,
Yes.
Representative Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino will be voting yes. Representative Perez,
Yeah.
Representative Gregg,
Yes.
Representative Moulton. Oh, okay. Representative Raymond.
Yes.
The amendment passes 15-0 with one absent.
Representative Bickford, would you look out in the hall and let her know that we're about to move something else? Please. The motion before us, moved by Representative Ball and seconded by Representative DeSimone, is now House Bill 583 FN as amended by Amendment 0793H. Would the clerk please call the roll?
Ought to pass as amendment. Chairman Pearson,
Yes.
Representative Long,
Yes.
Representative DeSimone, Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino will be voting yes. Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Moulton, oh, excuse me, absent at the moment. Representative Raymond.
Yes.
Ought to pass as amended, passes 15-0.
And Representative, all of you, all representatives, do you have any objection to going on to consent? Shouldn't.
I have a
Seeing-
question. How do we handle the Spillane amendment now, which is active in the,
It was not received and entered in.
oh,
Unless somebody chooses to present it from the committee.
okay, that's
It
right.
is a dead amendment.
That's right.
Representative Grossman.
I'd be happy to put it on consent, but it has a fiscal note attached.
I
So
do not believe it is a second committee bill, and let's take a look at the fiscal note from the original bill. It says, at least my copy says, due to time constraints, they didn't give one. So therefore, we can send it over, and if the clerk says we're wrong, he can bump it along its happy way, not for us to determine, so let's put it on consensus.
Okay,
Can-
before we move on, I may have missed this.
Representative Ball, would you write a very wonderful committee report for us, please?
Yes.
Thank you. All right. And this concludes the exec session on House Bill 583. And let's see, what do we have next here? All right, the next thing that was given to me is 548, open the executive session on House Bill 548. And this is an amendment that the sponsor, Representative Spillane, asks me to present, and it is Amendment 617. The amendment is 617 on House Bill 548. And this was basically, you'll remember, a patch job. The lines 5 and 6 on the original bill had a strikeout through the words "and has obtained or maintained health insurance coverage as required by a legal order of support." That was not requested by the prime sponsor. It was stricken erroneously, and my amendment 617 simply restores the words that never should have been taken out. So what you get in the Amendment 617H is the bill as the prime sponsor wished it to appear. And you may remember from the hearing, that was about the only discussion we really had. They've been going around. In fact, they are near you. You may remember the reason for the bill was if somebody has, let's say, a $50,000 salary and it's divided among a number of pay periods, sometimes the check might be, let's say, $499.98. And that technically puts you in default of, if you're supposed to be giving $500, you're in default by 2 cents. And the computers do not understand that, apparently, and as a result, some people have been penalized for being in arrears when it's 2 cents. So what the sponsor's bill would seek to do is simply bump it up to $25, where this kind of error, which apparently has happened to some people, shouldn't happen. That's what this bill is very simply all about. Seeing no hands up, the chair then wishes to move, ought to pass as amended on on the amendment 0617H on House Bill 548. And is there a second? Were you waving for seconded? No, I moved it. And it so moved you that you seconded it. Okay, thank you. Any further discussion? What's that?
I do have a question.
Representative Long.
Thank you, Mr. Chairman. $25 is the minimum child support payment? Is that what that is?
No, I don't think so.
It's not. Is there a
might be.
minimum? Is there a minimum? Do we know? Would Mr. Head know?
Attorney Head, do you know if there's a minimum child support payment in law?
All right, that's fine.
50. So 25 would be considerably under that.
Yeah.
And it's primarily for those rounding errors of dividing something by an odd number.
Yeah, I brought up that, excuse me. Thank you, Mr. Chairman. I brought that up at the hearing, whether this should be $50 or not, because of that reason. But you say if it's based on artificial intelligence that we're trying to correct, then I guess it doesn't matter too much. But we can always get another amendment. Won't take long for him to do that.
Well, I don't think he's interested in the minimum payment of child support.
no.
He is interested in being not burned anymore when something's off by 2 or 3 cents, and he picked
Well, I'm thinking of
25.
Representative Long question.
Representative Long.
So, yeah, this is in regard to the passport issue.
I think so, yeah.
And my understanding is that it's a $2,500 arrearage that the feds implement that on your passport. So, but we were told that it was like $4 and something cents. So I don't understand. I get the need from what I heard the sponsor telling us, but it's not the case.
Unfortunately, he is chairing Fish and Game at the moment and cannot be with us. Representative DeSimone.
Thank you, Mr. Chairman. The issue was the $4.89 or something like that. What happened was the feds contact the state when they need to know whether a person is in arrearage. And when the feds in that case did, they DHHS did not disclose the amount. They just said he was in arrears. Period, end. And they did not disclose the amount that he was in arrears. That's what happens all too frequently. I agree with you about the $2,500, but that's not what happened in this case, and it's happened in other cases.
He seems to be addressing one problem, not another, in this particular bill.
Correct.
And therefore not to be penalized for not doing something that another bill could have done.
So,
Okay, anything further, Representative Long?
yeah, so this bill does nothing to the issue that he had with the feds, because the feds aren't listening to our $25, or, you know, it could still happen if nobody's given them the amount.
Representative DeSimone for an answer?
Thank you. But in this case, the DHHS would not be able to report that he was in arrearages if it is less than the $25. They would not be able to tell the feds, yes, he's in arrears. They would have to say he's up to date.
Representative Gregg, this is where her daughter pays attention.
Or not. I would like to get actually can we get clarification? I know the people that work with child support services are here. Can we get clarification on at what point they would say, because I believe it's higher than $4, and I did read the federal statutes on that passport. It does not kick in until $2,500. Can we get clarification from them, please?
Is there anyone from Child Support Services that can answer specifically this point? I think we're making this more difficult than it is, but sure, that's why they're here.
Good morning.
Morning.
Thank you, Mr. Chairman. And thank you, Representative Gregg. My name is Lisa Dekatowski, Bureau of Child Support Services, Department of Health and Human Services, Bureau Chief.
Attorney Matthew Hayes, Staff Attorney for Bureau of Child Support.
If I understand the question correctly, the question is what is the exact amount of arrearages that the federal offset program for passport denial criteria is. The Bureau, the federal regulation is that when an arrearage balance is $2,500 or more, does the arrearage balance gets reported to the federal offset program if all criteria are met.
So on that basis, it would seem that this bill may be addressing another issue and not a passport issue,
Perhaps,
perhaps.
perhaps. Yes, Mr. Chairman.
Okay,
Perhaps.
thank you. Representative Gregg.
So if I just want to make sure I understand. So if they're $2,500, that's when the federal program kicks in to say the passport can't happen. However, is there, and that's the state reporting to the federal government, correct?
That is correct. That is the requirement.
So is there a point where the federal government like calls and says like, is there an arrearage? And you would say it's just a yes or no. It's not like, oh, it's $4 or it's $50.
Thank you, Representative Gregg, for that question. In the event that an obligor may have applied to have their passport perhaps renewed or requested for a new passport to be issued to them, if there is a indication on the federal passport side that there may have been an arrearage reported, they may reach out to the department to clarify whether the case is, or whether that arrearage is still active and still eligible for the continuation of the program.
Yeah, Representative Long.
Thank you, Mr. Chairman. So is there a time when you would tell anybody, even within the state, somebody going for their license, a yes or no without an amount? For example, if this bill were to pass, if it was $24, you would have to say, no, they're not in arrearage, correct?
So thank you,
I don't
Representative
know if
Long,
you have more to
for the
say.
question. I appreciate that. Let me just look at the amendment again.
Well, it's my understanding that this whether or not, I don't know, I've never personally answered that question. I'm not a caseworker, but I know that this statute, it seems like the theme of this executive session is that this statute, we wouldn't answer that federal, it wouldn't answer the federal agency's question by referencing this statute. Most likely just give them the arrearage, and they would make their own determination based on their own regulations. I don't think that we would say if somebody was in compliance or not in compliance in terms of this statute.
Are you stating that your regulations trump state law? Should this pass into law?
I guess I just don't have enough information on exactly what the sponsor was looking to get from us.
I'm really not going to the bill as much as I am your recent statement. You had said that if somebody asked you, you would make that determination on your regulations and not on state law, and I'm challenging that statement.
I guess I'm not really sure what's being asked. I'm not sure what the specific issues that we're addressing. I'm just saying that I don't know, I can't speak to whether or not we're giving a yes or no answer to some federal entity that's reached
Okay.
out to us on an individual case.
That's fine. I mean, you don't have to have the answer to our question. And if you don't, that's fine.
Unless Lisa Dekatowski has something to offer about that point.
Mr. Chairman, what I would offer is that the Social Security Act does require that states that are administering the child support Title 4D program have within their state plan a regulated provision in reference to the collection of past due support from federal tax refunds. So the Title 4D program does require that states participate in that program through the administration of said program.
Thank
So,
you.
Thank you.
All right. Does anybody remember why he brought us this bill? I mean, the passport $2,500 thing seems to be a red herring, and I have terrible notes on this bill. Representative Panic, do you remember what he's trying to say? Mic on?
Representative Spillane was going to take a trip. He needed to submit for his passport.
Yeah,
He was in the rears by 1 penny,
right.
and because of he was in the rears for 1 penny, his passport was denied.
Because he was, yes or no, in arrears.
In
and
the
he
rears
was.
by 1 cent. That's what he told
That's
us.
what I thought I remembered. So I don't
Yeah.
know where this $2,500 thing comes in then. Representative DeSimone?
The $2,500 comes in to where the federal government will then attach your income tax return. As far as I understand, and the $2,500 will at that point not only attach your tax return, but it will deny a passport. In this particular case, he did not reach the $2,500 mark, so they did not attach his tax return. However, they did refuse his passport,
Okay.
which he had applied for because he had to go to another country because of his employer.
Okay.
That was a demand on the employer's part.
Representative Perez?
Yeah, I do have a question because I believe I wasn't here for the hearing. And so this bill was introduced because a state representative had an issue with his passport, or that's something that it happened often in the, like with our constituents. That's something that I wasn't here, so I don't know. This is a personal issue, and he introduced the bill. This is something that really happens all the time, and that's why we introducing this bill. To be honest, I just want to be, when I'm voting for something or when I'm thinking about a bill, I just want to make sure that we doing because this is going to help our constituents. No, because it was affecting one state representative in a personal matter. That's all I want to know because I wasn't here. So
Thank you. Representative Grossman?
I came in at the end of this day's testimony. Were there any other folks that came forward with issues related to this?
The clerk will be checking on that. And if anyone else has another comment or question while he's doing that, you can do it now. Representative DeSimone?
Thank you, Mr. Chair. I just honestly find it very difficult to believe that this is a one-person issue. If it's happening to one person, we don't know how many other people that it's happening to, because not everybody realizes that they can come to the legislature to get it fixed. So I personally find it difficult to believe that it's a one-person issue.
I do remember at work, I periodically oversee my billing department, and there was somebody whose wage wound up being, let's just pick an arbitrary number, $699.99. And she trotted her check over to me and said, I thought I got $700. And we had a good laugh on that and looked at, it'll probably come out at $700.04 in a few months. And we laughed at that because she thought it would be funny, and it was. And so it does happen. But if there's penalties saying you're under, $699.99 technically, I suppose, means we underpaid her that month. And don't tell anybody I just said that, because we don't do it now. We made sure we don't do it now, just in case. But so, yeah, I would kind of think this would be the case. Representative Carino?
Only Representative Spillane spoke in support of his bill. There was one other individual who did speak, but testimony was irrelevant and one other folks in front of us spoke in opposition.
Okay. I think my opinion is this may not address other issues, but it seems to address this issue for one person, and my assumption it would be a few others too, and it isn't going to hurt anybody if we pass it.
Mr. Chairman, may the Bureau be excused?
I'm sorry?
May the Bureau be excused?
You may be excused. Thank you
Thank you.
so much. Would you like me to write a note that you are of great importance to this exec session for the people who pay you 0.99 cents a month or something? Thank you. Well, I would like to call the question here, seeing no objection. The question at hand is ought to pass as amended by Amendment 0617H, moved by the chairman and seconded by Representative Panic. And we are now voting on the amendment 0617. Would the chair please call the roll? Would the clerk please call the roll?
Chairman Pearson,
Yes.
Vice Chairman Long,
No.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball, yes. Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
No.
Representative Levesque,
No.
Representative Petrino,
No.
Representative Perez,
No.
Representative Gregg,
No.
Representative Moulton,
No.
Representative Raymond.
No.
That would be 8-8 on the vote, 8 yeas.
The amendment
8 nays.
fails, and now we will be considering the bill unamended, House Bill 548 FN, moved by Representative Pearson and seconded by Representative Panic. The clerk may call the roll.
Chairman Pearson.
Yes.
Vice Chairman Long,
No.
Representative DeSimone,
Yes.
Representative Bickford, Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball, yes. Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
No.
Representative Levesque,
No.
Representative Petrino,
No.
Representative Perez,
No.
Representative Gregg,
No.
Representative Moulton,
No.
Representative Raymond.
No.
The motion fails 7-9. We need to have a positive motion, and that will be ITL. If somebody would choose to move ITL on the bill, we have to have a motion going forward that has a larger number first.
I'll make the motion.
Representative Raymond moves ITL. Is there a second? Second, Representative Perez. The motion before us is inexpedient to legislate on House Bill 548 FN. Would the clerk please call the roll?
Chairman Pearson,
No.
Vice Chairman Long,
Yes.
Representative DeSimone,
No.
Representative Bickford,
Yes.
sorry, my pen just ran out. Okay. Representative Nelson,
No.
Representative McMahon,
No.
Representative Ball, no. Representative Panic,
No.
Representative Seidel,
No.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino,
Yes.
Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Moulton,
Yes.
Representative Raymond.
Yes.
The motion ITL passes 9-7. The chair would ask Representative Raymond if she wishes to write the committee report.
Yes, that's fine. If you could pass me the sheet, I will take care of it at lunchtime.
And I will write the minority reports. So it is 7 to 9, 9 to OTP, 7, 9.
You don't put this here, right? You don't put that there, I just do this, and I put the bill number.
I know we are. I know we are. This ends the executive session on House Bill 548.
We should have. We ought to pass. Okay.
Dump them there. We won't need them for a while.
So who did the,
Yep.
the original going back?
Since we are about 45 minutes late, I am going to defer the rest of the executive session to, I hope, later today. And with that, do you have a regular calendar handy?
Ought to pass, I don't know if we did this.
Thank
Yeah,
you.
These two, is it staying the same? Oh my gosh, I just ordered pens. Thanks.
I now open the hearing. We've moved off of the executive session, people. We are now on the hearing on House Bill 475, establishing a right to submit evidence and testimony in family court proceedings. The chair recognizes Representative Post to present your bill. And I'm going to make an executive decision in our recess House Bill 475 until the prime sponsor can present her bill. We are already also running late on the next bill, which is 417. And the chair now opens the hearing on House Bill 417, and the chair calls Representative Testerman to present his bill. 417. We also have a pink card from Emma Savini that does not list a House Bill number on it, and if she is present, she may come and fill it out. Come on up. Not to worry.
Mr. Chairman,
Yes.
seeing as we have a lot of speakers, can we present the bill just so that we can start hearing the speakers?
Would somebody wish to, a committee member who's likely to be, you want to do it? Okay.
I mean, I'm willing to do it too. I mean,
Sure.
Mr. Chairman, forgive me for not knowing how to do this, but I
You are
just,
doing a better job than the prime sponsor so far.
do I just read the bill?
Just the title.
All right. Just give me a second.
You want the bill?
No, I've got it. I
Okay.
can.
Just-
Oh, wait. I typed in 417. I have to type in HB 417. Okay, so. House Bill 417 says an act relative to the definition of child abuse.
That's it.
Okay.
Well done.
Thank you for teaching me how to do it. Thank you.
Let me say at the outset as chairman that there is a much bigger bill on an aspect of this subject being presented in Representatives Hall at this moment. And there will be all day on two bills on this very subject. I've discussed this with a number, not all, but a number of members of this committee, and my inclination is when it comes to an executive session, I will push for retention because many of us were of the conclusion this is an evolving subject. Let my former committee in Reps Hall have all the fun with this, and we can look at it later. That's just me speaking, but that's letting people at the outset know where I would hope we will go down the road.
I'll second that.
I've got a whole bunch of pink cards, and here's the rules of the road. You get to speak for 2 minutes. 2. Write it out ahead of time, because at 1:45, I'm going to go like this, and that means you have 15 seconds, at which point. The reason we do that is not to be mean, but to be fair. There are people who I know in these hearings with a lot of strong opinion and pink cards measured in inches that people have taken a day off to come. And if it comes to 5 o'clock and we're still on a subject and more than half of the committee has left, that's because somebody spoke for 15 minutes before you and before them and before them and before them. And that means you who took a day off, you'll speak to an almost empty room, and I don't want to do that. That is not fair to you. So as a result, irrespective of what one's views are on any particular subject, we have adopted in the House this kind of a protocol. So you get 2 minutes. If you have written copies, when your name is called, please bring the written copies to Representative Bickford, and then he will pass them around. And then go to your seat. There's a little button you push, and when your microphone end turns red, that means your mic is on. So 2 minutes, irrespective of what you wrote on the card, it is a 2-minute speech.
Mr. Chairman,
Yes.
if you don't mind, can I just very quickly say something?
Yeah.
I would like to say thank you to everyone who's here testifying, and I'm hoping that everyone remember that we're talking about humans, and then we talking about a person, and then we all keep it respectfully. And I believe humans deserve dignity and respect, and hopefully we keep it that way. Thank you.
And this is true for those you disagree with.
Yep,
as well.
correct.
Thank you for that, Representative. I very much appreciate that. Chair, the chair calls Frank Knack, and you have written testimony. Please drop it off with Representative Bickford, and the clock starts once your mic is turned on. And you may begin.
Thank you, Mr. Chairman, members of the committee, for the opportunity to testify today. My name is Frank Knack. I'm the policy director with the ACLU of New Hampshire. We are here in opposition to HB 417. As you know, all know, there's a lot of people here behind me, so I hope that you all just take some time to read the fact sheet that I handed out. It really points to the fact that not from the ACLU's perspective, but from the perspective of major public health and medical associations, this is a dangerous bill. If you look in the footnotes of the fact sheet I handed out, you'll see from the American Academy of Pediatrics, American Psychological Association, the American Association of School Psychologists, the American Association of Medical Colleges, and the American Medical Association all have deep concerns with any policy like this because it'll harm our youth, our trans youth in New Hampshire. So I urge you to heed their warnings and oppose this bill. Thank you very much.
Thank you, sir. Appreciate. You made your point and to the point, and you were quite brief. Thank you so much. The chair now recognizes Stephen, is it LaFond or LaFord? LaFond, yeah. And you have written a testimony too.
Thanks, everybody. My name's Stephen LaFond. I live in Concord. I was born and raised 15 minutes from here. My grandfather owned the Park Street Barber Shop for about 40 years, just right here by the State House. I'm a father. I'm politically independent. I'm a homeowner. And I oppose this bill. So many of the new and incumbent members of this governing body ran on a platform of parental rights. One of them, who is my aunt, let you know that everyone should be able to make their own choices regarding medical decisions for themselves and their children. This tiny little bill with a fiscal impact ledger larger than the change the law itself is not doing that. The way it's sold to the hardworking people of our state is that you're protecting pre-adolescents from a radical agenda and irreversible surgeries. It goes after medication, interventional therapy, and is vague enough that every parent that is looking to do what they can to even just to understand what their kid is going through, the mental health care can be put at risk as well. We're told it's a major epidemic. Here's some stats that I'm in clinical research that I can give you based on Reuters and Komodo Medical. Over a five-year period, there's only been about 121,882 kids that are diagnosed with gender dysphoria. That's nationwide. In that time, less than 5,000 were reported to have begun any puberty blockers. Less than 4,300 started hormone therapy in the last year. There's only 282 instances of adolescent surgery, and the scary one that everybody's worried about, the one below the belt, only 56 of any genital surgeries for adolescents, 0 for any under. I want to compare that to something that might be a little embarrassing for some of the gentlemen here. In this state alone, 80% of people born biologically male, we all had circumcision. We were babies. We didn't make this cultural and religious choice. It didn't make us more men. It's a ridiculous idea. But my parents did it because they're good folks. It was with our cultural ideas that were in mind, and it was protected. But they also raised me to stand up to the idea of pushy folks that think live free or die was expressing a preference for our neighbors who don't agree with us do the latter. So I'm just advising you as a taxpayer and property owner, just keep investigating this bill. Run from it. It's not too late to stand for the liberty that we're trying to instill in our kids. Thank you.
Would you take a question or two?
Happily.
All right. I recall from testimony on some previous bills from folks who often vote opposite to me.
Sure.
The quotes, I don't always trust children to make the right decision for themselves, and quote, I don't always trust parents to make the right decision for their children, and quote, we need a village. How do you square those? And that's an honest question.
I like that. I like that question. And here's why. I'm not a Democrat. For my folks that were basically squaring the idea of what they wanted to do for vaccination, for mask mandates, for keeping our people free. If my kid's gonna mask, they're gonna mask. I'm not gonna make your kid do it. It's ridiculous. That said, If I have multiple doctors, a therapist, and everyone else looking into what's going on with my child, and they're like, this isn't a phase, I'm a skeptic. I'll keep going. As a parent, you don't jump into things carefully and you don't lazily just hope it's going to work out. I don't think anyone doing this is like high-fiving and running their way to the surgery table. Did that answer your question, sir?
Very well. Thank you, sir. I appreciate your answer. Any
Thank you.
other questions, Representative Bickford?
Thank you, Mr. Chairman. Thank you. You stated a few statistics here. If
Mhm.
you could go back and repeat those for me so I could jot that down.
They're in your handout.
Absolutely. I've also had
He
them in
only
the
had,
handout.
he only had like 5 handouts. I gave.
I only had 6 to be fair, but I'm happy to give you mine.
Please. Oh, okay.
I'm literally gonna
Well,
give
for
it to
the-
you
For
when I'm
all of
done.
us, I thought they were appropriate.
Oh yeah,
It
absolutely.
was 56 something.
Yeah, sure. I'll give it to you. So this is actually coming from the Reuters report that was done with Komodo Medical.
A little slow.
Sure.
Coming from what?
Reuters
Reuters.
and Komodo Medical. They're an investigative medical firm, sir.
Oh, thank you.
Oh, okay.
We are running very short of staff today
Yeah.
because of the large group in Reps Hall.
Okay.
And what we will be doing, I hope, at the end of the hearing over the lunch hour, is somebody will be running the reports where there weren't 20 copies to a photocopier to get enough for everybody else. So
My
that-
contact information's on the
then we'll
pink
all
sheet.
have it.
I'm happy to send it for you.
Okay, thank you.
Thank you. And thank you for your testimony.
Thank you.
Chair recognizes Holly Stevens from NAMI, a frequent visitor to our committee.
Chairman Pierce and members of the committee, my name is Holly Stevens. I'm the Director of Public Policy for NAMI, New Hampshire. I'll try to keep this brief because I know there's a lot of people behind me who aren't wearing an orange badge who want to speak today. We know that right now we have a mental health crisis with our youth. We know that our suicide rates are rising. The YRBS survey in 2018 showed that, hang on one second. 18.8% of New Hampshire high school students seriously considered suicide and 8.9 attempted that. We know that there's a small subset of that group of individuals who have even higher rates of suicide, and that is the LGBTQ plus community. A bill like this only goes to disaffirm their own identity and in a sense attacks it. And I do find it a little bit ironic, as you just heard, and this will be my last point, I think, of the day, that there are 2 bills being heard today on parental rights, and this bill would devoid parents of their rights. And as far as taking a village, I mean, I think you heard that the village is the doctors, the therapists, the parents, the family support around those kids. It doesn't need government interference, so NAMI New Hampshire is in opposition to this bill. Thank you.
Representative Nelson with a question.
Thank you, Mr. Chairman, and thank you for taking my questions. It's a quick one. What was that survey you referenced?
The Youth Behavioral Risk Survey. It's a survey that's done every 2 years in the schools.
The Youth Behavioral
Risk
Survey. Thank you.
You're welcome.
And thank you so much.
Thank you.
Chair recognizes Richard Owen Emberley. And your testimony is 1 copy?
Yes,
Would you object once you hand it to the clerk after you're done that we photocopy it?
that's fine.
As a disclosure, I do not own stock in a paper company, but I should.
Good morning. Thank you for having me. My name is Dr. Richard Owen Emberley. I live here in Concord. I'm going to shorten my comments for the sake of time. I would like to say that every major medical organization, both in America and around the world, all supports gender affirming care. And to answer your question, Chairman, it's not just the child's decision. It's not just the parent's decision. There are multiple medical providers who are also making these decisions, and we're all trained on this. This isn't made up. This isn't something new. This is something that's support and backed by a lot of research. And I'd like to just read my last statement here. HB 417 seeks to add sexual reassignment to the definition of an abused child. As a healthcare worker who has reviewed the literature on gender affirming care, it is very clear to me that gender affirming care is not child abuse. In fact, when considering the increased risks of depression and suicide that come with denying gender affirming care, it would appear that denying appropriate gender affirming care is child abuse. Thank you.
And thank you, Doctor. And if you could bring up your testimony to the clerk. That's either one. Thank you. Chair recognizes Amelia Brock.
Got a little confused. Excuse me, I'm quite nervous. Hello, my name is Amelia Brock. I'm sorry. And I am a mother to 2 teenagers, one who is transgender. I am speaking today in opposition to HB 417 to protect my child, my family, and others like ours whose parental rights will be taken away if this bill becomes law. It is every parent's responsibility to ensure that they do all they can to keep their child healthy. In fact, to ignore a health concern of your child is considered neglect, a form of child abuse. If my child had cancer or diabetes or bipolar disease, the state of New Hampshire would require and expect that I make every effort to see that my child received appropriate medical care. A transgender child who has been clinically diagnosed by medical professionals with gender dysphoria is no different than a kid with cancer or bipolar. It is a medical condition. As a responsible parent, under New Hampshire law, I am obliged to provide access to medical care for my child. If this law were to pass, the state of New Hampshire would require that my husband and myself deny our child the necessary medical care that has been recommended to us by board-certified, New Hampshire licensed medical doctors and psychologists, therefore causing us to neglect our child. This law proposes that a small number of politicians know more about taking care of my child than me, my husband, my child's primary care doctor, psychologist, and endocrinologist. As far as I know, none of you are licensed psychologists or endocrinologists and have never met my child. The government does not know what is best for my child, my husband and I do. Would you criminalize a parent of a child with cancer because they chose a medical treatment that a politician did not like? The arrogance of this bill is astounding. Some politicians are putting a sick twist on this hateful bill to say they are proposing these laws to protect innocent children. We all know this is a pack of lies. The true intent of this bill, bills like HB 417, is to shame and scare transgender children and push them back into the closet. Are you aware that transgender children, teenagers in particular, have the highest risk of suicide of all children? 82% of transgender teens have been suicidal. Over 40% have attempted suicide.
You've got 15 seconds now
Okay,
to wrap
the
up.
statistic from this National Library of Medicine. Proposed laws like HB 417 that are meant to shame and scare transgender children and their families will only cause more distress to an already very vulnerable population of children. This law supposedly protects innocent children's lives, may in fact be the thing that causes children to take their own lives.
And now would you wish to hand that testimony? Would you like us to have copies of it? Okay, if you could hand it to the end, please. Thank you so much. The chair now recognizes Dr. Jennifer Smith from Pembroke.
Thank you, Mr. Chairman and members of the committee. I do not have written testimony. I want to strongly urge you to ITL this bill. The last time this, I think, identical text was heard in this committee, it went to the floor 20-0. It was supposed to be on consent calendar, though it was pulled off. And this is ridiculous. How long will we have to continue to make the case that this is care that is done carefully? It involves parents if there's going to be any, unless there's a appointed guardian for someone who has had to flee their parents. And it does not make any sense that one would call this child abuse. Not only am I transgender, I have extended family members in the generation that this would affect who are also transgender. Thank God their parents are very supportive of them, as are the rest of the community their parents have gathered. And yes, everything takes a community. People who live in communities that are abusive need to be held to account. Our community among people who are transgender and the supporting allies is not abusive. We are careful, we listen to others, and we help people make the decisions that are very hard to make.
And 15 seconds, Doctor.
I'm done, and I'll be happy to take any questions.
Thank you so much. I remember you testifying before Health and Human Services numbers of times. Do you wish to take a question from Representative Moulton?
Absolutely.
Thank you, Mr. Chairman. I'm just wondering what you're a doctor of.
Oh, I'm a family medical practitioner, and I have a public health degree, which I put on my pink card, but the chairman failed to mention that. I do a lot of research, and I've done a lot of research on transgender stuff because I am transgender and have relatives who are and friends who are. So
Thank you very much.
And thank you so much, Doctor. The chair recognizes Ryan Aquilina. If you'd like us to have copies of it, we're buying a paper mill. Welcome. 2 minutes. Thank you.
Oh, there we go. Thank you so
Starting
much
now.
for your time and for hearing our testimony today. I'm a licensed clinical mental health counselor in the state of New Hampshire. I was born and raised here in the Lakes region, and I currently live in Manchester with my spouse. And I run a group practice of 25 clinicians. I write to you today appalled by the very idea of HB 417. And anybody who works to protect children in this state should be as well, in my opinion. I find fault with several points in this bill, and I'll outline them quickly for you here. So the process that any person has to go through, including minors, to obtain any kind of gender-confirming care is extensive. It starts with somebody's primary care provider, but then they have to get hooked up with mental health clinicians and then an endocrinologist, and there have to be letters written. This is an intentional process, and it's evidence-based. And somebody doesn't just wake up one day and decide that they're trans and then poof, they get all of the medical care that they need that's necessary. That's not how this works. But even going through the evidence-based process, there are still many providers who will not provide gender-confirming care. A child who approaches their caregiver requesting these services sets in motion a chain of events involving all of the things that I just talked about. And it has to start with consent of the caregivers. The caregiver has to be given the autonomy to be able to consent to their child being given these services. To assume that children would be subjected to this is false, and it's also discriminatory. Also, statistically, providing gender-affirming care, as some of my colleagues have stated up here already, can literally save the lives of those who receive it. Suicide is the second leading cause of death in people ages 13 to 24 in the state of New Hampshire. LGBTQIA plus youth are 4 times more likely to attempt suicide than their peers. There's a suicide attempt of an LGBTQIA plus youth approximately every 45 seconds. 45% of LGBTQIA youth have seriously considered attempting suicide in the past year, and more than half of them transgender or non-binary. that statistic rises sharply with LGBTQIA plus youth who live in homes where they do not feel supported by their caregivers and their families. Next, I want to talk about enforceability. As a clinical mental health counselor who works primarily with kids, I interface with DCYF consistently.
You have about 20 seconds.
Okay. DCYF has a difficult job, to be sure. And the way the current child protection laws are written, DCYF is tasked with sometimes impossible standards already. And so how are we going to add this to their plate and expect them to continue to be effective when the laws are written, in fact, in a way that makes them not as effective as they could be?
One more sentence.
Yep. So
It can be a complex compound sentence.
I don't necessarily think I have the bandwidth for complex because I'm going to the other hearing as well. But thank you so much for your time. I really appreciate you.
On the way over, would you take one question, please?
Yes,
I
please.
do have a staff of family practice providers and counselors.
Mhm.
So I'm just the liberal arts guy in the building.
Yeah.
You know, but I have asked them this question about how many youngsters, age 10, 11, 12, 13, have a same-sex affection or a sense of I'm something other that then transition out in your research, because I have mine.
So in my research, which I glean a lot from the Trevor Project. So if any of you are interested, that's a really great resource, the Trevor Project. I don't know because, and it's hard to look at it from my experience because like the practice that I work in and as my practice as well, we work on the exploration process.
Okay.
We kind of let it be what it's going to be as opposed to saying, oh, this person's going to transition or this person's not.
Okay.
Yeah.
The folks that may have had a sense for, and I'm trying to use polite word, I really am, and there's just so many impolite words all over the place. But folks, youngsters who feel a certain way for a month or two or three or a year, and then don't feel that way anymore, is a statistic too. And, you know, like I said, I've got some. It sounds like your practice is not with that population.
It is and it isn't because we encourage exploration of that because it's a normal developmental process.
Sure,
The
absolutely.
exploration of gender and sexuality is absolutely
No
normal.
question.
So we encourage that, but we don't necessarily actually take data on how many of those people come out as LGBTQIA+.
Okay.
Yeah.
Appreciate that. Thank you. Yes. Yes. So thank you so much. And the chair is now looking for, I think it's Henry Feldman, a counselor named Henry Feldman.
My handwriting is not the best.
That's all right. I deal with medical people by
Okay.
day. And if you have written testimony, when
I
you
do.
finish, you can pass it, put it on Representative
will.
Bickford's place. Thank
And you all can certainly call me Henry if you need to. That's no problem. I actually have an answer to the previous question, sir, if you'd like it. There was research done, came out in the summer of 2022 that said that generally kids who start what we call a social transition, 97.4% of them will persist into a medical transition at some point in their life. So the clinical standard is insistence, consistence, and persistence. And so what that data tracked was kids 5 years after initiating a social transition.
This is for transgender, not same-sex attraction.
Right. So
Okay,
kids
thank you.
who
I just
are-
wanted to get our.
absolutely. Yep. Kids who
Thank
are
you.
assigned a gender at birth, as we all are, and then assert that their assignment at birth was incorrect. Okay. Sure. My name is Harvey Feldman. Thank you to the committee for hearing my testimony. I am from Concord. I'm here today to voice my strong opposition to House Bill 417. I'm a licensed therapist in New Hampshire, and I have clinical expertise in working with LGBTQ youth and their families. Every day I see the life-saving nature of gender-affirming care, and if there ever was an opposite to child abuse and neglect, gender-affirming care would be it. Before I entered private practice, I was a clinician working primarily with youth in systems of care and partnered often with DCYF offices and workers throughout the state. I have seen child abuse and neglect up close and spent the early part of my career supporting families through the process of reunification when possible and foster care and adoption when it wasn't. The DCYF workers I had the chance to get to know during those years were some of the most dedicated professionals I've ever seen, and their commitment to youth and care was and is unending. This bill, quite frankly, is horrifying. It would require those already overtaxed workers to open cases, investigate families, and perhaps remove youth from loving, safe families. If systems of care in New Hampshire were functioning at 100% capacity and perfect, this bill would still be horrifying. However, I can say confidently that the system is broken. There are not enough caseworkers, safe foster families, or clinical resources to support the amount of children and families in the system now, today. LGBTQ youth who are in systems of care are already disproportionately subject to discriminatory, harmful practices, including conversion therapy and tactics. And removing them from safe, affirmative homes is truly one of the most unethical, unsafe decisions I can imagine. As a licensed therapist, this bill would require me to report families who are accessing gender-affirming care, care that is accepted to be the safest and most protective families can give to their children. It might require another provider to report me for practicing ethically and within clinical standards. As I said, I've seen child abuse up close, and equating gender-affirming care to what I've had to witness is deeply, deeply offensive to me.
Just give you 20 seconds to wrap it up, please.
Okay. If this bill were to pass, it would mean that the therapists and providers would have to choose between ethical practice and state law. Thank you very much, and I urge you to retain or kill or stop this bill, please. Thank you.
If you'd like us all to have copies, please. hand
Sure,
one
and
through.
I'm available for questions if folks have them now or later.
Representative Bickford.
Thank you, Mr. Chairman. I have a nagging question.
Please.
As to
You need to ask a question.
asking-
They're getting really tight on us, asking questions. Okay?
why does it need to be done at a pubescent
Thank you.
age as opposed to at the adult age?
Do you mean, what, can you just tell me what it is?
Why is, the issue here is because it's done below, at the, younger than 18.
Right.
Why does it need to be done at that time as opposed to waiting until they're adults?
Well, what we know from research is that mental health outcomes improve significantly when kids can access medical affirming care. And so the why is because anxiety, depression, self-harm, health disparities all go down when kids can access medically affirming care. So you might be asking why medically, and I'm answering with a mental health outcome, because the data is very clear that mental health outcomes are significantly better for kids who can go through medical transition when they're ready to do so. And we don't, in this country, as far as I know, there's no other medical care that's divided out by age this way. There might be different phases of it or different steps in it, but there's no other prohibition I know of around 18 versus not 18. There are kids who get breast augmentation. There are kids who go on puberty blockers for precocious puberty. All that happens earlier in their life than 18. And so I think we also have to ask why we surveil and question certain kinds of medical care and not others.
Thank you.
Thank you.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question.
Absolutely.
I'm a big survey and data junkie, so
Sure.
I was just curious. I wanted to know more about if you could tell me or remember, that the statistic, the 97.4% continued to transition.
Yeah.
Can you tell me where you
Yeah.
remember where you got that from?
Yeah, so it's called the Trans Youth Project. It was initially started out of University of Washington, and then the researcher Christina Olson moved to Princeton, and that's where she is now. And it's the first longitudinal study of trans youth over time. So we have, so if you're a gender nerd like me, we have the 5-year data came out in 2022. We'll have more data in 5 years. So she's essentially, the Trans Youth Project is this cohort of kids growing into adults, and she's going to follow them. And so that initial data was 97.4%.
Okay, great. I appreciate that. And I
Yep.
was actually typing what you were saying. I
No,
didn't
that's
want you to
great.
think I was being rude. Okay.
No.
Representative Panic.
Thank you, Chairman Pearson, for allowing me to ask a question. And thank you for taking the time to come up here and explain things to us.
Sure.
You said that the 5-year data just came in at 2022.
And it was published in the summer of 2022.
Okay, so how long have these studies been going on?
Right.
that the puberty blockers and hormone therapy is the correct answer
Right.
to introduce it to these children that are
Right.
like 10, 13 years old.
Right. So we've been using, maybe not me personally, but the big we have been using puberty blockers for what we call precocious puberty since 1980. And that's for kids who are not transgender, but medically enter into puberty before they should. And so they're given puberty blockers to stop that from happening. And then they stop taking the blockers, their puberty resumes. So we have that data from 1980. Cross hormone therapy and puberty blockers for trans kids, we can trace that probably back to the late 80s, early 90s. And so it is correct that we don't have, 40 or 50 year longitudinal data on this. What we do have is the statistics and the information about self-harm and suicide.
Follow up.
Thank you. The puberty blockers and the hormone therapy that are being prescribed.
Yep.
Are these FDA approved for that specific, or are you using this like off label?
I'm going to consult with the doctor. Off label, right? That's what I thought. Yeah, it's off label. So it is so I guess I would say it's FDA approved, but use off label. Is that the way to say it?
Used off label.
Yep.
There's lots of things used off label.
Sure. So yes, it is used off label.
I can explain that if somebody wants to.
Like ivermectin, for example.
Yeah, thank you. That's a good example. I think there's many more. I'm blanking on them, but there's many more.
Okay.
Thank you so much, Counselor. Appreciate the testimony. The chair now recognizes Emma Savini from New Futures.
Thank you. As stated, my name is Emma Savini. I'm the Children's Behavioral Health Policy Coordinator at New Futures. My comments have largely been stated by the fabulous folks who have spoken so far, and I'm sure others would appreciate having a little extra time. So I'm going to yield my time and just underscore the importance that this bill should be voted inexpedient to legislate, and that the gender affirming care is not child abuse and is in fact critical care for children who need positive mental health outcomes.
Thank you so much and welcome back.
Thank you.
And now the chair calls Beth Margison from DCYF, another regular. Committee, if you've been in a committee for a while, you get to know who comes and comes well prepared, and even if you disagree, can take good questions. So welcome.
Thank you very much, Mr. Chair and members of the committee. I appreciate your time to speak this morning. I'll be very brief. I do not have written comments. DCYF is in opposition to this bill. It does not consider gender assignment procedures or surgeries to be a form of child abuse. And I'm willing to take any questions if anybody has any. Thank you. I'm very grateful for that. To be honest.
The chair's going to disagree with that. We've appreciated your answers to our questions. Chair recognizes Sales Karsten from the New Hampshire Youth Movement. And you've got written testimony, and if you want us to each have a copy, you can pass it down at the end. If you don't, that's okay too, and you got 2 minutes.
Perfect, thank you. I'm Sales Caston. I live in Dover. I'm here representing New Hampshire Youth Movement, a youth organization with many trans student members. Should this bill pass, parents who follow professional medical guidance and affirm the gender identity of their children would be charged with child abuse. This is a ridiculous attack on transgender children and supportive parents, and it would result in young people across the state not being able to receive gender-affirming medical care when needed. I think there's a lot of misinformation about what it means and looks like for young people to go through a gender transition, and I hope to clear some of that up. Gender transitions are not child abuse. There's consensus among medical researchers that gender transitions effectively treat gender dysphoria and improve the well-being of transgender individuals. By far the most common of these treatments among youth is hormone blockers, which are pills or shots that delay the effects of puberty. The effect of hormone blockers is entirely reversible, and the use of blockers is associated with improving overall well-being, reducing depression, self-harm, anxiety, and suicidal thoughts, and social interactions with other kids. In addition, in many situations, all parties agree that a transition is a good idea. Parents are supportive of their child transitioning. The child or young person wants to transition, and the medical professional involved is also supportive. In a situation where parents, the individual, and a medical professional are all on the same page, why should the state be involved at all? No one is being harmed, and everyone is in agreement. Gender transitions are well-researched, safe procedures that improve the well-being of a transgender person. We aren't asking for a lot. We're only asking for the government to stay out of people's personal medical business. Please ITL HB 417, and thank you.
Next time you come, you get 15 extra seconds.
Thank you.
Thank you. And the chair recognizes Amy Whitney from Goffstown.
Hello. I do not have a written testimony. I was actually inspired while sitting there that I wanted to say something, so I'm going to wing it with some notes I made on my phone. I am here as the mother of a transgender teenager. While I've done my research over the years, I am not here with data or figures. I am here to tell you what being a transparent, my goodness gracious. I am here to tell you what being a parent of a transgender teen is for me. It means watching your child withdraw into themselves without any idea why. It means learning that your child is self-harming without any idea why. It means fearing that your child could take their own life without any idea why. I have always been an open-minded ally, even received awards for that when I was working before I had children. But when my son finally told me that he was my son and not my daughter, I internally freaked out. I sobbed in private. I talked to my therapist. I dove into research, and I hoped this wasn't real. And none of that was because I wasn't willing to accept what I was being told by my son, but because I knew that his life would suddenly be so much harder, that he would be bullied and discriminated against, and I feared for his future and his safety. Over time, through continued therapy, soul searching, and open communication that I'm lucky enough to have with my son, I came to accept that this was his truth. He wasn't transgender because it was fun. I think it is in fact far from that for him. He was transgender because he was simply born in a body that didn't match who he is, and he finally had a voice and an understanding to share that with us. I love my son unconditionally. I would die for him. And by supporting and providing him with access to affirming care, that is not what child abuse is. To me, that is what being a loving parent is. Thank you.
If you wish to hand the phone over to Representative Bickford, we will make 20 little phones and pass them around.
I'll email it to you. How's that?
Thank you.
Thank you.
Chair recognizes Erica Perez from the New Hampshire Youth Movement.
Hi, I'm Erica Perez. I'm a director at New Hampshire Youth Movement. This is testimony written from one of our members. If I get cut off, it has been emailed to all of you already. I'm writing to ask you to oppose HB 417. My formative years were not my best. I faced regular emotional abuse. I was molded to believe that I was not good enough in any regard. My grades were not good enough, my interests were not good enough, and my personality was not good enough. When I let it slip that I might be bisexual, I faced a tirade of slurs that drove me out of my home. I learned to never let it slip that I am transgender. All of this led me to being an adult struggling with my sense of self. The one thing I know is that if I had parents that were accepting of me back then, my entire life would have been different, and I would be in a better place now. I'm telling you this because there are thousands of children across the country with parents like mine, children who will not be supported in their interests and endeavor and face backlash for not being an exact replica of their parents, and who might be put in dangerous situations if it comes out that they're a member of the LGBTQ+ community. And then there are children whose parents are the opposite. They are warm, loving, and accepting no matter what. This bill will criminalize those types of parents, while the parents who really do abuse their kids will likely never have to face the same consequences. This is wrong. Gender affirming care is life saving, especially for young kids. We're not talking about things like surgeries. Gender affirming surgeries are incredibly rare for trans children as it is, but things like hormone blockers can make all the difference in ensuring a child's mental health, therefore their life path. The parents who understand this and take appropriate action should not be punished. They are doing what the parent is supposed to do. They are taking care of their child that they brought into this world. Not everyone is born into a family that will accept and support them, which is terrible enough reality.
You have 15 seconds, please.
Okay. Those who are lucky enough to receive that type of love should be able to bask in it, not worried about their parents being reported to CPS. Anyways, please ITL HB 417. Thank you.
This one. Thank you. Chair recognizes Ben Kramer.
I have a copy of this, and you can feel free to make copies too.
Thank you.
Well, hi, everyone. My name is Ben Kramer. I'm a resident of Newmarket, here to testify in opposition to this bill. I worked with young people and children for about 5 years as a camp counselor, adventure trip leader, and camp director. Those years were the single most impactful experience I've had, giving me insight into the lives and experiences of young people and children. Worked extremely closely with kids ages 6 to 18 and their parents. I also have a degree in outdoor education. I know kids who are navigating being transgender at a young age. Some were presenting as their true gender for the first time at camp. Some had recently begun receiving gender-affirming healthcare. Those children who for the first time were seen as their authentic selves were some of the happiest kids I've worked with, and their parents some of the most loving I've ever met. I've also known children experiencing abuse and neglect. I've interacted with parents who were abusive. I've reported suspected child abuse as a mandated reporter. I was trained extensively in how to recognize it and trained others. The experiences of these children experiencing abuse could not be more different than the trans kids being affirmed in their identity. Those parents are not the same. Not once did I, as a mandated reporter and a child care professional, consider that abusive parents and parents who affirm their trans child would both be abusive, because they are simply not. As a parent, affirming their trans child is the exact opposite of abuse. It could not be more dissimilar. Affirming a child's identity is an act of love and support. To classify it as abuse is simply wrong. Urge the committee to vote inexpedient to legislate or retain this bill. Thank you.
Thank you, sir. Chair recognizes Kendra Ford. We'll hold on to, there we are.
Good morning. I will email my testimony to you. I'm Reverend Kendra Ford, and I am a Unitarian Universalist minister. I served the congregation in Exeter for 21 years, and now I am a climate activist with 350 New Hampshire.
What kind of activist?
Climate.
Climate. I'm sorry.
Climate change
I got it now.
is the
Thank
issue
you.
I'm working on. But I am also here for this bill because standing up for life on this planet is part of my work in the world. So I oppose this bill strongly because I'm here for life and for love and for making sure that life gets to bloom in its fullness and its complexity. I think it's important that religious people stand up, even in this context, maybe especially in this context, to say that in our society at large, the religious claim includes this claim, that being LGBTQ is just life being in full bloom. So you've heard from the medical professionals, you've heard from the mental health professionals, you've heard the statistics and the studies, all of which support that gender transition is just part of life. And I want to tell you something about my religious tradition in particular, which is that covenant is really important to us. Covenant is a promise that we make in community, a promise about how we'll live together, and how we'll live in this world. And one of the pieces of our covenant is to respect the inherent worth and dignity of each person. That means letting each person discover who they are in community. And you've heard that described now about gender transition over and over again, that it isn't something that's just someone wakes up someday and says, oh, let's do this. It's something that they discover very deeply about themselves. And I think many humans find that their gender is a really important part of their identity. And we want that acknowledged and expressed in community. And so, of course, that's going to be rich and varied in this life. So in my covenant, I affirm that for all people, and I affirm people to find their own way with that, with support and community. So the folks who wrote this bill maybe want to take care of children, which is such a great thing. And there are so many ways to do that. I've heard from people from DCYF today, they could use a lot of funding, and some funding for that department would help a lot of children. We could increase food subsidies, we could increase school funding, we could increase mental health funding in our state. Those are things that would really protect children. And I hope that those things can be taken up and done so that we can indeed take care of people well in our culture. Thank you.
Thank you. Any questions? Seeing none? Thank you. Next, I'll call up Lori Warnock.
Good morning. My name is Lori Warnock, and I live in Hampstead. I wanted to specifically address a comment made by Representative Pearson. I'm sorry, he stepped out of the room. When he equated the use of ivermectin and its off-label use with the use of FDA-approved and long-used and tested medical interventions to prolong the development of secondary sex characteristics, which is a temporary and reversible process that has been used medically and has been used by medical practitioners and recommended by medical practitioners, as opposed to the use of horse paste as an unproven method of preventing or treating COVID-19. While ivermectin is in some cases available for human use, it is not in any way, shape, or form used previously for the prevention of virus transmission. It's used to treat parasites. I think it was a very false equivalent to compare a drug that has been used off-label, recommended predominantly for animals in an untested manner, to compare that to the use of FDA-approved medications in the appropriate way for which they were developed and have been tested and have been applied. As a comparison, when we're talking about identifying child abuse, this is an appropriate medical treatment. It has been long practiced and proven. These are medications which have been proven safe in exactly this age group for exactly this purpose. So I think to create the impression that the off-label use of these appropriate medications that are in fact reversible so that a child, as they grow, can fully realize their identity and make their own decisions as older children or adolescents or adults, comparing that to the off-label use of a veterinary medicine is inappropriate. I work as an educator for the Northern New England Poison Center. I'm speaking on behalf of myself today, not as a representative of the Poison Center, but I can tell you we have seen over the past 5 years a dramatic increase in suicide attempts and self-harm among younger and younger children. And I cannot stress the fact that anything we do to jeopardize their mental health, especially when we're talking about a system that is already underserving this population, would constitute child abuse. And I thank you for taking the time this morning to hear me.
Thank you. Any questions? Representative Panic?
Thank you. I thank you, Representative Long, for allowing me to ask the question. Are there cases where, when they're using the puberty blockers and the hormones, that the parents are not aware of that treatment, or are they always?
I'm not qualified to address that question. I think there are probably medical professionals in here that are more aware of the privacy practices between practitioners, young adolescents, and parents. Sorry.
Thank you.
Any further questions? Seeing none? Thank you, ma'am. Next, I'll call Chris Urchel. Just a reminder that we're at 2 minutes. Thank you.
Good afternoon, Chair Pearson, members of the committee. Thank you for hearing my testimony in opposition to this bill. This is probably the third or fourth time I've been before this committee in consecutive years to testify against this same exact bill. You will hear plenty of information about the benefits of gender-affirming healthcare for transgender youth and other youth experiencing gender dysphoria. You will also hear plenty about the harms that come from denying access to healthcare. I want to focus, I'm an attorney with GLBTQ Legal Advocates and Defenders, GLAD, based in Boston. I'm a New Hampshire licensed attorney, and I want to focus on the legal issues that come into play with respect to this bill. I think that you probably know that similar legislation has been passed prohibiting parents from being able to obtain health care for their children who are experiencing gender dysphoria in other states. And in 2 states, there have been lawsuits, both of which have resulted in the injunctions against the laws. And the basis for those lawsuits is constitutional claims that they violate both the rights of the parents, because parents have the right to direct the upbringing of their children, and nothing is more essential to that right than making healthcare decisions in partnership with medical professionals adherent to widely accepted standards of care. Nothing could be more central to your role as a parent than making those healthcare decisions for your child. Second, I want to establish that there is an equal protection issue. The 14th Amendment of the U.S. Constitution, as well as the New Hampshire Constitution, prohibit discrimination against a class of people if that discrimination is irrational or otherwise, violates the rights of a protected group.
15 seconds.
And so transgender people are a class of people who are singled out by this legislation and denied access to healthcare. And by targeting that group of people, the legislation is unconstitutional. I'm happy to take any questions.
Any questions? Thank you. Thank you, Attorney.
Thank you for your time.
The chair recognizes Kimberly Hester from Nashua.
Hi, my name is Pastor Kim Hester, and I'm a resident of Nashua, New Hampshire, and serve as pastor of Lutheran Church there. I come before you today to urge you to reject House Bill 417 and to protect the rights of all citizens of the state of New Hampshire to make physical and mental health decisions in conversation with their doctors, family, and caregivers. The core of this bill is to seek to instill fear and levy criminal penalties at parents and medical professionals who are seeking to provide the best medically supported care for their children and patients. What kind of society are we living in where the same people who in another place today we are advocating for the rights of parents while seeking to threaten teachers for being safe spaces for children and youth are at the same time seeking to take the right to make decisions for the health and welfare of their children away and make it criminal to provide love and care? What kind of world are we living in when medically trained, certified healthcare professionals are restricted from providing that medical care that for too many of our kids and youth is the difference between life and death? As a pastor, an educator, a parent, a step-parent of a trans young adult, and as a citizen of New Hampshire, I call on all of you to stop with the politics, to end the ignorance and hatred, and simply leave the medical decisions up to the medical professionals and parents and caregivers as they do what is needed for their children together. Providing the best medical and mental health care for anyone is never a crime and should not be treated as such. Remember our state motto, live free or die. Let's stay on the side of living free. Protect our kids and youth and those who care for them, and stay out of their health care, and simply say no to House Bill 417. Thank you.
Chair recognizes Derek Brunt.
Hey, I'm here to testify in opposition to HB 417. Before I get deeply personal, I'm going to talk for a moment about the economy because I'm told people care about
Just
that.
remember you have 2 minutes total.
Yep. New Hampshire has a booming technical and scientific sector. I have a highly skilled job within this field and could have worked in any state I chose. I chose to move to New Hampshire in no small part because it's a haven where my family can be safe. If this bill passes and I one day have a trans child, I would choose their life over my job. Most of my colleagues are allies to the trans community, and I believe they would make the same choice. This bill would absolutely create a massive brain drain in New Hampshire, damage our property tax base, and make the lives of everyone worse. But now on to the real problems with this bill. I have a dear friend whose information I'm not going to share for obvious reasons, who has an amazing trans daughter who I met this summer. She's vibrant, joyful, and happy as any teenager hopefully can be. If this bill passes, my friend will be faced with a choice. Option A, she can stop providing her child with access to gender-affirming care, a choice she tells me would almost certainly make her daughter suicidal. Option B, she could continue to provide access to care for her daughter covertly and risk losing her child altogether to the foster system. Do not let anyone tell you that the foster system will not steal kids if this bill is passed. If this does happen, that transgender daughter's care, her health care, is even worse. She could lose her parents and her health care at the same time. And the third option is flee the state. All these options in the same place. One less human who is transgender getting to live their free life, free of state violence in New Hampshire. There's no mincing words. The impact of this bill would be to kill trans kids in New Hampshire or force them to flee. It wants to get trans kids out of this state. It is exterminationist. It
10
is gendercidal. You should not pass this bill. You should not have, honestly, given this bill the time of day. I'll be done.
Thank you. Chair recognizes M.K. Kilcoyne from Dover.
Hello, my name is MK Muir Kilcoyne. I use they, them pronouns. I'm from Dover, New Hampshire. I'm also 30 years old and identify as gender fluid and trans. I'm testifying in opposition to HB 417. The bill before you today proposes to call accepting and loving parents abusive for supporting their children in their gender expression. I would like to tell you my story of coming out to my family and how that's affected them to this day. My first experience with questioning gender identity actually came from my cousin coming out as a trans woman. When I was 13 and she was the same age, she came out to me on MySpace. She ended the letter with, "I understand if you don't consider me family anymore." I clumsily offered my support because she was right. Jenna was a woman. 3 years later, in English class, the topic of trans people was brought up alongside intersex folk. A board class tried to say it was unnatural, and I was able to tell him how wrong he was. Fast forward to 2016, I'm working on college campuses, and I have the opportunity to learn that transgender isn't just the binary male to female or vice versa that I had thought. There was non-binary, agender, and what ended up making sense for myself as gender fluid. Next came telling my family. I remember calling my sister and asking if she'd still love me, mimicking the words my cousin had used a decade before. She said, of course, she just didn't know what advice she could offer. I told my mom while sitting on the beach, completely unplanned. She was understandably confused by the terms, but accepted it and has done her best to stay educated on gender identity. Finally, it was my dad. He's Irish Catholic, and one I was most worried about, having been daddy's girl my entire life. We were in his truck moving some things to my new apartment, and I just blurted it out. I was able to explain that I always felt somewhere in between, but definitely not just a girl. I said, I know you love me, and I don't want to be scared to tell you. Spoiler alert, my whole family loves me exactly as I am and supports me. Now my dad uses titles like first of my offspring when referring to me. My mom loves being the educator for other folks about queer terms. They're not always perfect, but they're always trying. When my parents' friends come to them wondering how they handle me being me, they simply answer with, they love me. And that's it. I don't think they know how many lives they've saved by being accepting of me and letting people see that.
You got 15 seconds, please.
Wrapping up. Granted, I came out a lot later than the parameters of this bill, partly because I didn't know there was anything else I could be. I probably wouldn't have been as eloquent, even though I wasn't to begin with, and my parents even more confused, but I know the result would be the same, and that is not abuse. As such, I urge you to oppose HB 417. Thank you.
Thank you so much. Chair recognizes Abby Maxwell.
Should I wait?
No. Go
Okay.
ahead.
My name is Abby Maxwell. I'm here representing myself, speaking in opposition to HB 417. My daughter is 10 years old. When she was born, we thought she was a boy. She spent ages 3, 4, and 5 begging for long hair and dresses, but we lived in a small town where already she was mocked for her pink shoes. My husband and I wanted to protect her, so we said no. When she was 6, she asked me if it was illegal for her to wear a dress. I still remember how I froze, horrified by the impression I was giving my child. I called my mother that day, and together we sewed the Halloween costume my child had been begging for years. She would be a witch in a dress. That costume was the first dress my daughter ever got to wear, but it was just a costume. By winter of that year, she was banging her head against the wall, insisting that she could not go out in boy clothes. She was staying up crying half the night. And then one day, as we drove to visit my mother, my child said from the back seat that she did not want to exist anymore if I kept making her live as a boy. Finally, I woke up to the suffering I was causing my child, and I sought help. My husband, daughter, and I visited the best children's hospital in New England. There, we learned about transgender children and how to care for them. My husband and I were scared, but we knew that we had to follow the research and trust the experts. Soon after that appointment, we finally let our daughter change her name and pronouns. I'm not exaggerating when I say that she transformed overnight. A weight she had carried her entire life fell off her shoulders, and a light came on inside of her. Everyone saw it. I don't know what care my daughter will need in the future. But if this bill were to pass, it would not only mean that the life-saving option of puberty blockers would be banned, it would also mean that her therapist could not affirm her as a girl. Her primary care doctor could not. It would mean that we would have to leave
You're
the
over time.
state.
Please wrap it up. You're over time now.
Sure. I spent my entire life thinking about these bills. With all due respect, you cannot imagine the amount of time this takes out of my life. So I will take about 30 more seconds.
No, you're finished. Thank you. Everyone else went along. The chair now recognizes Candace Moulton. Everyone else wanted to speak longer too, and they went along. We understand. Candace Moulton, do you wish to testify?
I do.
Thank you. Come on up to the table, please.
Thank you, Mr. Chairman.
2 minutes.
I just want to share from a personal perspective. My son currently identifies as a boy, but I would call him gender fluid, and his name is Kyle. A day without Kyle is a day without sunshine. He likes Hot Wheels. He also likes unicorns. He likes Shopkins. He likes LOL toys. He likes Scruffaloofs. But he also likes, blocks and Legos. He likes them all. As a mom, one other thing too, his hair is currently about the same length as mine. I love him, and I would have to, if this bill was to go through, I would have to not buy him the toys that he wants, maybe. I don't know what it would look like on a day-to-day basis, but I do know, just as a parent, like if I'm going to give him $100 to spend for his birthday, like why, if he wants LOL toys, my only concern as the financer of his birthday gifts is that he's going to play with whatever he asks me to buy, to be honest. I just don't want to like buy something that he's just never going to play with. So, honestly, whatever makes him happy is what I want to do as a mom. So whatever he enjoys is fine, to be honest. If he wants to add to his unicorn collection, I just want to make sure he has somewhere to store it in our house. So I just want to give this perspective as a mom whose child is still developing their gender identity.
10 seconds, please.
Thank you. Just that I would feel that it would be in his best interest to affirm whatever he wants to be. That's my role as a mom.
Thank you.
Thank you.
Chair recognizes Christine Hegarty.
Sorry. Thank you for this opportunity to speak to you today. My name is Christine Hegarty. I have been here before. I am strongly opposed to HB 417. As a parent of a trans child who just happened to turn 18 yesterday, I am absolutely appalled, offended, and distressed that I could be considered as a child abuser. This bill is dangerous for all children, but especially for those seeking gender-affirming care. There is more abuse happening in families where parents cannot understand or support their children's call for help. I have worked very hard to pay attention, learn, and understand who my child is. The parents who do not take the time, take the same care, are the ones that are damaging the lives of their children. They are the abusers. Getting medical care and mental health guidance is the best scenario for kids who are questioning or struggling to live their lives. And there are so many that do not have access or adults that can support them in finding it. How in the world could you accuse parents in this case of child abuse? My daughter was so lucky, so I have been told many times over, to have her dad and I as parents. We have not pushed her to be anyone other than who she truly is. We have let her guide us in this process. Since she was 4 years old, I've been listening to her. You might think a 6-year-old would not be capable of communicating their needs, but just as a child who scrapes their knee or cuts their finger can scream in pain, so can a child who is struggling with gender dysphoria.
15 seconds. Good, thank you.
Please do not punish parents and endanger families who are actually caring and protecting these most vulnerable children. Thank you.
Thank you. Chair recognizes Karen Testerman for 2 minutes. And you've got handouts you can give to our Representative Bickford. 2 minutes.
Thank you, Mr. Chairman and committee. I am the David in the Goliath. Thank you for your dedication to give us strong and serving the people of the state of New Hampshire. I come before you to testify on HB 417 and in support of HB 417. While I truly believe parents were gifted with the responsibility to govern in the affairs of their children in their care, actions by the legislature and executive branches of New Hampshire have literally thrown a monkey wrench into the works. Through their actions in 2019 in codifying the existence of other than biological male and female in the recognition of gender identity, this action causes a Pandora's box, allowing parents to make the decision to alter by chemical or surgical means the natural biological sex of their child. Some of the unintended consequences of this decision are suicide, lifelong dependency on pharmaceuticals, depression, and other psychological maladies. In this situation, it is my opinion that such action is child abuse. So when the situation is the right of the parents to cause confusion and physical harm to one or more of their natural born or court-granted children, I submit this testimony and ask you to support 417. I would also like to address a question that was posed to Representative Pearson early. Approximately 92% of children who are confused in their gender identity as a child growing up, by the time they reach puberty, have changed that opinion. Additionally, the American College of Pediatricians also supports this as being child abuse. And I have one more quick thing to say to you,
And
because
you got 15 seconds.
certainly excuse me, puberty blockers and sex hormones do not have the U.S. Food and Drug Administration, FDA, approval for children for gender care. No clinical trials have established this their safety and such labeled use. And there are no long-term studies that show us what's going to happen in the future in these children.
Thank you very much. And with that, I end the hearing on this bill. There are no more pink cards in my possession on House Bill 417. There was a question for Ms. Testerman. I'm sorry. That backlighting has, there we go. Thank you so much, Representative Gregg. I do apologize for that.
Yeah, so as you heard, when we have statistics, we do like to see what's your source for that. So you said 92% changed their mind or whatever. What's your source for that, please?
I would have to research that again for you. I just know it from the back of my other research that I've done. I am also a microbiology trained person, so I do a lot of research. Thank you. I can get that to you.
Thank you. Okay, now we're done. We will come back at 1:15. is call you to an on-deck circle so you can walk down and be ready to testify when the person testifying is finished. So if you wish to go down to 201, 203, they've set that up as the overflow room. We are sorry that both Reps Hall and the Ice Arena in Manchester are occupied at the time. Committee members, coming around is an amendment to the bill. Could you all pay attention? It is an amended version of the bill, which is really what they wanted in the beginning. And so the reason I'm giving it to you is you may have a comment, and if you're commenting on the original bill, the language may not be in the original bill. So, it's sincere, but it's useless. So we're going to try to work off this. Anybody who just came in who does not have a seat, either you will be standing for the next several hours, or there is an overflow room in 201, 203 that will have this hearing piped in there. So if you want to go there, you may. Oh, joy. What's that? I can't. Well,
Mr. Chair. Mr. Chair.
You have lots of piles. I don't want it to get lost.
you know I do. Oh, thank you. If you were here for hearing on 417, that was opened and continued and closed this morning. We plan on rescheduling that for next Tuesday at 9:30. House Bill 417.
Bigfoot is now passing around.
Mr. Chairman, can you repeat that? Those of us in the corner are confused.
The hearing on House Bill 417. Is that
That's the previous bill.
okay? What's the one we didn't do? What's the other one? 475, sorry. The hearing on 475 is postponed to next week at 9:30.
Mr. Chairman.
Committee members, a lot of extra copies are now coming around from various testimony of the last bill where the people making presentations either had one copy or only a handful. And the team made photocopies for everybody. And they are coming around now, so pardon our indulgence here as we get caught up.
I have a question. I got this.
I know we're all swamped at the moment. We have here Raymond's testimony.
Yep, that's Raymond's testimony. And I now open the hearing on House Bill 10 and recognize the Speaker of the House, the Honorable Sherman Packard. The committee members should have received the desired presentation of the bill, which is an amendment 720. This is important for you to know now. So if you ask questions based on the old version and those words are not in the new version, you didn't need to do that. So this is how you know. Mr. Speaker.
Thank you, Mr. Chairman and members of the committee. As you just pointed out, Mr. Chairman, this is the final version. And that's what we're requesting that the committee take up and vote on. The original version that you have in front of you, the original bill that was filed was a placeholder, and this has gone through numerous different layers that I will explain. Mr. Chairman, I'm having a hard time understanding why any legislator or parent be against this legislation. Parents are responsible for the upbringing of their own children, with the help and support of government, not the opposite. That's what HB 10 protects. Protects parents' rights and the ability to be 100% involved in their children's daily lives. Came close to passing a similar bill last year. We went to work on it and have spent months working with advocates, legal experts, and parents. This result was common sense legislation that protects the rights of parents while supporting our most vulnerable population, our children. This bill is products of months of collaboration with the Senate and the Attorney General's office, and it is the fourth version of this bill. In a recent poll of 1,000 New Hampshire voters taken last month, respondents chose parents over state employees to have the final say of what their children are taught, nearly 2-to-1 margin. When specifically asked about schools keeping students' behavior regarding sex and gender secret, 78% supported the parents' right to know. We support parents' right to know what is happening to their children when in school. And I and many others believe parents make the best decision for their families. I'm a father. I had a daughter in school, and I certainly would have wanted to know what was happening in school with my child. We support the parents who want to be involved in their children's lives and take an active role in their education. Rhetoric perpetuates that lie that school personnel know more than we do and what is best for our children. There was a time when parents were being labeled as terrorists and being attacked simply for wanting basic transparency. This happened in many of the school district meetings, some which I attended in my local town. Opponents of this bill say the legislation is dangerous and harmful. What is dangerous and harmful is not having parents involved in their children's lives and future. In the first line of the bill, it says, "The General Court affirms that it is a fundamental right of parents to direct the upbringing, education, and care of children, their children." Show me what is dangerous and harmful about that. The only thing dangerous and harmful is believing that parents do not have a right to protect their own children. Parents deserve transparency, and HB 10 provides the protection they deserve to have. Mr. Chairman, I will not be taking any questions, and I will let Representative Greason, who is the original sponsor, dissect the bill for the members. He is much more knowledgeable about it than I admit I am. I was a prime sponsor of this bill because I truly believe that is the parents, not the state, who should be responsible for the upbringing of these of our children. I truly believe this is one of the most important issues of our time, and we must keep parents completely involved in their children's lives. With that, Mr. Chairman, I will let Representative Greason dissect the bill for you, and that's why I've chosen not to take any questions. Thank you.
Thank you, Mr. Speaker. The chair recognizes Representative Greason and also Representative Paul Terry, who is one of the other co-sponsors and knows some details that Representative Greason says he doesn't know. So it sounds like a good team. Those of you who are standing, the overflow room is 201-203, where this hearing is being broadcast. If you filled out a pink card but go to the overflow room, I will call the names in such way that you will have time to walk down carefully to this room from the other one. With that, Representatives Terry and Greason.
Good afternoon, Mr. Chair and committee members. Thank you for the opportunity. I am privileged to introduce House Bill 10 to follow the Speaker in introducing House Bill 10. I do want to bring your attention primarily to the amendment 0720. This was supposed to be the original bill that you would have seen. You never would have seen the other version. And it's okay that you did. There's no secrets in there. The amendment makes it more streamlined, and it did go through a more stringent vetting process to make sure that there were no conflicts with the Constitution or any other laws. The Attorney General has reviewed it to give us the language that would be necessary. And so what I do want to do is to just very quickly go through and show you, highlight the differences, the changes that you will see in the amendment versus the original copy that you have. That way we can avoid some questions that may not be pertinent to the bill. First of all, there is a section in the original version that defines compelling state interest. That has been deleted from the amendment at the direction of the Attorney General, because the concept of compelling state interest is throughout our RSAs. Every judge, every attorney understands that principle, but to try to define it in any one particular in any one particular piece of legislation could potentially compromise the definition in other aspects or in applications of the law. So that became problematic by trying to define it too narrowly or being too broad. And so that has been deleted, but the expression or the phrase compelling state interest is still in there because that is an essential part of the government's ability or the power or the authority to infringe on anyone's rights regardless of the nature of those rights. They have to have a compelling state interest. Secondly, a large portion of the original, what is section I, it's going to be on the original version, page 3, beginning at line 25, section I-5, says school board notifications of parental rights. Most of this entire section has been deleted. I can get to it real quick. Let's see.
Line 25.
That would be beginning at line 25. That section, the school board, it goes out to outline that the school board, school district, or school administrative unit shall, in consultation with parents, teachers, and administrators, develop, adopt, and promulgate publicly a policy to promote parental involvement in the public school system. And it goes out and outlines what those things might be. There was a concern that this might become an unfunded mandate. It wasn't directly one, but it could be perceived as being one. We don't want to even come close to having that perception that it could be a 28A violation. So we eliminated that entire section. It's actually not even necessary. It makes the law much more just longer than it needs to be, and may perhaps even introduce some confusion into it. So we don't want it to be confusing in any way, and we certainly don't want there to be any unfunded mandates which would violate the law. So we deleted that out of the amended version. So that's why the amended version is much shorter than the original version as well. If you go to the section that is violations in the
Is this the amended or the?
It's of the original bill, that section 5 has been deleted. Yep. In the amended version, section 7 is violations. The original version.
Page number?
Page 5 of the amendment and page 6 of the original version.
Okay.
In the original version, it calls for, in Roman numeral 1, a violation of any provision of this chapter by an individual shall constitute a Class A misdemeanor. And then it goes on to explain the violations. In the amended version, this Class A misdemeanor has been eliminated as a first offense. We don't want teachers accidentally committing a crime, and so to eliminate the potential for inadvertent commission of a crime and it having a Class A misdemeanor, we made it an intentional on a repeated offense. So if you'll notice, the first offense becomes a civil action, a right of parents for civil action, and then a repeat offense would then be subject to a Class A misdemeanor for a teacher who would intentionally violate on multiple offenses. So, and this is not unprecedented. If you go through the statutes, there's actually a senior citizens bill of rights, and if you violate the provisions of the senior citizens bill of rights, that is a Class A misdemeanor. So it's not unprecedented for that to be a standard of punishment for violating the rights of someone, as in our statutes. Those are probably the biggest changes. Oh, actually, and one other thing I do want to point out, because I know this is going to be hot button, and so I'm going to be ready for the darts to come flying at me on these sections. But if you go to the section 169I4
page,
let me get to that real quick. That's going to begin on page 2. Page 3 also continues until you get to page 4. And I want you to to look at page 4. It's the amendment, page 4. Hold on. Is everybody on amendment page 4? Points W, X, and Y. Points W, X, and Y. Those are probably the most contentious of all of the points. Everything else is explicitly stated in RSAs already. These are the only ones that don't have any other references in the RSAs. The original version, or the amended version, changes the original to include the clause in each of the 3 lines. You'll see the clause upon inquiry. The concern that came up when the bill was first introduced last time was that if a student confides in a teacher, would the teacher then be compelled to call the parent immediately and inform the parent? We want to have a good relationship between the students and the teachers, but we also must have a good relationship between the children and the parents and the school and the parents. So how do we do all that? And to compel the teacher to then immediately inform the parents could violate a trust or a relationship that the student may have with the teacher. But it also, we need to be sure and protect that relationship with the parent as well. And so we put the upon inquiry on there, which means that the parent would have to ask. And then once the parent asks, then the teacher would be required to inform. What's happening that we see a lot of, and I mean, just this morning, every day seems to be a new example of why this bill becomes necessary. But just this morning, I read of a school in Colorado where the assistant principal asked, how do we deal with children that would come out as transgendered or gay or whatever, anything. It doesn't matter what it is. It could be an eating disorder. We don't know just how, but it's specifically this what happened to deal with a transgendered child. But how do we address the situation where the parents have explicitly said, no, you will call my child by their birth name and the appropriate pronouns, et cetera, et cetera. The parents have explicitly said, this is what you'll do, but the schools were not abiding by the parents' wishes. So the assistant principal asked the question, what do we do? And the assistant principal was advised to lie to the parents. Blatant lie to the parents. You tell them, what you do is you address the student at school by the name they've chosen and the pronouns they've chosen. But when the parents ask about it, you lie and you tell them what they want to hear. That's what was done. And that is why a foundation that is built on lies will crumble. You undermine the relationship between the student, the child, and their parents. That's a natural relationship. The student-teacher relationship is not a natural relationship. The relationship between the parent and the child is a natural relationship. And you undermine that when you lie to the parents. And so I would ask the kids, next time somebody, when you have an opportunity, ask the teachers and the principals or anybody. It doesn't matter left or right or center or whatever. If you would lie to my parents, how do I know you're not lying to me? And so we are trying to protect the integrity of the parent-child relationship, protecting the children, not from their parents, protecting the children and protecting the parents' rights to govern all those decisions that parents have to make regarding their children. And so I will leave those comments off there so that we can answer specific questions pertaining to the bill. But one thing that is important to understand in this bill, what this bill does not do, none whatsoever. This bill does not say a child cannot transition. This does not say that the child cannot come out at school and be whatever, whoever, called by whatever names or pronouns. It doesn't matter. That's not what this bill does. It does not say they cannot do that. It doesn't say they can't join any particular clubs. It doesn't say they can't participate in any particular activities. All it says is that they must have parental consent and knowledge. And I'm not really sure how that is harmful and dangerous And that would, just as the speaker said, how is that harmful and dangerous? And I know one of the questions that's going to come up, because it came up last year, what about the parents that would abuse their child because they found out? Well, we already have laws that deal with that. And if you will turn in the amended version and in the original version, but in the amended version, there is a section that says, it's page 4, line 23. This section does not authorize a parent of a minor child in this state to engage in conduct that is unlawful or to abuse or neglect his or her minor child in violation of general law. This bill also does not restrict or prevent those who are mandatory reporters of any suspicious or anything you might suspect as being abuse. It doesn't prevent them from reporting that suspected abuse. So it's not about what the kids can and cannot do. It's that they can and cannot do it without parental permission. And I think that's a pretty reasonable thing to do. And I'll take your questions to that.
Representative Raymond.
Thank you, Mr. Chairman, and thank you, representatives, for being here. Mr. Chairman, I would like to ask for a bit of personal privilege here. The representatives have clearly put a lot of work into their amendment. It is 6 pages long, and I cannot read it while also attending to your comments. My brain doesn't work that way. So I would like to beg everyone's indulgence in giving the committee a few minutes to actually read this so that I can ask intelligent questions. I had prepared questions based on the original, but it sounds like there are some significant changes, and I would rather spend 5 minutes reading and understanding what's in front of me and asking intelligent questions than spend 10 minutes asking you questions that you tell me don't apply.
Thank you, Representative, for bringing this up. The chair will recess for 5 minutes.
Thank you.
Can we ask for just for a little bit of silence though, because the recess is so that we can have the time to read this. Thank you.
Representatives, you may continue. Questions for the representatives so far?
Mr. Chair, Representative Raymond was going to ask a question, but she asked to take the recess.
Okay. Representative,
Mr. Chairman, I too have prepared remarks, but in view of the fact that there are questions on Representative Greason's testimony, I will wait until the questions have been exhausted.
okay.
Thank you.
Representative Long.
Thank you, Mr. Chairman. Thank you for your testimony, and thank you for articulating the amendment. So on line 5, where it says, actually starts on line 4, the general court further finds that important information related to minor child shall not be purposefully withheld if inquiring, correct?
This was in reference to, actually in the original version of the bill, the statement actually had to not be withheld either inadvertently or purposefully. And so we don't want someone accidentally committing a crime. We needed to eliminate the inadvertently portion of it. And so this is purposely withheld.
Okay. And I'll come back to questions. I got a bunch if somebody else has.
Representative Moulton.
Thank you, Mr. Chairman. I'm wondering how this applies to psychological services where there is confidentiality built into the child and therapist relationship. And I'm just wondering if the terms medical, personnel and medical professionals and things encompasses psychological services.
Thank you for your question. Except as otherwise provided by law or a court order.
That covers it. Representative Petrino.
Thank you, Mr. Chairman. Thank you, representatives, for taking my question. Looking through the bill very carefully, I don't see what is in here that doesn't already exist someplace else, as in federal or state statutes, Department of Education, directives. Having talked for 40 years, I'm looking at each item and I'm saying, yeah, okay, I get it, I see it, we do it. For example, opting out of sex education. Kids can opt out of absolutely everything and anything that a parent says, I don't want my kid to participate in. So can you just direct me to where in this bill is there something different from what I haven't experienced in 40 years as a high school teacher?
Well, thank you for the question. The motivation behind this bill is because despite being in law, there's a lot of infringement upon the rights of parents, so much so that a judge in Manchester last year said that parents don't have rights. And so we want to clarify that indeed they do have rights. These are their rights. That in fact this isn't even an exhaustive list on this right of those rights. However, the law can only enforce that which is stated in this. If this becomes law, you can only enforce what's written in here. The language of this bill is slightly different from the original version in that the language outlining all the rights that parents have is actually taken from a technical advisory that was issued last year by the Department of Education, the New Hampshire Department of Education. And so this was submitted to remind schools that parents do indeed have rights. Here's the references to statute. We just wanted to codify this in one clearinghouse. These are the rights that parents have. This is the enforcement mechanism behind those rights. If there's no enforcement, then there are no rights. And there's clearly been some infringement, and I'm sure there's plenty of people who will testify as to how school, and it's just like with right to know. We have the 91A laws. I sit on the Judiciary Committee, and we have bills that are coming before us because despite having laws on the book referring to the citizens' right to know what's going on in their government, you still get obstruction by the same government officials who refuse to release the information under a right to know request. So just because it's written in the law doesn't mean people aren't going to violate it.
Representative Grossman.
Thank you, Mr. Chairman. Thank you for coming before us today and bringing this bill. So as an educator, my concern is, and as a parent as well, so both sides, I've got 3 teenagers and they're in high school, and we regularly have meetings at school, and I hear the guidance counselor say to my son, whatever we talk about, we're not going to, like, there's a privacy code in those teenage years, of letting students know that there's a safe place for them at school to talk, and that it won't all be divulged to their parents. My fear, my worry is that those relationships will become severed and school will no longer necessarily be a safe place. And then on the other side, the effect on our educators. They're pretty important in our community, and I'm concerned that this would affect folks from going into education and wanting to be in public service of teaching our kids in community, because they would lose control of their classroom to potential parents that, you get where I'm going at. So do you think that this would have an effect on the educator pool?
I don't know who will and will not get into education, but I also, to flip that back around, I'm concerned about the relationship between children and their parents and what might undermine that relationship. Why would teachers intentionally place themselves between a parent and their child? Does that not then make the home a not so safe place? You are causing the child to then question whether their parents care for them and love them. I know that it caught me I was taken aback by a very disturbing comment that came out. Some kids will be beaten to death if their parents find out about find out this information. And that what that does now is paint parents, all parents, as being child abusers. Just all you have to do is disagree with some school policy. All you have to do is oppose whatever, or all you have to do is ask the question, hey, what's going on with my child at school? And now all of a sudden you're being looked at as a child abuser. So how does that foster trust between the parents and the schools? How is that fostering a good, positive relationship? Why would parents then want to put their children in schools? I'm pretty sure that kids are coming out of the public schools because the parents don't feel that their children are safe in the schools, because there's not even a positive relationship between the parents and the schools. So that's undermining the whole relationship at home. So remember, you got to go back to natural rights. The relationship between a parent and the child is a natural right. There is no natural right of a student or teacher and a student. So I'm not really sure where your concerns are arising from if you are purposely misinforming parents, if you're purposely just lying to parents, if you're withholding information that parents need to know about their own children. Separate it from any kind of abuse. Abuse is a totally different and not anything that we can support or condone in any way. Separate that from just every other ordinary citizen, regardless of their political persuasion. You've now labeled them as an abuser and a domestic terrorist.
Representative, picking up on that thread, when you were describing the assistant principal in Colorado who was told to lie to the parents, do you think if that either is, and we discovered it, or is becoming more common, this will accelerate the drive amongst many people for education accounts and charter schools and religious schools and homeschooling and so on, because the distrust has now grown, and for palpable reason?
I absolutely agree that this would only exacerbate the problem of distrust. It would sow discord in the community between the parents and the schools, with the teachers. children are they're just not going to know who to trust. They won't trust their parents and they won't trust the teachers. They're not going to have anyone to turn to because if my parents are lying to me or if my teachers are lying to me, then who do I turn to? Why are we having to put the National Suicide Hotline on the back of their ID card? I think they're going to get busier if we cannot even form a relationship based on trust. And so, and by the way, we know about that issue of the school in Colorado because of a right to know request.
Thank you, Representative. Representative Grossman, you wanted a follow-up, I believe. You're done? Representative Raymond.
Thank you, Mr. Chairman. And thank you so much for indulging me and letting me have a chance to read this. I really appreciate it. So I have a couple questions on the amendment, and then I have a couple questions that your testimony has then
Just
triggered
two questions, and we'll give others a chance,
Okay.
and we may get back to you.
So I will ask first about your testimony. You're citing a case in Colorado, and you cited a judge saying parents don't have rights here in New Hampshire. So I'm asking you to please send the committee that information so that we can see that news article or right to know request or whatever it is, and then any case law regarding Office of Civil Rights complaints that allege that schools are violating parents' rights in this way. And then on the amendment, my question, well, I'll have to boil it down. My question is on page 3. If you look down to lines 22 and 26, it says on 22, the right to review medical records, and then there's some exceptions if there's a criminal component. What about DCYF involvement? So, for example, if there is a DCYF case alleging medical neglect or some sort of abuse or any other type of DCYF involvement where a DCYF is investigating using medical records, would that also be appropriate to have an exception here, or are you thinking only if it's a criminal investigation?
When DCYF is involved, there is a compelling state interest for there to be an action. Hopefully, theoretically, DCYF does not interject itself into domestic situations uninvitedly or not directed by an authority to
No,
direct
someone
them into-
makes a report, DCYF goes
Correct.
out.
So when the parents are, and by nature of an investigation, there is an investigation of a crime committed, either neglect or abuse. So DCYF being involved, the right to access and review all medical records of his or her minor child, unless prohibited by law, if the parent has been convicted of any crime against them, or if the parent is the subject of an investigation of a crime, perhaps neglect or abuse. So the investigation may be by DCYF, and law enforcement agency has requested of the applicable court that any information not be released. And so to be able to investigate is part of the compelling state interest and is not interfered with. They're still able to do that. And so that becomes a court-directed order at that point. So DCYF can still investigate. And the medical records, if the judge determines that they shall not have access to the records, then the judge can then issue that the parents cannot have access at that point. So it's all within law enforcement and the investigative process. So it's not a conflict at all.
Other questions from other representatives? Representative Petrino.
Thank you, Mr. Chairman, and thank you again, representatives, for taking another question. I'm a parent. I'm a grandparent. I was also an educator for 40 years. Vast majority of teachers, school administrators, and so forth are parents themselves. Why do you think they would put forth policies that would deny them their rights as parents? I mean, we're talking teachers and parents. Vast majority of teachers are parents. Do you think that they would put forth policies that would deny them their own personal rights?
I don't know. I don't know why they would. Maybe they don't understand that they are. These are their rights as well as parents. If you are an educator and you have a child in a school, you are not directly teaching that child. Let's say you're a 5th grade teacher and your child is now in 10th grade. You're not directly teaching that child. But let's say something's going on at the school that you disagree with. You would be covered by these rights right here to be informed about what's going on. It doesn't matter what it is. Everybody keeps thinking all these worst case scenarios. Oh my God, the sky's going to fall. And it's like just basic. You have the right to know what's going on with your kid. Don't you want the right to know what's going on with your kid at school? And so they don't understand. I don't know whether they don't understand, they don't care, they don't know. I don't know why they would do it. I don't think it's a simple answer. So understanding that these rights as a parent apply to you regardless of your profession.
I would just add to that one of the reasons why this bill has been put forth in this state, as well as in other states, and now a bill introduced in Congress along the same lines as the bill that we're looking at today, is because there have been numerous instances across this country where policies have been put in place or individuals have acted in a way that effectively prohibits by the action of the individual, the parent from knowing what is going on with respect to his or her child or children in that school or in that medical care facility. This is essentially a right to know bill. And what it does is it brings together all of the rights of parents and publishes, it requires that they be distributed to parents so that parents know what their rights are. Whether they exercise them or not is a function of their understanding of their parental responsibility and how they conduct themselves as parents. However, to even begin to think that there are things going on that do not need to be addressed in legislation such as this goes against the grain of what is happening across this country.
Representative DeSimone.
Thank you, Mr. Chair, and thank you for taking my question. Isn't it true that when you spoke earlier about the possibility of a parent abusing a child when they become knowledgeable of something that happens in school, you in this amendment have addressed that on page 4, section 3, Roman numeral 3. The first lowercase parenthetical a authorizes a parent of a minor child to, in this state, to engage in contact that is unlawful or to abuse or neglect his or her minor child. You have addressed all of that, which was something that I asked for last year, and I thank you very much for addressing that. Although the abusive parents are not in numbers that good parents are, thank you God, this takes care of that. Is that correct?
It does take care of that. Actually, that clause was in the bill last year. Unfortunately, it didn't pass last year, but it was actually in there. That's a very key component to this. We want everyone to understand there's absolutely no, can't even begin to fathom condoning anyone abusing their child. And under any guise whatsoever. And so that is a key component of this law and always or this bill and always has been. You do not have the right. This is where natural rights and where government is allowed to infringe because no rights are absolute. Government has the right or the power, and the authority to then step in and say, you do not have the right to abuse your child.
Uncharacteristically for me, I will be brief in responding and adding and saying and summing and saying, under no circumstances is child abuse ever condoned under the law. There's no exemption. This bill does not provide any exemption whatsoever for holding accountable any parent who, on the basis of information allegedly received from a school official or employee or a medical practitioner, then has the right to do something that otherwise under law that parent cannot do.
I have
MODAB.
I have a question here. Is it true to say that this bill, across the board, is dealing with outliers? That is to say, abusive parents, bad acting teachers. We're not talking about all the parents. We're not talking about all or probably even many of the teachers. Are we not talking about those exception cases across the spectrum?
Yes, and in addition, what we have is a phenomenon that is occurring, that has emerged in the culture, such that there are parties who believe that they have a superior, we believe that they believe they have a superior right to be able to educate children in a way that is contrary to the way that children have been educated in the past, and contravenes the authority and undermines the authority of the parent, the primary relationship. This is a cultural phenomenon that is growing and is one of the reasons why we are seeing the veritable plethora of cases that are going to court and the bills that are being introduced in state legislatures and now in the Congress of the United States. We have a problem, yes.
Thank you. Representative Perez.
Thank you. Can you give me some examples of what is happening in the school that you feel that it need this bill to be introduced? And can you give me an examples? What states are you talking about that these issues been happening? Because when I'm making a decision, I'm listening to every single testimony with all my respect. But when you're telling me that it's happening in another state, when you're telling me that the parents have an issue, when you're telling me all this, I hear you. But I just don't just go with what you're saying. I would love to have an examples. I would love to have exactly information in front of my face that I can make the right decision. But just by going by other states and other parts of the country, it doesn't mean anything to me. I would love to see clear information, exactly where is happening, what is happening. And, I would love to see that. And to be honest, I want to know what exactly is being introduced to students that you feel like never been introduced before and is hurting the students or making the parents uncomfortable. The parents don't know what is happening in the school system. I would love to see that. That way, when I make the decision, can I have that information? Can you provide me that information? That's my question.
How many examples would you like?
As many as you can. I would love to see, because more information, more data is better for me to make my own decision.
I would agree, and I commend you for wanting to look at real life examples, and for your candor in indicating that you're not aware of many, if any, of these situations. We'd be happy to and pleased to be able to sit down with you and provide you with that information, and we will do so.
Representative Grossman.
Thank you, Mr. Chairman. One of my biggest concerns is for our trans and LGBTQ youth, and that in many situations it is life and death in terms of mental health and care for them to be living in the light. So if a student requests that their pronouns be changed and the teacher then goes to the parents, and the parents have requested to know what's going on, the school lets the parents know that their child has now requested different pronouns. That child goes home, is abused, because even if it's in law, we know that abuse happens, and it happens in dark places. It's not in the light. What does that child, student, teenager do after they've been abused by their parents because their teacher told them that they refer to different pronouns? So what's the recourse for that child, that student?
Again, there is absolutely no provision that would allow for a parent to abuse their child regardless of the circumstances. So what does the child do? You can call the police. You could tell we asked about, what about DCYF? Look, I'm being abused at home. There's mandatory reporting. So there is recourse for the child. How would they do it now? If a child is being abused for any reason, 6-year-old child wets the bed, gets abused by the parent. They go to school and the child or the teacher sees bruises on the child. Is mommy hitting you in the morning? Why is mommy, whatever that gets reported. There are already the means for this. You're singling out LGBTQ kids. It's all kids, any child that would be abused for whatever reason.
No.
And the recourse is the same. There is absolutely no excuse whatsoever for abuse, and this law would say you can't abuse your kids. And if you do abuse your kids, we have the law that says how you can be punished, and there is no cover for the parent that would abuse the child, none whatsoever. So I'm not really sure what you're trying to get at as far as what if this LGBTQ child gets abused by their parents? What if any child gets abused by their parents for any reason?
Protecting children.
Would you like a follow-up, Representative?
Just worried about protecting children and their rights.
Representative Perez.
Okay, so I'm gonna ask you a question. This is hard for me to ask this question, but I'm gonna ask it. What do you tell a child like myself? Okay, I grew up in a family where I went to a Catholic school. My dad, it was the one who was sexually abusing me. Okay, but my dad was very well-known person, and he was giving donations to the school, a Catholic school. So when my dad was pulling me from the school to abuse me, sexual assault me, and bring me back to school after he abused me, and the school stayed quiet. What do you tell a child like myself when you telling me that we are protected or the kids are protected? I wasn't protected. And that scar is on me for the rest of my life. Can you tell me, what can I tell a child like myself when you're telling me that the kids are protected?
Representative, I'm sorry for the abuse that you experienced, but you were also talking about a very extraordinary case where you were abused by your parent and then protected at the school from that abuse. That is an extraordinary case. You said that your dad gave money to the school, and whatever the collusion was between the school and your dad that would allow that to be covered up. There are cover-ups of sexual abuse in all kinds of organizations, not just schools. It's not just parents. You name the organization: Boy Scouts, Girl Scouts, public schools, private schools. You pick the organization, and you could find creeps in every single one of them. You could find bad parents. If you want to focus on just the bad parents, we could do that, but I don't think we're going to get anywhere by just trying to, what about all these different bad parents, when the focus is not on the bad parents.
Do you wish to follow up?
Yes, follow up.
Please.
Again, my question is, we're here to protect the children. If you're taking away that protection by taking away that child to be able to go back to that teacher and explain to that teacher what happened, because when that child went home, it got beat up. It got beat up really hard. And that kid is so scared to speak up because he have black and blue bruises that he has to hide. How can that child, and we're not talking about parents here only, but we're talking about teachers. But can you explain to me how we're not going to take the ability of the teachers when we're going to tell the teacher that can get in trouble if they hide some things from the parents?
Are teachers mandatory reporters?
Yes.
Teachers are required by law to report abuse. If they are not doing that, then they are in violation of the law. So who's protecting the children from the negligent teachers? And who's protecting the children from the teachers who are providing pornography to them? Who's protecting the children? We're talking about protecting the children, but who are we protecting the children from? Who are we protecting the children from? And it's always this example of all these bad parents out there when most parents aren't bad parents. So why are we hiding things from parents? Why are we undermining the relationship between the child and the parent?
Representative Petrino.
Thank you, Mr. Chairman. Thank you again for taking one of my questions. My observation is that this matter was never an issue in the past. It seems to be something that's relatively recent, and I'm trying to think of the motivation behind it. I'm thinking, and correct me if I'm wrong, that this really comes down to matters regarding the LGBTQ community. If Johnny gives Billy a Valentine's in school, mom wants to know, is this the impetus? I really want to get to the heart of the matter.
No, it is not. I'll just go ahead and answer it. No, it is not.
What then would be the assessment?
It is the things that are happening in school, regardless of the nature of what it is, the parent has the right to know. This law would not prevent kids from little Johnny giving Tommy a Valentine. It does not prevent Tommy from wearing a dress and being called Sally. It does not stop anything whatsoever. It just says the parents have the right to know what's going on in the life of their child. That's it. No, it is not motivated by the LGBTQ community. That is one aspect of it. It's one thing that's happening in the schools. You've got the closets where you can go in and change clothes, and it doesn't even stop that from happening. It just says the parents have the right to know what's going on and guide the upbringing of their own children. The parents have the right to make those education decisions. If they decide that that's not where I want my child, I want to do something else, they would have the right to then do that as well. It has nothing to do with what they can and cannot do as far as the activities go. It's anything and everything. The parents have the right to know what's going on.
Representative Gregg.
Thank you, Mr. Chairman, and thank you for taking my question. I appreciate you being here to support your bill. As someone who has great insight into what happens in abusive situations, and this is kind of a two-part question, is that okay? So, would it surprise you to know that some kids who are in abusive situations actually don't know it's abuse because it's the only reality they know?
It doesn't surprise me at all.
So would it also, gosh, it's so hard to word and just keep it down to one question. I apologize. Parents who have, you want to talk about the good parents, right? Because obviously there's a lot of talk about abusive parents. Why is it that a good parent doesn't already have communication with their child, open communication where the child is talking to them about all of these things, if we're talking about good parents being able to parent?
I had a wonderful relationship with my parents, and I didn't tell them much of anything that was going on in my life. Adolescence is a very weird experience. Girls are different than boys, I'm pretty sure anyway. We all experience different things in our lives, but I can promise you this, there are things that my parents still don't know to this day. There are kids, having a good relationship with your parent and telling them everything is two completely different things. Yeah.
Once again, there's absolutely no protection whatsoever for abuse by anybody in any venue under any circumstance. And when someone becomes aware of abuse, just like if you go to the hospital, and I had a situation a number of years ago where my son had a very adverse reaction to poison ivy. Well, immediately, the medical personnel were questioning my wife and me as to whether we beat him with a rod on his heels, because they had to do their due diligence. By the way, let me assure all of you that we were cleared rather quickly, and we were not charged with abusing our son because he caught poison ivy on his heels. But these are real life examples here, and real people who, when they become aware of abuse, they are required. Clergy are required. Lawyers are required. Teachers are required. Everybody is required. If they see something, they have to say something. And there are child protective services in all of our states, and all students have access to that. You know, you can lead a horse to water, but you can't make him drink. but you can encourage a child. If a child, and part of the educational experience for children can be, if something is happening in your home that is not good, that doesn't make you feel good, then tell me about it. And if told about it, then the teacher has a responsibility to act upon that. Now, but the main focus of this bill is a parent's right to know what is going on in a classroom or with a healthcare practitioner. That right is a natural, fundamental, primary right that has been established in natural law and also in judicial law. The Supreme Court has ruled on many occasions, and circuit courts of appeal, that the parents are the primary caretakers of their children and will direct their upbringing, and they cannot be impeded in that upbringing unless there is something nefarious that's going on, in which case there are remedies that are prescribed in law.
Do you wish to follow up, Representative
I
Gray?
do, please. Thank you. So you said something about the child being able to tell the teacher if something's happening or whatever. What's to make them feel confident that that's going to be secret if they know that anything else that they tell their parents or tell is going to go directly back to the parents? How does that keep kids safe and feeling confident in talking to the teacher?
Well, I think the question that I hear you asking is, what makes a child feel, would make a child feel safe and confident to be able to confide in abuse that is taking place in the home, to confide in the teacher that abuse is taking place in the home and that nothing will be done about it? No, the point here is that something must be done about it and will be done about it. If the teacher doesn't do that, then the teacher has failed.
You want to rephrase it?
Yes. So if we pass this bill, and it's, say the kid has something weird happen where they want to change their middle name to Shark, and maybe they're being abused at home. So maybe it's like their dad's, name that they don't want to identify with anymore. So they tell the teacher that, but the parent says, "Did my kiddo change their middle name?" And he says, "Yes." Well, then they get in trouble at home. What confidence does that child have that they can say, "Hey, you know what? My teacher my dad beat me when I got home because I changed my name." What confidence do they have to be able to go find safety at school? Because a lot of homes are not safe, I hate to say.
Go ahead.
At that point, okay, first of all, the teacher does not know that the child is going to get beat. The child may suspect that he will get beat. The child has told the teacher, "I want to change my middle name," for whatever reason. But the child has not yet told the teacher, "I might get beat for this." You are asking about what to do after the fact. If the child wants to be called by some other name, if the parent asks, the teacher would be obligated to tell the parent, not lie to the parent. The problem is if the child is then beaten by the parents and the child says, "I just got beaten because I changed." Now the teacher has to act. Why would the student now trust the teacher? Because the teacher then acted on their responsibility. The teacher's not going to know. What's going to make the child feel safe? They told the teacher that I got beaten by my dad because I changed my name. Now the teacher acts in accordance with the law as the teacher's supposed to act. Now the child trusts the teacher because the teacher has now protected them from the abuse. That's the proper response. But otherwise, child wants to change their name to something else. Parent asks, "Is my child going by some other name?" The teacher says yes. That's it.
Representative, my follow-up question to this very specific question is, over the 50 years I've done a fair bit of counseling, I've discovered the danger in families of too many secrets.
Yep.
And I have seen so many families where the parents did not learn it from the child. The parents learned it from a neighbor whose child told the neighbor, whose neighbor told the parents, and the anger in the family was not so much the action, but the duplicity the skulking about, the secrecies, and so on. And I knew growing up that if I did something downtown, it didn't have to be my teacher. It was a generic teacher in that city. My parents would know before I got home. And that kind of, this is not in any way making light of the all too real situations where there are abusive parents.
That's correct.
I am just saying that it doesn't solve the problem
Right.
if the child changes the name at school.
Right.
Except now the parent distrusts the teacher and looks on the neighbor's child as the rat. So, and I think that started off as a question. Is that within the framework of what you're saying here?
Are we asking kids to rat out their neighbors?
No. No, we are suggesting the possibility that if the teacher does not report something and the neighbor's child does, that now the parents have another reason to distrust the teacher who's supposed to be working in tandem with the parents. That's what I'm asking.
If the teacher does not report abuse, then the teacher would be in violation of the law.
Representative Nelson.
I don't even remember what I was going to ask. I'm sorry.
Representative Raymond, while Representative Nelson remembers.
Thank you, Mr. Chairman. I want to get back to understanding the language of the bill and kind of away from hypothetical situations. So there are a couple of areas where I am still seeking understanding. The first one is page 1, line 7. It talks about that information about a child shouldn't be purposefully withheld from their parents, et cetera, while the child is in the custody of the school district. It's a really weird phrase, and I'm curious if you mean while the child is attending school, and also whether this only applies to public school districts, or if this will also apply to charter schools and private schools.
Well, thank you for the question. It is a good question, actually,
Yeah,
because
my questions aren't bad.
Yeah.
She's pretty good for first year.
There is a concept of what's called in loco parentis. And this deals, so in here is the concept of in loco parentis. This is actually down on same page, Roman numeral 3, line 20. Notwithstanding a compelling state reason, the concept of in loco parentis and any interpretation and application thereof shall not infringe upon the natural and statutory rights of parents as recognized in existing law or by adoption of this statute. So this goes back up. This relates to the concept of in loco parentis. So a school acts as a representative of the parents. They're given authority and responsibility to take care of the kids, to educate the kids, in lieu of the parents or in place of the parents.
So what I'm really getting at with the question, though, is by saying in the custody of the school district, is this legally, is this going to be interpreted as public school districts, or does it cover private schools, boarding schools, charter schools?
This should cover schools, everyone.
Because I notice all the other places, it just says schools, which was helpful.
Yes, if you would need to remove the district from there,
Or just the phrase is freaking me out. Okay. And then
it's a custody. The children are at the school. They're actually compelled to be at school by the law, and so that is they are in the temporary, if you will, custody of the school. They have responsibility of the child for that period of time, and so while they are there, parents don't lose their rights because the child is not in their physical presence under their direct supervision. They're at the school.
Okay.
And so this does apply to all schools, but that custody relates to in loco parentis.
Okay.
And,
It's all schools.
and in addition, with respect to in loco parentis, the whole concept of in loco parentis implies that there is a de facto trust relationship that exists between the parents and the school, or the parents and the healthcare provider, such that the parents need to be knowledgeable of what it is that they have entrusted, or the medical practitioner. The parents need to know what they have entrusted their children to that school and school personnel, teachers, educators, healthcare providers. They need to understand and have delineated what in fact that is. And part of that goes to curriculum, of course,
Right.
and we have laws that speak to that. But in loco parentis means there is an implied trust relationship between the parents and the school.
That's fair. Yes.
And therefore the school officials are subsidiary to and should be supportive of the parents rather than to assume a complementary role or one that is that asserts that they have the same kind of authority that parents do. And that's part of the issue that's in play here in the Manchester case, which, as I understand, is on appeal.
Okay. Yeah, I would love to read up on that case. So on,
Like a follow-up.
I would. I have two other areas of language questions, and then I'm done. That was it. So just if you can bear
Well,
with me.
actually, you're done when I say you're done, but please continue.
Thank you. All right. On page
Too many
3
of us have watched C-SPAN and we think we're in Congress.
All right. On page 3, line 26, it says, item T, the right to consent in writing before a record of their minor child's blood or DNA is created, stored, or shared, etc. This is not anywhere else in the law, and I'm curious as to the genesis of this and how it will affect secondary science classes who occasionally do blood typing or, they do the gel electrophoresis with DNA. You don't really learn anything except what DNA looks like.
This does not interfere with the education process. A science class that would do blood typing, we did that as well.
Yeah.
I don't even think we had DNA back when I was in elementary school. That's a new phenomenon.
It's pretty fun, actually.
But the idea is that this the keeping of a DNA record. This is all about your child's information being kept by someone somewhere for some reason, and the parents would have the right to know who's collecting the data. This is not science class. This is somebody collecting data on your child.
Okay. And then the last one is on page 6, number 5, Article 7. When you're talking about consequences for violating the law. So it says in there that if you're found guilty knowingly violating any section of the law, et cetera, et cetera. So my question is, what is the vehicle by which this would be tried? Is it through an Office of Civil Rights complaint? Is it through the Department of Education? Is it police are arresting people and then it's going through the criminal court process? Like, who's making that determination? And what are the standards of evidence that will then be required?
Going back to the first point is that it would be a court of competent jurisdiction. It starts out as a civil action. That's step 1. Actually, step 1 would be a complaint.
Right. I mean, one would expect that a parent would call up the principal and say, I have a complaint, go through the normal public complaint process.
So we've gotten no satisfaction whatsoever. Step 1 is a civil action. If the teacher continues down that, it becomes a criminal action. So it would be the parent would have the right to file a complaint. This would be tried in a court of law because it's a violation of a civil right.
So does this parent have to potentially hire an attorney and file their own civil complaint? Do they go to the Department of Education? Like, how do they? Because right now there's a system, right? You appeal.
Representative, you're going on way too far.
Sorry, I'm just.
Leave the question and let them ask it, please.
All right.
Answer it, excuse me.
It is a legal process. The burden of filing the complaint is on the parent. If they believe that their rights have been violated, then they file the complaint on that. Then there'd be a trial. There'd be what evidence would be necessary to convict for a Class A misdemeanor. That's what the judges are to decide.
Thank you. Any other questions from anyone else who hasn't asked? Gets first dibs. Representative Ball.
Thank you, Chairman Pearson, and thank you for taking my question. I worked in a middle school as the emotional behavioral specialist which provided me a lot of opportunity to work with parents of children who were having difficulties, whether it was emotionally or oftentimes behaviorally. Would you agree that actually including the parent in those meetings that we had to address the children's behavior or social emotional components actually allowed the child to feel safer at home, because we now, I wrote it down, we now had an avenue to provide help for the parents and education, which in special education, we must educate the parents on the child's disability. I'm not saying that this is disability, but it does provide that opportunity to educate the parent. And it also puts the parent on notice that we know the child is going home with something that may not make the parent happy. And we made sure the parent knew we would be checking in with the child frequently to be sure they continued to feel safe at home.
Absolutely.
So you agree with that?
Absolutely.
And may
Would
I
you
have-
like another go?
Yes, sir.
One more
Thank
go.
you.
Okay.
What concerns me is that we've heard testimonies saying that the trans children tended to be more like, I think that was very high, 19% more likely to commit suicide. And so what concerns me is would you agree that if we don't include the parents in on this conversation, aren't we putting the child at more risk at home to lead a double life and not be allowed to share this with the parent and get the help they need as a family unit?
Absolutely. Absolutely. It goes back to the keeping of secrets. A young man who's a friend of my family, my son, one of my sons, we did not find out, or his parents didn't find out until he was 25 years old, that he had been molested by a man in his church. And it happened when he was 9 years old. Kept it a secret. It wound up destroying him so that he did not succeed at committing suicide. When secrets are kept, families and individual lives are destroyed. Schools should be fostering a communication between the children and the parents. If they're mediators to facilitate that conversation, God bless them for being that mediator, that referee during those awkward adolescent years, whatever the case, regardless of the situation. Someone's being bullied at school. Somebody who's coming out of the closet, or whatever this, it doesn't matter what the situation is. Parents the schools can provide an incredible resource to provide that relationship between the parents and the children. I think it's essential.
Thank you.
Representative Nelson.
Going back to page 4, thank you, Mr. Chairman, and thank you for taking my question. On page 4, going back to lines 4 through 8, isn't it true that the representative of the school isn't bound to freely share the information once received, but actually would only be required to share information if the parent asks, inquires?
Yes, and that's a very important point. The parent has the burden is placed on the parent to ask for the information. The school is then obligated to not lie to the parents and actually provide correct information, adequate information. So it's upon inquiry that the parent receives the information.
It is only required on the school when it's a mandatory reporting situation.
Correct.
Otherwise not.
Correct, as detailed in the law. Correct.
Yeah, just clarifying.
Yes.
I have a follow-up, Mr. Chairman, if
Okay.
you don't mind. Thank you, Mr. Chairman. Thank you for taking my follow-up. And my follow-up would be, this inquiry would be at the time asked. So it wouldn't be like a standing order inquiry where the parent would be allowed to say, I'm inquiring and this inquiry lasts the entire school year.
Hadn't really thought about a standing order. I've been out of the Navy for 10 years now. So, no, it is upon inquiry. It's not a standing order. If my son ever changes his pronouns, you will tell me. No, it's the constant communication.
Thank you. Appreciate it.
Thank you for your testimony, except for Representative Longs.
Thank you, Mr. Chairman.
Welcome.
I'm just trying to get the need of this. As a parent, I never depended on my children to give me any information. They weren't going to do that. It was my job to know my child. My job to know my child. If there's something I didn't know about my child, I'm not sitting down and having a conversation with my child enough. So I'm glad you answered the question. I had the same question with respect to the school district, meaning just the public schools. You're saying no. Then when you look at page 6, on 9 and 11, $2,500 be restricted from any further access to all schools in the district. So if I'm at St. Paul's School in Concord and I'm a teacher that violated, I get a $2,500 fine. I cannot teach in Concord for a year?
Actually, that $2,500 fine is for a contractor or third party employed by the school that violates the section.
Yes.
Okay. Okay. So has it?
That'd be like the custodian or
Okay, so-
an outside vendor that comes
Yep.
in and makes a presentation.
Okay, so I'm a custodian at St. Paul's and I'm violating this. I can't be a custodian in any school in Concord district?
Is St. Paul's in Concord?
Correct.
Okay. Yes.
Okay, but I could go to Manchester and be a custodian. But,
You could apply.
well, I can according to
You
law.
could apply. You're not prohibited by the language in this particular in these sentences.
Okay.
You could apply, and assuming you have honest references, that district would have to determine whether or not it opted to employ you, whereas the other district could not for 1 year. Yes, that's correct.
Okay, so the other district, if I could follow up, the other district that I'm applying for, this doesn't prohibit them from hiring me. This bill doesn't. So it would be an unfair labor. I don't know if it'd be unfair labor practice, but it would be unfair labor law that they would refuse to hire me because of the incident I had at St. Paul's. Because where does the law state that they can't hire me? Right?
Well, if you believe that if your reasoning is correct here, and I'm not challenging it, but if your reason bears out as being correct, then you would want to make some sort of a change here, because you don't want to have an unfair labor practice in the law, right?
Okay.
So either going to take it out entirely, or what you're going to do is you're going to make it applicable in every school district throughout the state. So it's either for everybody or for nobody.
Okay.
Yes,
No, I'm glad
I think
to hear
that's a good
Okay,
observation.
no, I'm glad to
We
hear
appreciate
that.
that. Thank you.
So just one more question, if I may.
Which
The all the laws that are here, federal or statutory laws, are there remedies already? So my teacher didn't tell me that my son has joined a rugby club that I told him I didn't want him to be in the rugby class. The rugby. I didn't want him playing rugby. So they didn't tell me. So do I have remedies now that it's statute?
I've not found any remedies where if the teacher allows or the school allows your child to participate in an activity, joins the rugby club against your permission or without your permission or without your knowledge, I've not found where there is any remedy today.
and then you inquire, and then you're told, and then you say, I don't want my child participating in the chess club or rugby or whatever. I'm not aware of there being any sanction for that at this time. So the answer is no, I don't. We don't know.
Okay, thank you.
Representative Bickford.
Thank you, Mr. Chairman. Thank you for taking my question. What about police or SROs? Can I go up to them and say, I want to know what my children are up to? SROs are the school
Right.
resource officer. Can I expect them to report about my children as well as teachers, et cetera? Because they're gathering all kinds of information on students. That's their job, actually. You know, it's always nice to know about the party too, that's gonna happen before it happens.
You'll get an invite next time, sir.
We do not specifically, they are employees, but some of them may be employees, some of them may be third party because they may be not actually part of the school or they might be a police department, an actual police officer of, say, Concord Police Department. I don't know. Each school may be different. But if they are, we do not specify that SROs that the parent could go and inquire at the school resource officer.
Huh, okay.
I
Concerns me.
Well, I think the question is, what is the chain of accountability here with respect to the employment of the school resource officer? Is the school resource officer an employee of the school, or is the school resource officer an employee of the local police department? In which case, that would then give us an indication of where we need to raise some further questions, particularly if it's the police department.
In my school district, if I may, the school pays for the police officer during the school hours. It's on the warrant right now.
Okay.
But that's a resource. Talk about, you know, we want information. That's their job, is to gather information. And I'm saying, you know, maybe it's a good idea parents know what's going on. That's the place you really ought to know.
The parents have the right to the information. That's what we're getting at, is the parents have the right to make the inquiry and obtain the information.
Well, do we have a confidential issue going on here? A confidential issue with
What's
juvenile?
the confidentiality?
They haven't committed a crime, but they gather information about, you know, sexting and that sort of thing. But the parents aren't, I'm not sure if they're getting the information about it. I was
Well, once again, the only way that they would be able to gain such information would be to make an inquiry of the school resource officer, because the school resource officer is not required to contact the parents and tell the parents under the provisions of this proposed legislation. Now, the school resource officer, it may be a policy of the school, it may be a policy in the community that the school resource officer is obligated to do that, but that's separate from what is encompassed within this bill.
Yeah, right, okay.
Okay.
I'm disappointed.
As we currently understand it. Well, we thought it was perfect, but maybe it's not quite there yet, and maybe you could help to perfect it.
Yeah.
Thank you. Seriously.
Thank you so much for coming up here, Representative. Would you like your presentation?
Yes, and I'm going to truncate this out of mercy for the members of the public as behind me and
Just
and
for the
fellow
information of
representatives.
the public, if everyone who signed a pink card
Yes.
speaks for 10 minutes, it is 10 hours we will be here.
Yeah.
You're not going to testify for 10 minutes. You're going to testify for 2 because we are kind to you. So if you had a long testimony, this is the good time to boil it down to 2 minutes. The last hearing demonstrated it could be done. Go.
So thank you. Thank you, colleagues, for the opportunity. I'm pleased to once again be able to speak in support of HB 10, this year's version of the Parents' Rights Bill, the version that I sponsored last year along with Jeff as a co-sponsor. Almost made it. We hope that it will be sufficiently acceptable to representatives such that it can pass this year. Remembering that no piece of legislation is perfect, and if it needs to be tweaked, as the saying goes, in the future, of course, we're more than willing for that to be supportive of those suggestions. I believe we're in the throes of a great philosophical and political struggle that goes to the heart of the question of the proper role and place of educators and healthcare providers for minor children in relationship to the children whose parents have entrusted to them for their educations in healthcare, including the scope of both the educators and the healthcare professionals. What we know is that the judicial record is clear. A child, according to the Fourth Circuit Court of Appeals, and their decision was not appealed to the Supreme Court, therefore their ruling in this opinion stands, is, quote, not the mere creature of the state, close quote. Now, this is an important assertion or recognition and assertion in my view. And the reason for that is because we have actually had countries in the 20th century that we can look back upon who asserted that children were actually the property of the state. Maybe most of you are so young you do not remember the Soviet Union, but that was the case in Bolshevik and Stalinist Soviet Union. We take a different view here in this country, and we're clear that a child is, quote, not the mere creature of the state. That decision was Troxel versus Granville in the year 2000. Further, the court ruled and declared, quote, it is difficult to envision why a school would even claim, much less how a school could establish, a generalized interest in withholding or concealing from the parents of minor children information fundamental to a child's identity, personhood, and mental and emotional well-being, such as their preferred name and pronouns. Close quote. I didn't even know that we were discussing such things in 2000. I was too busy parenting, I guess. So therefore, absent any established compelling state interest, the right of parents to determine the educations and health care of their children is primary. Inherent in such a recognition is a tenet that parents have a right to know what their children are being taught and how they're being treated by ones who stand in a de facto and professionally determined relationship of trustee of parents and to whom they are therefore accountable. I believe that the greatest point of tension in our time is the teaching of children by school personnel that their gender identity is fluid and a matter of choice. But more is the assertion that the teaching of these precepts is protected against parental inquiry. They're being claimed by many that a parent has no right to know. What this amounts to is an assertion of a right that has no basis in law or nature, and that effectively challenges the primary role of a parent to direct the upbringing and care of children. In one sense, HB 10 is a corrective to this departure from law and historic practice, but in another and even just as more important sense, and I want to underscore this, because it's a perspective that only was begun to be scratched at here a little while ago. HB 10 provides for greater clarity in the proper role of educators and healthcare providers with regard to their relationship with both parents and children. While in one sense it may be seen as a corrective, in a larger sense it serves the purpose of advancing the people's will to better define and encourage greater trust between schools and their personnel, healthcare providers, parents, and their children. HB 10 recognizes that parents and guardians have multiple statutory rights to direct the education and care of their minor children. Regrettably, not all parents, children, and school personnel are aware of these statutory rights. What HB 10 accomplishes is the bringing together in one place, so to speak, an enumeration of these rights, establishes a handful of new ones, WXY, and requires that all affected parties be made aware of what they are. We have a right, we have a responsibility to inform parents what their rights are and what their responsibilities are. In my life and career, I devoted a great deal of time to help people know what they did not know and to encourage them to live into the knowledge and practice of those things that would raise their quality of life and enhance their relationships with others. And this is how I see HB 10, not as a weapon, but as a tool for parents and educators and healthcare practitioners to more effectively work together to care for children to which each respectively and specifically have been entrusted. Parents are at the center, yes, and they are the primary decision makers, yes. Professional educators and healthcare providers are resource persons. They're helpers. Clarifying and securing these roles and relationships is in view in HB 10, and so I urge that you consider it favorably and move it forward for the betterment of everyone here in the state of New Hampshire. Thank you.
Thank you, Representative. Before we move on to testimony, I have about 2 minutes for the committee. Next Tuesday is town meeting day. And the note came from our committee assistant, would we be interested, therefore, in changing the day of our meeting next week to Wednesday? The chairman of judiciary, who normally gets this room on Wednesdays, will not be needing it next Wednesday, so we could meet here and not at Store's Garage. But it's just, are you thinking this is a good idea? I can be here either day. Are you interested in Tuesday next week? Town meeting day will affect some of you, or Wednesday? You're good. You look good. You look very good. Yeah, but that's not what you meant, is it? No. Okay. How many, and you can vote twice here. How many would like Tuesday? Well, I can do Tuesday. That's pretty much everybody except a couple. How many would like Wednesday? Looks like Tuesday has it. Sorry. Now, as I said, I put my watch away and instead I have a calendar. And that was a laugh line. And if I hold up the cards on one side and the cards on another side, 10 minutes equals 10 hours. I did the math. So we're going into a 2-minute rule. We do that so those of you who have been patiently waiting and will be long patiently waiting will not be here at 10 o'clock tonight. Or you'll have invested a whole day and you never testified because you had to go home at 9. So I'm asking my vice chair, who has abilities on his phone to do countdowns, and at 1:45 he can wave something or say 1:45 to let you know it is time to wrap it up. And you're not going to be punished by me shutting off your mic, but I will do that if you go much longer. So with that in mind, I'm going to take people from both stacks, call 2 names, and so if somebody's in the other room, you've got a few minutes, actually 2, to walk down here. First up is Representative Sean from Cheshire District 7. And pronounce your last name for me, please. Filio, okay, of course, yeah. And Sarah Smith is in the on-deck circle. Is Sarah here? If she's in the other rooms, she can wander down. So thank you, Representative.
Thank you, Mr. Chairman, and thank you, members of the committee. I will be amending the testimony that I had planned today for the interests of parsimony. A little bit about my background. I have a law degree and worked for the Massachusetts Attorney General's Office in the Civil Rights Division. I also hold a PhD in health promotion and was a tenured faculty member at Flinders University in South Australia, and have published over 24 peer-reviewed articles in the areas of human sexuality and health promotion. I come today to give you a brief tour of the academic literature in the areas of LGBTQ mental health, a little bit more brief than what I had initially planned. The academic literature is unequivocal. According to data from the U.S. Surgeon General, as a whole, LGBTQ youth are 6 times more likely to commit suicide as are their straight peers, and some estimates put that as 20 times more likely. That statistic remains true when we control for factors like race, socioeconomic status, and other potentially confounding variables. Why is it that LGBTQ youth are substantially more likely to commit suicide? It's that we live in a culture that is tremendously hostile towards LGBTQ people. You don't need to look any further than the nightly news to confirm that fact.
Representative, you have about a minute left, so steer it back into the bill, please.
Unfortunately, LGBTQ youths oftentimes have a negative experience coming out. The title of a 2016 academic article aptly sums it up. Family support would have been, amazing. Indeed, recent academic research demonstrates that the median experience of coming out to family is negative or hostile. But I know that sometimes as a legislator, hearing research falls on deaf ears. So listen to my experience of working on the Trevor Project, which is an LGBTQ suicide hotline. A youth called in with gun in hand after he had been outed to his mother against his will.
You now have 20 seconds, sir.
This youth said that his mother told him that she no longer loved him, that he was an abomination before God, and that she wanted him out of the house. I spoke to him for over an hour, and we talked about ways to deal with stress and how he could talk to his mother again. And then the chat went silent. I tried to contact him to see if he was there, but he wasn't. I don't know what happened to him, and perhaps I never will. How many chats like that will it take for you to find this bill inexpedient to legislate?
I now call Sarah Smith, if she's in the room. There she is. And in the on-deck circle is Representative Sellers from Grafton, District 18. Please, please turn on your mic. You got to hit the button on the bottom and it turns red at the top. That bottom, yeah.
Thank you. My name is Sarah Smith, and I live in Pembroke, New Hampshire. I'm a retired teacher, and I'll be short. I had just a couple things I wanted to say about this. If I was morally faced with a situation where I was talking to somebody who and they were telling me about their pronouns, for instance, and I knew that I had to report them to their parents for that, and at the same time they were also telling me, don't tell my parents, they'll kill me, which is how a kid would speak. Maybe they literally would kill them, but you're saying you're putting me in the situation where I would have to report that, knowing that they would be harmed. And I find that morally reprehensible, that I would be put in a position of putting someone in the way of harm. That's my objection to this bill. And but if you had to have a bill like this, I did find an area that you could fix. And that is that you've left out the idea of, you mentioned military recruiters, but you failed to mention ROTC. And in some states, kids are put into ROTC without their parents' permission. That should be included too. Are there any questions? Thank you.
Thank you very much. The chair next recognizes Representative Sellers from Grafton District 18 to come up, and in the on-deck circle, flown in at great expense, is Emma Gregg.
Thank you, Mr. Chairman. Thank you, committee members, for hearing my testimony. I just wanted, as I was sitting here, I was just taking notes. I don't really have anything prepared to say. I just wanted to say a few statements and let you know a few things here. One thing I noticed that, a child goes to school for about 12 years. All right. During that time, it's about 12,960 hours of the child's life, 6 hours a day, 180 days a year. During that same 12 years, or at that point, they're 18 years old. So during that time there, they have actually, lived 156,780 hours. So basically, the school has the child for 8.2% of their life during the entire 12 years. It comes back that the parental rights here is the parents. And then at that point here, it's the, we have to come back and say, is it the, and I don't want to use the word ownership because it's not the right word, but does the government, does the school own the child, or is the child the property and the upbringing of the parent, or the parents? And I think we're getting things confused there, and things are getting backwards. And another thing I wanted to bring up is, we see out there, it says, you see something, say something. But when it comes to schools and parents, you hear something, you don't say anything. It doesn't make sense. So some of these things, we're trying to protect the parents so the parents have that choice of knowing if something's going on with their child. And I think that is important, that the parent needs the right to know, and you need to be protecting the parent, not the government. Thank you.
Thank you, Representative. Next up is Emma Gregg, and in the on-deck circle is Aubrey Friedman. Do we have an Aubrey Friedman? Right in front of me.
Hi, can you guys hear me clearly?
Mm-hmm.
Okay. Good afternoon, Mr. Chairman and committee. Thank you for your time. My name is Emma Gregg. I'm 16 years old, a sophomore in high school, and I'm a survivor of domestic violence. I am here to ask you to vote against HB 10. As a survivor, I know the importance of being able to have trusted teachers and faculty at schools. While some parents are good and trustworthy, I know firsthand the damage a parent can inflict. According to the National Children's Alliance, in 2020, 618,000 children were victims of abuse and neglect. 77% of those cases were abused by a parent. As many as 10 million children witness violence between their parents or caregivers each year. Growing up in my household, we hid a secret, one that included holes in the walls, bruises, constant yelling, and threats. My biological thought that we were his property, that he could own everything about us and what we did. We were told what happened at home was family business. Then one day, he was taken out of our house. As we started to figure out that this wasn't how everybody lived, we became more scared of my dad and what he might do. My mom had me and my siblings pick a teacher that we trusted at school that we could talk to. I picked the school counselor and my 4th grade teacher. When I was having hard and scary days, I knew I could talk to them. Some things I didn't care if my mom knew about, and other things I wasn't ready to talk to her about. I was confused and working through a lot of emotions. At home, there was still a feeling of being scared about what might happen. I didn't want my dad to know any of it. He had been very violent, and I knew that he would hurt us. After knocking out and strangling my brother while he was in our house, my dad told us that if we told anyone, he would finish the job. If a bill like HB 10 was in place at that time, I can't imagine I would be able to be sitting here today to testify. My mom has always made sure that we know that this journey in our survival is our own, that we get to make choices on how we deal with this. She also empowers us to ask teachers and get different perspectives because even adults can make mistakes. Teachers and counselors are required to go to school and get degrees to teach and advise kids, but anyone can be a parent with no degree or classes required. Without the ability to be able to talk through some very confusing times with my teacher and knowing that I was protected, my journey in surviving would be very different and not as successful. I have many friends who have trusted conversations with teachers because they are scared of their parents. We need to be empowered to figure things out without retribution from abusive and violent parents. Even though not every house was like mine, many are, and you can't tell the difference. On behalf of my friends and other students, I ask you to understand the damage a bill like this can do. Please vote against HB 10. Thank you.
Thank you, Emma. Chair now recognizes Aubrey Friedman with Brian Harlow. Is Brian Harlow around for the on-deck circle? Anyway, go ahead.
Aubrey Friedman, Bridgewater. I speak in support of this bill. There's a few things I don't like about it, but it's definitely a step in the right direction. I think it doesn't. The thing that people freak out about is this changing the names and the pronoun thing at school. The thing, I think more people these days are accepting of if you're gay, or I know people will dispute that, but I think it's more accepted these days, gay, bisexual, whatever. But if the kid goes to school and they want to change their pronouns and do all that stuff, that's where people freak out. And that to me goes beyond the line, and that's where parents have to know. So people also say, well, this will force teachers to out the kids. And that's not true. If a kid confides to a teacher or a counselor or whoever at school that they're gay or bisexual or transgender, I don't see anything in this bill that requires the teacher to tell the parents. And they really shouldn't. You know, it's a confidential thing. But if they go over the line, they go, no, we're going to change I'm now a different gender and you got to have a different name. That goes over the line. That's crazy as far as I'm concerned. And this bill, I know in SAU 4, we have pushed the administration on this, and they say the policy is that we will encourage the kids to tell their parents, but we will not tell the parents themselves. And we're talking about changing the name and the pronoun and all that stuff at school. That's crazy. So I think that parents need to be informed of that, but there's no reason, nothing in this bill that would force a teacher to be like an informant or, inform on the kids. So I think there's a lot of emotionalism there, and it's just not in the bill that I can see. And also,
Thank you very much. You have hit the 2-minute mark.
thank you.
Chair recognizes Brian Harley, Representative J.R. Hole in the on-deck circle.
Can you hear me? Okay. Mr. Chairman and the committee, thank you for providing me with this opportunity. The sponsors of HB 10 wonder why the LGBTQ community seems concerned. I'd just like to say children are well aware if they're loved at home. Children are also inherently aware if their home is safe. Safe as in safe to divulge I'm queer, gay, trans, bi, non-binary, what have you. Safe as in safe for mom to know dad, grandma, uncle, what have you, is abusing me and will take action to protect me. Or dad to know I'm being abused by my other dad, whatever it may be. This bill will put some kids at risk. All kids? No, of course not. But I guarantee more than we can imagine. Mark my words, not all priests abuse, not all coaches abuse, not all scout leaders at all abuse. But trans kids do get kicked out of their homes for having the courage to live authentically. LGBTQ kids do have the gay beat out of them by some parents, not all, when they find out. Am I talking about all parents? Of course not, but it does happen. I volunteered in Cambridge with Bagley, which is a nonprofit working with LGBTQ kids who find themselves on the streets, homeless. I didn't learn what I'm telling you now from Twitter or from the guy next to me. I heard their stories. They were heartbreaking. I'm not looking for your provisions to protect kids. I'm looking for you to vote inexpedient to legislate, which will, in my opinion, protect those kids. I have one question which I know can't be answered now, but just rhetorically, and okay, real quick. The sponsors keep hammering home this doesn't greenlight abuse. In crafting HB 10, did the sponsors contact the New Hampshire Coalition Against Domestic and Sexual Violence or any of the 12 crisis centers in our state to read and look at the problematic aspects? If so, please share that view, and if not, why not seek expert guidance? Thank you for listening, and
Thank you very much,
please
sir.
vote ITL.
Chair recognizes Representative J.R. Hole with Early Perez in the on-deck circle. Is Early here?
Thank you, Chairman. Representative Hole, serving the District of Merrimack 27, here in support of HB 10 as filed. I think everybody in this room shares the view that children are important and we should do whatever we can within our power to protect them. That's clear. How we may go about it might differ, but we all have a common goal to make sure children, typically in their home environment, if at all possible, are provided for, are protected, are supported, are loved, are cherished, and are raised to be responsible adults. We also know that not every family is perfect. I wish that was the case. You need a license to drive a car, but not be a dad. Not that I'm arguing for licenses for either, but my point there is, right, it's easier to be a parent in some cases than it would be to learn how to drive something as simple as a car that most adults do. I also want everybody to realize that when the state gets involved with a family, okay, No matter what their goal is, there will be harm that happens. The goal when the state gets involved is to minimize the harm to the child, meaning the state's involvement and the harm that comes from that is less than the harm that the child is experiencing at that present time. In the ideal world, that would be 100% of the time. And unfortunately, sometimes that isn't the case. I think putting a bill forward to make it clear relative to the best interest of the child, thank you, that when the state gets involved, their goal should be to support the child at the best interest. And sometimes that means not getting involved. With that, I'll close my testimony and ask that you pass this as filed. Thank you.
Thank you, Representative. Chair recognizes Erely Perez, and in the on-deck circle is Derek Burnt. Do we have Derek Burnt anywhere? Just wave. Thank you, Derek Burnt, for waving. Erely Perez, come on up.
My name is Katie Masters. I am from Lilton. I am reading on behalf of Erica Perez from the New Hampshire Youth Movement.
Got it. Thank you.
Good afternoon, members of the committee. I am from Manchester, and today I will be speaking in opposition to HB 10. My biggest issue with the bill is the punishment put in place for teachers. For a first-time offense, credentials are to be suspended for a year. Do we really think that a bill that is written to be so vague that this is a practical repercussion? We are trying to get more teachers to quit at a time when we need teachers the most. Teachers are often part of a safe space for students. This bill would fine any teacher who encourages or coerces or attempts to encourage or coerce a minor child to withhold information from his or her parent as breaking the law. I don't think that educators would be purposefully encourage any student to withhold information from a parent, but what if the parent isn't providing a safe space for their child? I come from a Catholic household myself. My mom, despite being generally accepted of other people, always made comments about how she would never want me to be gay. I was out as a bisexual at school, and some teachers were aware of that. Had I been out at home at that age, it would have put me in an uncomfortable situation with my parents. I wasn't ready to have that hard conversation yet because I didn't know what the outcome of that conversation would be. Would I be accepted or put down? Would my housing be at risk? These are hard questions, but they're even harder at 17. Even now at 24, I can't get myself to tell my family that I'm non-binary because I'm scared of how damaging that information could be to our relationship. This bill also mentions a guarantee for a parent to opt his or her minor child out of any portion of the school district's health education program that relates to sex education instruction and acquired immune deficiency syndrome education.
You have 15 seconds to
Or any
finish.
institution regarding sexuality. My question is why? Why would we take away a student's decision to learn about those things in an educational setting where they can ask questions and be prepared to make good decisions about their health?
Thank you for your testimony. And would you please fill out a pink card with your name on it for the record indicating whose testimony you read? Thank you. And next up is, I read it as Durl Burnt with Elaine Plant up behind next. Okay, is Elaine here? Put your hand up if you are. That'll do. Thank you.
Hi, I'm here to testify in opposition to HB 10. As a child, my parents made it their goal to opt me out of every form of sex education that wasn't abstinence only, and they made it their goal to convince me to be as homophobic and transphobic as possible. I'd like to summarize for you the impact that this did and did not have in my life. It didn't prevent me from realizing I'm trans. It didn't prevent me from learning about sex and sexuality, and it didn't stop me from falling in love with a trans person, who's now my life partner. Here's what it did do, though. It caused me to lose years of friendship with my high school best friend who came out before I had moved away from the harmful beliefs that my parents gave me. It caused me to seek out sexual information from unreliable and dangerous sources. And it stunted my knowledge of basic sexual health in such a way that my intimacy and trust in marriage was, and in smaller ways, continues to be harmed. When I think about the lives of my high school friends with the same experience, many of them cis straight kids, this last point sticks out. I know so many people who, when they got married, they experienced pain and suffering because they were not given education and rather made to feel ashamed of their bodies. My life experience has shown me that it is impossible to stigmatize and shame queer sexuality without also stigmatizing and shaming the monogamous cis het sexuality that the writers of this bill would hold up as morally correct. The right that this bill upholds is not the parental right to keep their child from learning information. I don't know that that's even possible. Rather, it's the right of a parent to harm their child's ability to form intimate and loving relationships and friendships, to grow into a healthy and well-connected adult. I hope after you hear this that you can understand that this bill uses the language of protecting children, but it provides the legal framework for parents to do great harm. Please vote in opposition. I'd also like to add that our law only provides to protect kids after they have been abused. Kids know their parents will abuse them if they come out, and the law provides no protection for theoretical abuse, and this makes it easier for that abuse to happen. I'll take any questions.
Representative Raymond.
Thank you. I'm sorry.
One question.
I just didn't get your name, and I like to take notes.
Derek Brent.
Thank you.
Thank you. Chair recognizes, it looks like Elaine Plant. I think I have that correct. And on the on-deck circle is Cameron Munns. And then Representative Perez from Londonderry.
Thank you. So Elaine Plant, Dover, New Hampshire. I agree that it is a fundamental right of parents to direct the upbringing and education and care of their minor children. Important information relating to a minor should not be withheld from his or her parent, including information relating to the minor's child's health, well-being, education, while the minor is in the custody of the school district. Parents have a fundamental and inalienable right to be the influencers and moral compass of their family and their children. This begs the question that's being asked, why? Why is a parent's rights bill necessary? And the answer is that the schools have overstepped their boundaries in all these areas and are usurping the fundamental rights of parents. As the gentleman had said before in the beginning of this meeting, that there is an attitude that our children should be educated differently from how they've been educated in the past, and that parents are abusive. The amount of information of a sexually explicit nature being provided in the schools is overwhelming. Over 90 sexually explicit books in our school libraries and on Sora. Why are we hypersexualizing our children to begin with? The American School Counseling Association has encouraged their trainees to lie, undermine, and withhold information from parents. This does not make schools a safe place. If this is where the training is coming from, in their training program titled No Limits, there is video of this leadership detailing this undermining in their own words. This is discoverable. You can find it on courageisahabit.org by Alvin Louis. And in addition, there are surveys designed to be self-fulfilling prophecies in there through the data mining of the surveys that we have. I agree with Representative Ball that connecting the parents with counseling is one of the best things you can do. Include the parents in the conversation, and this will build trust where there currently is none.
Thank you for your testimony. The chair recognizes Cameron Munns with Representative Christine Perez in the on-deck circle.
So just to give you some context, I was a public educator in Nashua for 11 years before I chose to resign because of why I'm here today. Second of all, I just want to comment that if you want to make a claim on over-sexualizing children, then I would like to see you at Target in front of the baby section with, protesting against the the baby onesies of ladies man or anything like that. So if that's what you're actually worried about, I'll see you at Target. So I'm in complete opposition of this bill due to its blatant anti-trans government overreach, and it would be an offense to anyone in this room to think that it is not anti-trans. If you notice, all the people coming up, they're mentioning trans rights, they're mentioning, heaven forbid, their child actually uses the English language and plays with pronouns. I'm also in opposition to it because it goes in quite contrast to HB 619, which was heard earlier today, which takes the rights of medical decisions away from parents with their trans children. And yet in HB 10, someone actually sitting just here, one of the co-sponsors said parents and not the state are responsible for upbringing of their children. So I'm concerned with some obvious hypocrisy in that. HB 619 also says that public schools K through 12 in New Hampshire shall refer to children by the name and gender that they're enrolled as. But HB 10 says that parents have their rights. So that would potentially get rid of the rights of the parents of trans students. So essentially, basically, everything that I've been listening to today has been contradicting itself in the name of protecting children. But really what it is it's anti-trans legislature. And someone earlier today said that tools can be, this is a tool and not a weapon, but tools can be used as weapons when wielded to cause harm.
Thank you for your testimony. Aaron Penkachek? I'm sorry, Representative is next, then Aaron, and please correct me when you come up here. I have Penkachek is in the on-deck circle.
First, I'd like to apologize for overstepping my bounds and coming up to you.
Welcome. I mean, forgiven, whatever. Welcome.
Thank you. Hi, my name is Christine Perez. I am from Londonderry. I am a retired nurse. I am a mother. I'm a grandmother, and I'm now a state representative. About 3 years ago, I had a bunch of parents that I was going and speaking at school board meetings with who were having a terrible time getting any response from their school board to find out what was going on with their children, to find out what books were in the library, what Choose Love was. They were having a horrible time. Many of these parents withdrew their children from public school based on that. Last May, these parents approached me and asked me to become a state representative. Never did I think I would. I ended up on the Judiciary Committee, and I believe that I was put there for a reason, although it wasn't one of my choices. I keep wondering, so I decided that I was going to be a rep because one of my main goals was to stand up for parents and children. Not my only, but parents and children. And I keep wondering why we're here even discussing this. What has happened to our society that we have to have laws protecting parents, whether they be biological, adoptive, custodial, or whatever? These parents were not having problems with sexual orientation for their children. It was much more general things that were going on. So this is not just a bill to protect parents of LGBTQ children. On March 1st, 2023, a representative and 6 co-sponsors introduced in the U.S. House of Representatives a parental rights amendment to the Constitution. The amendment would enshrine, that means preserve in a form that ensures it to be protected and respected, the traditional liberty of
You
parents.
have 10 seconds left.
Okay, and direct the child's upbringing and education. This is common sense. Children are not given Advil in schools without permission, can't go on field trips. There is a bill right now that to raise the age.
Thank you for your testimony. We will now hear Aaron Penachik and followed by Zoe Hill. You're going to hit the red button first.
I'm going to
Thank
give you back some of your time because most of what I wanted to say has already been said. But and in particular, the lady that just testified taught about most of it. I keep hearing everybody's falling back on the LGBTQ issues on this bill. We've been hearing all day on this testimony. It's not just about that. It's about teaching materials. It's about books. It's about electronic access to books, including the Sora app. It's about counseling. It's about health. It's about surveys being taken from the kids. It's about bullying. It's about disciplinary action. Why can't parents have, I don't even know why we're having this conversation, to be honest with you, like the lady there just said. It boggles my mind, frankly, that we have to have a bill that allows parents to be participating completely and wholly in their children's education. So I urge you to vote this bill OTP for those reasons. And I'll give you back the rest of my time, sir.
Thank you, sir. Chair recognizes Representative Emily Phillips from Rockingham District 7 and friend. Did the friend sign a pink card?
More than a friend. This is Teddy. So I'm Emily Phillips. I represent Fremont, New Hampshire, Rockingham 7. I ran for office based on the parental rights issue. I want you to know that I stood out front as an activist before I decided to run because it was so important for the last term parental bill of rights to pass, and it didn't happen. So here I am. I want you to know that we represent the people of New Hampshire. The people of New Hampshire on both sides, I believe, want this bill to pass. So that's just the only thing I wanted to get up here and speak about. I think that a lot of people are pinning this to be a trans issue. I don't think it is. I just want transparency. I was on the school board for 3 years in my town. I've seen a lack of transparency as far as what parents have access to know what's going on in the school with their kids. And I think this is a very important issue and that it's going to keep coming up. So if we don't pass it now, it's going to continue to come back. Parents want to know what's going on in their kids' school. So open to questions. I'm sure you guys want to move along, but that's it.
You have about 10 seconds more, and we can look at the cute one for about 10 seconds. Oh, I'll see you in the House of Representatives in about 16 years. Kid.
Yeah, hopefully I'll be gone by then. All set?
Well, they do let older people in, but thank you.
Thank you.
And Zoe Hill is next with Stephen LaFond in the on-deck circle. No Stephen LaFond so far. I mean, no, somebody, do we have Stephen LaFond? I do not see if he walks in from next door. Actually, we have plenty of choice seats down here in the regular room. Then Janine Babarat. Andrew McPherson. Sally Stout. With Heather Mullins, I think, next.
Hello. This bill isn't about concern of what individual teachers think of doing with a child that they do or they don't do. This is about dealing with what a school system or district plans in a very organized fashion to have more control in the students' lives. Representative Ball suggested school meetings with students, parents, and staff, and that is a very good idea because it takes away the secrecy. Parents have no idea what's going on in their kids' schools. I've been testifying in my school district school board meetings for 2 years, and I ran for school board. And I can tell you what's going on. Obscene books in the library. We've already identified 85 in the Dover school libraries that are horrendous. 85. I can give you a list. Access to pornography via Sora, which is the online library the schools use, with links to pornographic websites on the school-issued computers. Bathroom issues affecting all the students with destruction of bathrooms, drug use, people being afraid to use the bathrooms, students being surveyed and counseled by behavior specialists and teachers with very little, if any, training to be doing that. Equity walks in K through 12. Less than adequate class time focused on academics, as evidenced by the very low proficiency scores for 10 years in Dover.
You have 15 seconds left. Get the juiciest sentence.
And curriculum content. Parents have no clue. I have all of it. I filed a 91A and I have it. I think we need to pass this bill because we need transparency for parents. Thank you.
Yes, will you take a quick question?
Yes, certainly.
Thank you very
Recognizes
much.
the clerk.
Thank you, Chairman. Thank you for taking my question. I've been doing a little bit of research, and I was shocked to see, and would you believe that 3/4 of parents are unaware that 90% of children beginning at the age of 8 have been exposed to online pornography on their telephones, on their tablets, more often than not in their homes.
Well, but they're doing it on the school issued Chromebooks, and they're doing it through Sora, the library link, but they're also doing it through Spotify, which is a music link, and Kinks.com, Grinder.com. These links and worse are connected by these books online from the school Sora app. Thank you.
Thank you so much. The chair recognizes Heather Mullins with Andy Bemis in the on-deck circle. Well, Helen Mullins will get another chance. Then I will recognize Andy Bemis with Paul Santos in the on-deck circle.
Thank you, Mr. Chairman, members of the committee. My name is Andy Bemis. I'm opposed to HB 10. I grew up in New Hampshire at a time when the environment for LGBTQ minors and adults was more hostile than it is now. As a parent of 2 teens, I've been lucky to see how much better things have gotten for my kids and their families, the support they get from their friends, their families, and their teachers. Growing up as transgender is still uniquely challenging under the best circumstances, but the love and affirmation these kids receive makes a world of difference, and I wish I had had the same when I was growing up. Empowering individual parents to object to LGBTQ affirming curriculum and punishing teachers for respecting the confidence of students who may not feel safe disclosing their gender identities to their parents would undermine the support our children rely on. Parents who object to curriculum related to sexuality already have the freedom to discuss alternate assignments with their students' teachers. And New Hampshire already requires any adult, not only teachers, to report suspected child abuse or negligence. The representatives who presented this bill have already made a good case for how redundant it is. This bill would only succeed in making some of our most vulnerable children less safe, and in some cases enable their abuse. If the bill's authors are motivated by parents' rights, as they say they are, then I urge you to listen to the families that have presented their stories today. There's this idea that keeps coming up. I'd like to add that this isn't actually about LGBTQ issues. So I look forward to the circumstance where a teacher overhears a male student talking about how they have the huts for a girl and then are compelled to have to tell their parents that their son is in fact straight. So don't tell me that that's not what this is about. Like, if we're here to be honest, let's be honest. And as for those of you who have testified in opposition for the bill, it's been wonderful hearing your stories today. And, you know, I think it's given me strength, and I hope you all feel the same. Thank you very much.
Thank you for your testimony, Paul Santos, with David Trumbull behind him.
Thank you very much. I appreciate being here. I'm Paul Sontag from the Amherst, Milford area, Souhegan Valley. And before I start, I only have one point I really want to cover from all the rest that's been touched. But I just wanted to say that I'm totally affirming and supportive of all the services that go out to LGBT community. So whatever I say, please realize that all those services are necessary for you folks to get what you need for mental health, etc. My topic would be talking about the relationship between teachers and parents and superintendents and school administration. We talked a lot about confidentiality and transparency. And so I've been a teacher, principal for 30 years, and then with extra experience later on. I'm also a recovery coach at the present time. But what I'd like to say is about this is that all the teachers that I know look for a school district where they can work with parents. They love parents. That's why they're there. They did not come just to teach subjects. They came to have and be a relationship with the students and the parents. You might not believe that, but it's really true. And so the idea is, for my suggestion here, to mitigate a lot of this stuff without a lot of money, I would just really look for an initiative where parents and teachers and the administration can start building relationships. One of the issues down here, as we said, you know, if teachers love working with parents, that's what I always did. and parents really want to have a great relationship with their teachers because they know they're going to get a good education if they have a good relationship with them. So what's the key point here? The key point is trust. And if parents and teachers can have trust relationship together, what do you think the children are going to model? What do you think they're going to model? They're going to model the adults that are in their life.
You're already over. Could you wrap it up in about 10
Yes,
seconds, please?
exactly. I could.
Yep.
It says you can't mandate relationship, but it'll mitigate a whole lot. And I still would suggest that if you could get the two to come together and listen to one another, we would have great success.
Thank you,
very
sir.
much.
David Trumbull with Kerry Coventry up next.
Good afternoon. Thank you for having me. I oppose this bill for a couple reasons. First of all, if this bill is just a catalog of parents' rights all listed in one place, except for W, X, and Y, as was said by one of the presenters, then just take out W, X, and Y. Why don't we just have a discussion about whether or not we should have a parents' bill of rights, and then next time talk about LGBTQ rights, because this is getting conflated into two completely different issues, and the losers are going to be the LGBTQ children in this state. Second, parents' rights are important. I'm a parent. I have two kids who went through the public schools, but they're not absolute. They don't all of a sudden get 100% of the rights when they turn 18. It's developed. It comes over time. Just look at your custody cases and divorces. The Supreme Court of New Hampshire says that around the age of 13 or 14, the child's wishes become crucial. We should recognize and respect children's wishes. Parents are important, but they shouldn't be given extreme supreme rights. Number 3, this bill is only going to affect two situations in the real world. Homes that are not safe. The homes that are safe, the parents who support their LGBTQ children, this bill isn't going to affect them. But the places where they're not safe, this bill is going to make that child's life much more unsafe. And it's not going to necessarily lead to abuse. It will probably lead to homelessness. Somewhere between 30 and 40% of LGBTQ kids, especially transgender children, end up being homeless. That's what's going to happen. They're going to get outed when the parent asks a question, and they're going to end up out on the street. And that's a dangerous place for a young person to be. And lastly, the person who's also going to lose in this is the LGBTQ kids who lose a safe place to be. 22% of high school children in this country, according to the CDC, are LGBTQ. This bill is going to be perceived as an anti-LGBTQ bill by all of these children. They're not going to feel like they can talk to their teachers anymore, so they're going to lose that one safe place. You think that's important? One trusted adult reduces the risk of suicide 40%. I urge you to look up online the amicus curiae brief in that Manchester lawsuit. It's available to everybody. It's great reading. It's filled with citations and sources with data. It's got every single argument you need to know why this bill is bad. Thank you.
Thank you very much. Wow, you got so much packed in just over 2 minutes. Amazing. It can be done. It's either Kerry Coventry, is it? Don't see. Paige Wood. Paige Wood, now up.
Hi, my name is Paige Wood. I live in Greenfield, New Hampshire, and I strongly oppose HB 10. This bill endangers LGBTQ plus youth as it would dissolve safe and affirming spaces in schools and open them up to abuse. Rates of depression and suicide among trans youth drop dramatically when they are supported by their families, schools, and communities. Unfortunately, not all families are supportive, a fact that the sponsors of this bill would rather not think about. This bill eliminates a child's autonomy in favor of the absolute authority of a parent. I would ask those who support this bill why the rights of a parent trumps the rights of a child. The sponsors of this bill claim that this bill does not permit parents to abuse their children, and while that is true, it severely limits the ability for educators and medical professionals to prevent abuse. This bill is nothing but culture war nonsense masquerading as parental rights and is intended to force LGBTQ plus children back into the closet. Thank you.
Thank you for your testimony. Merrick Finn, followed by Maxine Mosley. Do I have a Merrick Finn? Do I have a Maxine Mosley? Do I have a Mary Cousins? One Mary Cousins, please. With a Maggie O'Neill in the on-deck circle, do we have a Maggie O'Neill? We have a Maggie O'Neill's hand.
Maxine.
That is Maxine Mosley.
It is.
Wow. Okay, I'll take that card back. I'll swap you for a Maxine Mosley. Thank you. It's like baseball cards.
Good afternoon. Thank you for the opportunity to testify. I actually wrote a testimony and then I changed it 9,000 times. I'm going to go back and stick with the original, not to confuse everyone. My name is Maxine Mosley. I am a retired school counselor from Manchester. In 43 years in my career, I served thousands of young people from kindergarten to high school. On the middle school and high school levels, I was very often one of the few sounding boards and support systems for GLBTQ youth. It was never my job to tell them what to think or to tell them who they were, but to listen and encourage them when they were ready to share their identity with whomever they felt safe sharing that information with, including their families. It was and never is my role to out anyone to their parents or guardians or families. And in many cases, and you've heard this term already, I was one of the trusted adults. Let me share a story that just happened 2 weeks ago. I met a 19-year-old young person who's now living at a friend's house, a friend of mine. This youth was kicked out of their parents' house because they came out as trans. When I met them, my first question is, what are your pronouns? My friend, who is considerably older than me, was confused about why I would ask that question. I explained because I wanted to communicate with this person respectfully and how they wished to be referred to and as. The most amazing thing happened, and this has happened throughout my professional career. This youth gave me a big smile, a hug, and just started talking about their struggles and their pain. They shared with me how they had thought about joining the military because they knew they would be put in a position to die. And I will add that they said, and die so my parents would think that I could be honored. Their parents wanted them to be fixed, changed, and to make an active decision not to be a trans person. I am still evolving and learning at almost 68 years old. But my heart knows how wrong this is. In a world where compassion and connection is everything, this young person was considering ways to die because of the shame that was thrust upon them for who they were.
And now you're over time. Would you give us about 15 seconds more to wrap it up?
I will. Thank you.
Turning the page over didn't count against it. You can go now.
Criminalizing educators is what this bill will do. I've been an educator my entire life. We have continued to be muzzled about how we care for children. This has nothing to do with the parental rights about curriculum, assemblies, guest speakers. I'm all for that. But when you ask an educator to respond to a parent about sexualized questions about their children, it's wrong.
Thank you so much for your testimony. The chair now recognizes Maggie O'Neill with Katie Masters in the on-deck circle.
Okay.
It's high tech.
Thank you. Good morning. My name is Maggie O'Neill. I drove about an hour from Newmarket to be here, so thank you for hearing my testimony. I want to express my opposition to this bill. It concerns me for several reasons. One, I'll go back to my 8th grade year when I did not yet know that I was queer, but a teacher figured it out actually before I did and informed me. And luckily they did not out me to my parents because I grew up in a Catholic household. So it was a bit of a question of when I could come out to my parents safely. I eventually did on my own terms, and we have a beautiful, loving relationship now, but it was my choice. And so for trans students who are experiencing questions about their pronouns and trying out new names, this is a real issue. When I eventually went to college, I became a teacher. I've taught in schools, I've taught in after-school programs, and I've had students come out to me and try out new pronouns with me, let me know, hey, I'm going by this name, and please don't tell my parents. The reason they try this out is because it's a safe space and it's lower stakes. Their most important relationship is with their caretaker, their guardian. They want to make sure that they can safely make this change in a lower stakes atmosphere. And I respect teenagers' autonomy. Nobody's going to be harmed by trying out new pronouns and trying out a new name. So to include that kind of information in a bill that's purporting to protect children from all kinds of dangers is quite frankly insulting to those in the trans community. I urge you to oppose this legislation. Thank you very much.
Thank you. And now the chair recognizes Katie Masters with Bill Blum on the on-deck circle. No Katie Masters. Bill Blum. I'll give him a second shot. And you are?
Katie Masters.
You are Katie. Sorry.
That's all right. All right. Good afternoon. My name is Katie Masters, and I am a resident of Littleton. I am testifying today in opposition of HB 10. My opposition stems from the language of the bill that allows parents to call for restriction of access to peer-reviewed data on gender and sexual orientation. I grew up in Stewartstown, where there were 9 kids in my class. From a young age, I was ostracized by my classmates for a myriad of reasons, from being the stereotypical nerd, to being overweight, to not being interested in sports or other recreational activities. What I've only realized as an adult is that I also felt othered because I did not fit into our society's gender norms. If given the knowledge and opportunity, I could have come to terms with who I am at a younger age, and while I would not have found my people in that group of 9 kids, I could have found peace that people like me exist and could be found, even in our rural northern communities. HB 10 would ensure that kids like me have no chance of accessing information that could not only show them a whole world beyond our smaller, isolated communities, where they don't fit in, but it could save their lives. As someone who can be counted in the statistics of LGBTQ youth who have suffered from depression and suicide attempts, I strongly urge this committee to oppose furthering this bill. Our children deserve every opportunity to grow into their full potential with compassion, understanding, and the ability to access information beyond their family group, which, like my own, may not be a safe space to foster that potential. To say that this is a protectionist bill is a lie, as it hides state interference in the rights of our children for self-discovery in favor of fear of anything different and parading it as rights for parents. Being different and accepting that has set me free and brought me joy in ways that I have never felt in the 3 decades of my life leading up to the present. I am better for it, and others like me would be as well.
Thank you so much. Bill Blum, and following is Mary Cousins.
Good afternoon, everyone. My name is Bill Blum. I'm here to speak in opposition against this legislation. It's been identified and there was some last minute changes to it. I didn't have time to sit there and read 6 pages of it, so I apologize. I'm speaking against something that was in the original bill that is no longer present. This bill is called the Parental Bill of Rights. Very similar legislation passed in Florida, also known as Don't Say Gay. So I want to recognize that as being what it is. The LGBTQ plus community is under attack right now, and I feel that this bill is a direct attack to my community. As a parent, my child, my oldest one who's 17, did in fact change their name as well as their pronoun at the school that I was unaware of that it happened. But guess what? It didn't change anything at home. It's still my child. We talked about parental bill of rights earlier about how we need to make sure that the parents are in charge of the situation. This reminds me of colonial times. Kids are not property. They're not dogs. They're not your piece of land. They're actual human beings. My job as a parent is not to control them. My job is to provide a safe space for them to thrive, whatever that may be. It may be my son, my daughter, my non-binary individual. Don't care. Things happen a lot that parents won't understand, and without safe spaces, i.e. schools, our children won't have a safe place to talk. Earlier, a few minutes ago, the gentleman in front of me created his own safe space by having a pistol in his waistband. Guess what? I didn't really care about that. This is New Hampshire. We all have our own rights. I also want to recognize that that brief pause was a moment of silence for the people who will take their life if harmful legislation is passed like this. I may not know your name ever, or if you were successful in taking your life, but I will recognize that passing this legislation will provide an outlet for that to happen.
Thank you for your testimony. Mary Cousins, followed by Haley Brown.
Thank you, Chairman. I'm a little nervous. I've never done this before. My name is Mary, and I'm from Loudon, New Hampshire. I'm a veteran. I'm a parent, a grandparent. I feel like we are on a very slippery slope. China's children are governed by the government through their school systems. We are the United States of America. We are a live free or die state. I believe everyone has an opportunity to live their life the way that they choose. I am in support of the parental rights because I do believe that every parent has a right to raise their children as they see fit and not somebody else and what their ideas are. I believe that open communication is successful between teachers and parents and the children. Sometimes children are confused more often than not. And if you lie to the parents or you conceal from the parents, how are they supposed to be part of the solution of their children's upbringing? One other thing is that it's not really just about LGBTQ, whatever. It could be a young girl who got pregnant. It could be someone who's gay that their parents are really okay with it if they only knew. But if it's held from them, they're not part of that nurturing process. The bottom line that I believe is that I don't understand why we're here talking about if we should have parental rights over our children. But I believe that it's important that we don't go down that slippery slope and avoid or cut off parental rights for our children. So I am in support of it, and thank you.
You did great for your first time.
Thank you. Is there any questions?
Thank you so much.
Thank
Haley
you.
Brown, followed by Michael Guglielmo. The Italian guy next to me is monitoring my pronunciation. Guglielmo. Do I have to go like this?
Hello, my name is Haley, and I'm here today in opposition of HB 10. I believe from my own experience, this bill puts New Hampshire children at risk of harm. We must believe our children who report abuse. No child lives in fear of their parents for no reason. I grew up in a violent religious household. When a close relative was outed when I was 8 years old, I learned that I could not safely come out while living at home. No outsider could have adequately assessed this risk. Like many abusers, my parents coached us on how to lie to Child Protective Services. I needed adults to believe me about the abuse I experienced in spite of my parents' carefully curated good reputation. No child is too young to disclose abuse. We would not deny a child protection when they disclose any other reason to fear their parents' abuse. Most parents are good and loving. But my faith as a Christian teaches me that the shepherd leaves the 99 to save the one. Queer children are the one. Even one child dying or being abused as a result of this bill is a disgrace to us all. Even if there are repercussions for abuse, if this bill does not condone that abuse, it will trigger it, it will cause it, and we need to ask ourselves how we can be preventing that proactively. Children are not closeted for no reason. Parents need to bear the responsibility to be safe and trustworthy. You are responsible for your relationship with your child. Coercing teachers to break this trust will not improve your relationship. You cannot coerce your child if he feels safe with you. My parents homeschooled me, and I lived under the total ideological authoritarianism that is being glorified in this bill. It did not make me straight. It facilitated my abuse. If homophobic parents choose to exercise the right to know, they will also be exercising the right to ruin their relationship with their children by violating their children's trust in them. This won't legalize abuse, but it will result in it. It will undermine children disclosing abuse. It will undermine good parents' relationship and trustworthiness to their children. I did not have a single safe adult in my childhood. Talking to a safe adult might have prevented years of shame, suffering, and suicidal ideation.
You're over time. You now have 15 seconds to wrap it up, please.
Teachers are a haven for at-risk and abused children, and we need to be empowering them and making them be trustworthy to their students so that students who are experiencing violence will go to them.
Thank you. Now, let's see. We call upon Michael Guglielmo. And remove your hat, sir. That's inappropriate here.
Are you asking me or telling me?
I am telling you to remove your hat.
Really?
Yes,
You're
sir.
telling me to remove my hat?
I am doing that.
My name is Michael Guglielmo. Google me. I am here in support of this bill, and anybody that opposes this bill doesn't have a right to be a parent. As taxpayers, the school district has one duty, and that is to protect the best interest of a child. Your duty as an educator is to teach the truth, not lies, facts, not fiction, and biology, not a social agenda that propagates non-gender. You're non-gender. I mean, hey, I'm going to stand here as Julius Caesar right now. I'm Julius Caesar, and I'm a female. You believe that? If you believe that, you're crazy, okay? Non-binary philosophy, ideology is not to be taught in schools. We don't teach ideology in schools. We teach facts. We teach the truth. And if you oppose this bill, you have no right to be a parent. That's all I got to say. Should I put my hat back on now?
It would be
I'm done.
courteous not to.
I'm done.
Because of the
I'm
wording.
done. I am on the record. I am done.
All right. Now recognizes Katie Burns with Kim Peasley to follow.
Thank you, Chairman and committee members. I'm Katie Burns. I'm here testifying on behalf of New Futures. New Futures is a nonpartisan, nonprofit organization that advocates, educates, and collaborates to improve health and wellness of all Granite Staters. New Futures opposes House Bill 10 because it prevents students from establishing supportive networks outside of their families, which has been shown to mitigate the factors of adverse childhood experiences, or better known as ACEs. The students who are most vulnerable to the dangerous implications of this bill are students exposed to these ACEs, and particularly students who are living in homes where parents are struggling with substance abuse, mental illness, domestic violence, and a messy divorce. These ACEs oftentimes accumulate and lead to negative mental, physical, and behavioral health outcomes. The accumulation of ACEs can reduce a child's future lifespan by up to 20 years, making these toxic home environments a major public health concern. In Manchester alone, over 1,000 children were mentioned in police reports last year. For these students, schools are their only safe space to have a safe, trusted adult. It's important that these students feel safe in sharing sensitive and personal information. And when a child is able to share their challenges with a trusted adult in these schools, the risk of dangerous consequences as a result of their ACEs are reduced. Communities across New Hampshire have invested in building collaborative partnerships to address ACEs, including many police departments from all over the state who have dedicated efforts to collaborate with schools and mental health agencies to reduce barriers for children accessing therapeutic supports offered by licensed mental health clinicians. This bill will counteract efforts by discouraging students from accessing in-school supports, especially if these students are fearful of a parent exercising newly granted rights to breach their confidential therapeutic relationships and records. If passed, this bill will reinstate barriers that our first responders, educators, and health professionals have worked so hard to break down. If you would like to see New Hampshire continue to be recognized as a national innovator in programs addressing ACEs and advancing children's positive health outcomes, then you will oppose this bill. For these reasons I've shared, New Future strongly urges the committee to vote ITL on House Bill 10.
Thank you so much for your testimony. The chair recognizes now Bob. You were Kim? No, you were Katie. Now Kim.
That's right.
And then
Thank
after
you.
that is Bob Keating.
I first want to say thank you. It's been a very long day, an awful lot of bills today that we've been active in, and appreciate your time.
When we don't run the clock when you're thanking us.
Oh, good. I could go on. No, I'm just kidding.
Yeah, there may be a moment when we may come back to you, but you're now on.
I'm a professional and I live and work in Concord, and I'm a parent of a transgender son. I'm testifying in opposition to HB 10 and SB 272 and the other anti-trans bills today. I would be remiss if I didn't note the lack of decorum that I feel in presenting a 6-page amendment right before testimony began, and also not in red line. It made it incredibly difficult. I'm an attorney, and it made it very difficult for me to assess what was been changed, and I find that interesting at best. These bills are aimed at suppressing fundamental rights and interfering with a student's autonomy in matters that are deeply personal and best known to the individual student. These bills require parents to be completely and truthfully informed if a student is being identified as a different name, gender, or pronouns than they were enrolled as. These bills also require that parents be informed as to any extracurricular activities, clubs, or organizations their student is participating in. This begs the question, why would a parent with a healthy relationship with their child be unable to have these conversations directly? Why are we being led to believe that there's a need for the state to step in? It seems clear that the children being targeted by these bills are likely living in a home that's not safe, and the state has no business in advancing any agenda that puts these children at a higher risk. These bills overreach by requiring school districts to provide an opt-out for certain instruction about sexuality. These bills establish a path toward discipline for any school employee who encourages or coerces or attempts to encourage or coerce a minor child to withhold information from their parent, and contain a requirement that school districts develop procedures for a parent to learn about the nature and purpose of clubs and activities offered to his or her minor child's school, including those that are extracurricular. I have heard several times today that some don't understand why we're even here. I would note that that's a privilege.
You
As a
are at
parent
2
of-
minutes, and give us 15 seconds more, please.
I'll wrap it up. As a parent of a transgender son, it's bills like these that encourage daily systematic attacks on his very existence, and they put him in danger. As a legislator voting in favor of these bills, you are in fact culpable. According to every major medical association in the U.S., the presence of gender-affirming care is a strong predictor. Lack of it is a strong predictor of suicide risk.
Thank you, Counselor. I appreciate your testimony. We now call upon Bob Keating with Hayden Smith in the on-deck circle. Hit the button in the front.
My name is Bob Keating, and I want to thank the committee for the opportunity to speak. I am a retired marriage and family therapist of over 50 years. I spent 40 years working as a clinical supervisor in residential care with many children coming there as a result of abuse and neglect and significant mental health issues. I have, and I just looking at the faces, I think likewise have been strongly affected by the voices of Emma and Paige and Derek, who spoke about their direct experience about this. I'm also a parent, a grandparent, and a great-grandparent. And in my profession, we spoke about this very briefly, is about confidentiality. Confidentiality is a central tenet of our culture, saying that there needs to be places that people can share their stories. One of the sponsors of the bill talked about things that they never said to their parents. Almost all of us who have been parents know that we are fortunate that other people have been there to listen to our parents. Not about problems with the parenting, but the simple fact to be able to have somebody else to be able to share and work it through. So that's why we have confidentiality laws, and they're very specific about what are the protections and what has to be disclosed, and generally that's around the framework which is dangerous to the person or dangerous outside. So we have that already built in. We have stories here that have been showed about things that went wrong and about allegedly when professionals don't share the stories, but we also know the stories about when things went wrong in the other ways. I have direct experience that one of my colleagues was involved with a family, and the family, particularly the father, was so opposed by the intervention, quote, by the state.
Sully, you're over. If you could give us 15-second wrap-up. Got to hit your mic again. I
Again.
canceled you.
Yeah, excuse me. Thank you. That this bill, and I'm opposed to it, is that I'm fear unintentionally what it does is it makes more kids at risk. 40% improvement rate when trans kids have somebody to talk to.
Thank you now so much. And the chair calls on Hayden Smith, followed by Representative Potenza.
Good afternoon, members of the committee. My name is Hayden Smith, and I'm from Hanover, and I'm here representing New Hampshire Youth Movement to testify in opposition to HB 10. Our movement includes many New Hampshire high school students who would be affected by this legislation, but are not able to be here today to speak on it due to school. So I'd like to speak a bit on their behalf on why this bill is unnecessary and even harmful. Our students have told us time and again that what they want out of school is a stimulating education that will prepare them to navigate and thrive in the complicated world they'll be living in as adults. This includes engaging with topics that may be uncomfortable to their parents, but still necessary to make informed decisions about their health and livelihood. I remember learning about HIV/AIDS in 5th grade, and while the topic may have produced some awkward conversations with my parents, it proved to be vital information for safeguarding my health. Unfortunately, this bill runs counter to what our students want by encouraging students to unilaterally cut their children off from learning about issues in school that they're not comfortable with. Now, parental discomfort with certain topics in their children's education is understandable, but there are more constructive and less confrontational ways of approaching the situation than what this bill prescribes. I think this bill is also an example of why we need to be cautious about over-legislating. HB 10 includes many statements about what parents can and can't do that are already widely recognized, and they're accepted by the public and by local law. But it mixes them with provisions and enforcement mechanisms that are unnecessary and could carry harmful consequences. Most, if not all, school districts in the state, for example, already have a process through which a parent can inquire about their child's schooling and even request that their student not have access to certain materials. But this bill creates its own rather vague definition of what these processes must look like, along with harsh penalties for school employees found in violation. While some school districts could foreseeably benefit from improving these processes, the solution should be made at the local level and not through a vague top-down mandate from the state legislature about what this process would include, especially when such a mandate carries heavy punishments for those found in violation.
Okay, you're in wrap-up territory. You got about 15 seconds.
Okay. We must be careful to treat our state's young students as people with their own agency and needs, not as pawns in some made-up conflict between parents and the world. Ultimately, our movement's members see this bill as an unnecessary piece of legislation that would create animosity between parents and educators where none need exist, all while disregarding the needs of the very people New Hampshire's educational system must serve, the children.
Thank you very much. And now we call Representative Potenza with Sean McDonough in the on-deck circle.
Thank you, Chair. My name is Representative Kelly Potenza of Stratford District 19, Rochester Wards 1, 2, 3, 4, and 6. The framework of opposition in this bill is all based upon the premise of abusive parents. And where is the due process? That's what's missing in all of this opposition testimony. And I want to be clear about previous testimony here. These are not new granted rights. And I assume that the committee is going to do their homework, and I'll make sure to send this testimony in as well. There's a long history which shows these rights that we already naturally have as parents. So Going back to 1923, it is the natural duty of the parent to give his children education suitable to their station in life. The fundamental theory of liberty, upon which all governments in this union repose, excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. That was Pierce versus Society of Sisters. That was another. These are all U.S. Supreme Court cases going back from 1923 all the way up into 1997. I do want to say that I do agree with, there's been a couple testimony about that amendment being delivered at the last minute. I don't like that either. I don't think that that's transparent. I support HB 10FN as introduced. I do not support the amendment. Everything in here spells out the rights that we already have as parents to ask questions. And I just want to say that I could give lots of examples, but I won't because there's no time.
And you got 10 seconds to wrap it up.
Okay. But these rights are parents that want to be involved, and they've probably had a roadblock that's happened to them. So spelling out the right of getting information, not about sexual.
Thank you very much. The chair recognizes Sean McDonough with Frank Knack on the on-deck circle. And I got to go back to the old-fashioned wristwatch. Oops, that's cocky. Here it is.
My name is Sean McDonough. I'm a student attorney from the Harvard Law School LGBTQ Advocacy Clinic, here representing Seacoast Outright. I am deeply concerned about the ways this bill would target and harm LGBTQ students. By restricting instruction on objectionable material, HB 10 would intimidate teachers out of discussing LGBTQ people and LGBTQ issues. Its invitation for scrutiny of instructional materials would only exacerbate the risk of discriminatory enforcement against LGBTQ topics. Further, with provisions designed to force teachers to interfere in transgender students' families, HB 10 would risk causing tremendous harm to vulnerable youth. The moment of coming out to one's parents can have significant effects on a young person's mental health, positive or negative, depending on how it goes. With the stakes so high, it's important to empower schools to help youth prepare and come out when they're ready. The last thing anyone needs is inflexible, state-mandated interference with that sensitive moment. Because of the frequent risk of harm from bills like this, I worry that sometimes we lose sight of the important fact that LGBTQ youth can thrive when treated with dignity and respect. Coming out as LGBT in an affirming home can increase feelings of safety and confidence. LGBTQ students who feel supported by school staff get better grades, are more likely to come to school and graduate, and have a greater sense of belonging in their school communities. And when transgender students receive the care they need, they can succeed and thrive at the same rates as their non-transgender peers. This legislature took an important step toward protecting LGBTQ youth in 2019 with school non-discrimination law. Please reject today's attempt to reverse course and target these vulnerable youth.
Thank you so much. Chair recognizes now Frank Knack with Aaron George Kelly up next.
Mr. Chairman, members of the committee, thank you so much for the opportunity to testify today. My name is Frank Knack. I'm the policy director with the ACLU of New Hampshire. I apologize, I don't have written testimony because of the amendment, so we'll be submitting that once we can take a closer look at the language. So I'll keep my comments somewhat high level. So from hearing the amendment outlined by the sponsor, it sounds like now we're much closer to the Senate version of this bill, which we have serious problems with. Many of the kind of real world concerns and how this is really going to harm LGBTQ, especially trans youth in New Hampshire, have already been articulated quite strongly by others. I'll focus on a few things that have not been lifted up so far. And because of the amendment and the new language around really trying to focus on LGBTQ youth and particularly trans youth, in particular, we're really creating a special tier of surveillance in schools for trans youth, which violates privacy rights and also sets New Hampshire up for potential violations of federal law. And so, to give an example, U.S. Department of Education's Office of Civil Rights issued a notice of interpretation explaining how it would enforce Title IX's prohibition on discrimination on the basis of sex to include discrimination based on sexual orientation and discrimination based on gender identity. And so, when you're looking at the new language of the amendment, as written, transgender youth are subjected to a distinct level of surveillance in schools, and we think that is a serious concern that you all should be looking into more seriously. And I just want to flag one other issue that hasn't been lifted up, is that New Hampshire Department of Education is currently invested pretty heavily in the One Trusted Adult program, and this bill would really undermine that work. That program is really about ensuring that students know that they have a trusted person at the school who they can confide in. And what this bill would do would be to gut that program. So we hope that you all will consider ITLing this bill. I'm happy to answer any questions.
Seeing none, thank you so
Thank
much.
you.
The chair recognizes Erin George Kelly with Betsy Harrington up next.
Good afternoon, Chairman and committee members. Thank you for the opportunity to speak to you today. My name is Erin George Kelly, and I'm the Director of Homeless Youth and Young Adult Services for Waypoint. I have come to express Waypoint's opposition of House Bill 10. I've worked with youth and families in New Hampshire for over 20 years and in homeless youth and young adult services in our state for over 15 years. I have seen firsthand that educators and school staff members are often the safest adults in a young person's life, especially youth who identify as LGBTQ. This legislation targets these exact people, educators and LGBTQ youth. Parents' rights may seem like common sense, but when you look behind the curtain, these terms are used to strip teenagers of their basic rights to education, physical safety, and freedom. This bill unfairly stigmatizes LGBTQ students because their journey will be policed and reported back to their parents. Teenagers are at a crucial stage of development and beginning to establish some independence from their parents and figuring out who they are. All students deserve to feel safe in school. They should be able to trust staff members to support them and not surveil them. This does not mean hiding information from parents. This means the appropriately trained school staff allowing youth to be experts in their own lives and share with parents when they are ready and able to do so safely. The Trevor Project's 2022 National Survey on LGBTQ mental health in New Hampshire states that 39% of LGBTQ in our state have considered suicide, and 10% of them have made at least one attempt in the last year. Forcing LGBTQ youth to be outed is not just harmful. It could lead to increased suicide attempts and death. This same survey tells us that 44% of New Hampshire's LGBTQ youth identify home as not being an LGBTQ affirming space.
You've got about 15 seconds to wrap it up.
You may assume that establishing a parent's Bill of Rights means connecting loving, caring, and supportive parents with what is occurring in children's educational setting. That is not the reality. And we know that firsthand at Waypoint because 25% of the youth and young adults that walk through the doors of our homeless youth and young adult services are LGBTQ young people.
Thank you for your testimony. You have come to the end of your time, and Betsy Harrington is up next with Jama Wilder to follow.
Thank you for the opportunity to speak today. My name is Betsy Harrington from Deering. I worked as a DCYF investigator and at the state prison as a sex offender counselor. In my work, I have never had to remove a child from a parent rejecting their gender or sexuality. I know it's happened, but it's very uncommon. I have had parents struggle with the news of their kids coming out, but I have never had a parent reject a child or beat a child for their differences. Abuse usually had to do with the parents' issues, often drug or alcohol related. I have worked with sex offenders, and I know intimately of their plots to abuse children. They found the loopholes. They became teachers, camp counselors, and coaches. They found a way to get close to children and to be trusted. Predators are surrounding our children, and parents are the ultimate protectors to their children. Teachers can be a wonderful resource to our kids, but they are a 180-day resource, maybe as much as 4 years, but they ultimately abandon their students. Parents are forever, and we house our children, not the school staff. If you support secrets and special relationships, it damages the child-parent relationship. You cut off this child from the only people responsible for caring for them until adulthood. If you allow secrets, you will have good parents removing our highest testing students for a safer educational environment. I am at that door. I'm ready to go. I see the dangers, and I'm not sure I can allow my kids to be put at risk anymore. Our public schools are distributing exploitive porn through our libraries and hiding secrets from parents. Why would any decent parent sign their kids up for that? I'm ready to leave. We will all soon be paying taxes to state-sanctioned abuse. I pay $1,000 a month to property taxes. I'd like that to cover a safe education for my kids. Otherwise, why would I want to pay such high taxes for something that's too dangerous to use? If I ask my son's teacher a question about my son, I expect the truth, or I won't trust that teacher with my kids.
15
End of
seconds
story.
to wrap
No
it
more
up.
secrets. Support House Bill 10.
Thank you so much. Chair recognizes Jama Wilder with Linz Jacobs. Next. That's you. Thank you.
Good afternoon. My name is Jama Wilder, and I'm the parent of 5 children, ranging in ages from 4 to 18 years old. Over a year ago, I was denied my request for a public hearing for my district school board. I wanted the opportunity to share with parents the things that were going on in our district. My children's curriculum was riddled with inappropriate sexual content. Many subjects were presented with divisive concepts that left my children confused and questioning why the information was being presented. I have the opportunity to speak to my children on multiple occasions, and they came to me and they told me it was there. The school district said that it was posted on their Google Classrooms, but the teachers weren't uploading it. So what they said was transparency never existed at all. And I know from my children telling me. I grew up in Hollis and went through preschool through graduation of the high school there, and it is a very different place today. Since I moved back to town, there have been 2 suicides in our district. The most recent suicide took place 1 week after the school illegally gave the children the youth risk assessment survey. They never gave us the option to opt out. And when the state gave them a slap on the wrist because they had broken the law, they simply said that they were destroying the surveys. They never gave it to the parents or showed them what those questions were asking their children. The school is incorporating toxic ideas they present as helpful through their social emotional learning programs. The mental health of these children is plummeting, and instead of pausing and looking at what harm they're doing to continue to make it harder and harder for parents to be involved if they don't agree with this. The last day that my children attended public school, my daughter was denied the right to present a project because the teacher told her it was argumentative. It was a PowerPoint presentation with 6 or 7 slides.
15 seconds to go.
She used a direct quote, and she gave what her interpretation was from the first president of the teachers union, John Dewey. Since my daughter's views did not align with the narrative, she was told she would have to redo the project and only use biography.com for her research. They did not question the direct quote, but she was silenced. Many times my children expressed their fears and inabilities to share their thoughts for fear of persecution.
Thank you, and that will end your testimony. We appreciate what you gave us for about 2 minutes and 20 seconds. Next, the chair recognizes Linz Jacobs with Heather Mullins to follow.
3 equality. I would like to state for the record that I also oppose the Senate side version of this bill, and I oppose HB Set 10. This bill would establish a path toward discipline for any school employee who encourages or coerces or attempts to encourage or coerce a minor child to withhold information from his or her parent. No educator should ever coerce students, period. However, many conversations between a student and trusted teacher or other school employee might look like this. The student says, "I'm gay," or "I'm trans," or "I think I might be bi." The teacher says, "Thank you for telling me. Have you told your parents?" The student says, "I don't feel safe doing that. I know my parents believe being gay or trans is wrong," or "I'm not sure if I'm ready for that conversation yet." The teacher says, "It's okay to not be sure," or "It's okay to come out on your own timeline." That's how my conversation with my favorite high school teacher went when I knew it wasn't safe to come out to my father, who believes being LGBTQ is a sin. I can easily see how many people who fearmonger against trans people would try to say that a teacher is encouraging a student under those circumstances, even though it's a simple, neutral response that lets the student, who knows their family better than any teacher, think through their own coming out timeline. It is not clear how encourage is defined or interpreted. When my father did find out I had feelings for my best friend and that we would kiss sometimes by hacking into my personal internet accounts, he told me homosexuality was disgusting and immoral and not how I was raised, took away my phone, and I thought I might be sent to conversion therapy. I was limited to applying only to colleges that specifically did not affirm LGBTQ students. He gaslit me by telling me I wasn't queer, just confused, constantly criticized and shamed me to the point of only talking about me like my true self was an entirely different person, and that I was only worthy of love if I adhered exactly to his worldview, and telling me that I was so immoral that he was concerned for the state of my soul. This never changed, continuing into adulthood. These are also the reasons that I gradually came out to a few close friends and teachers at my high school, because I desperately needed the few people I trusted to
You got
accept me.
15 seconds to finish up.
To wrap up, I'm also concerned about the line that requires parental consent for healthcare practitioners. Does this include school-based behavioral health counselors? If so, that's cutting off another lifeline for LGBTQ kids like my younger self, whose parents deny any need for healthcare. ITL HB 10.
Thank you so much. Now the chair recognizes Heather Mullins with Holly Stevens afterwards.
All right. Thank you guys for calling me again when I had stepped out of the room, but I appreciate that. So my name is Heather Mullins. I have a 13-year-old daughter. I'll tell you right now, like I would take a bullet for my child, and I think I'm probably one of the only people in the room that would. And so while I hear horror stories about parents having abused their child, like I guarantee you the majority of parents are the biggest protectors of their children. Every single one of you up there can probably say that your children you would do anything for. And you can't give away my rights as a parent without giving away your own. So if at some point in time you're not sitting behind that bench and you're a parent just like me and you disagree with a law or something that gets passed, do you want that being pushed on your children? A lot of what I'm hearing with this LGBTQ stuff as being like sort of the prerequisite to remove parents' rights is really like a fundamental lifestyle choice, right? The idea that a child is going to get abused if they have, let's say, a Christian or Catholic family because they disagree with, pronouns or things of that nature is just ludicrous, right? Like most parents, even if they don't agree with changing their child's pronoun, they'll be like, you know what? You want to change your name, you want to change your pronouns when you're 18, you're not under my roof, do it. They're not going to beat their child for having like these peer groups at school. And the other thing that I want to point out is that there's actually a group called Gays Against Groomers, and there's ones called the Changed Movement, which are LGBTQ, former LGBTQ, that have gone through transitions, including a gentleman behind me who is living proof that some of these ideologies they're pushing on kids whose brains haven't fully developed have lifelong irreversible consequences that are life-threatening. And so I appreciate everyone caring about children, but there's two sides of this equation and two sides of this conversation that on a national media standpoint, only one narrative is being allowed to get talked about. And it's actually within the LGBTQ community, it's frowned upon to detransition or to say, you know what, I'm more suicidal post-operation. We really need to say the kids genuinely suffering from gender dysphoria when they are 18 and older, if they want to make that decision, that is on them. But to take our children and use this LGBTQ stuff as an excuse to remove parents from having a seat at the table for what's best for their kids, to me is just, it's horrifying as a mom.
Thank you so much. We let you go a couple of, about 15 seconds over. Thank you so much for your testimony. Next, we call Holly Stevens from NAMI. And after that, Brian Blackton, excuse me.
Good afternoon, Chairman Pearson, members of the committee. My name is Holly Stevens, and I'm the Director of Public Policy at NAMI New Hampshire. NAMI New Hampshire is a nonprofit grassroots organization whose mission is to improve the lives of all people impacted by mental illness and suicide. We are here today in opposition to House Bill 10. I did notice, as I think some folks had mentioned, the date on the amendment is March 1st. And being a small nonprofit with limited resources, it would have been really helpful if we were able to have.
We would have liked to have had it too. There was some glitches not of our doing.
Can you take that off my time?
Give the lady an extra 30 seconds.
But just going back to that, it would have been helpful to have it before the start of the hearing today. I heard Speaker Sherman Packard mention that this has been in the works for a while. Also, when he was bringing the bill to the committee. My written testimony may not seem as relevant now as the bill has changed. I will send my written testimony on Senate Bill 272 to the committee since it seems similar to the amendment. But even though my original written testimony may not seem relevant to this amendment, it is. We are in the middle of a children's mental health crisis, and we need all hands on deck. We need to come together, and neither the original bill nor the amendment will accomplish this goal. The bill and the amendment destroy the trusted adult relationship that students have with school personnel. This relationship is critical in suicide prevention, one of the biggest missions of NAMI New Hampshire. This relationship is critical this bill vilifies school personnel, which will further the perceived divide between parents and teachers. It calls out trans youth in particular, which are extremely vulnerable population, of which 43% in New Hampshire report being negatively affected by politics. 43% of the trans youth community report being negatively affected by politics.
I'll give you an extra 20 seconds to wrap it up.
Thank you. I just have one sentence left. Therefore, NAMI New Hampshire urges the committee to recommend this bill inexpedient.
I owe you 15 next time. Hold me to it. Thank you so much. Appreciate your work and your testimony. Brian Blackton, please, with Brian Hawkins next.
Sorry. Very broken. I'm Brian Blackton from Concord. I'm a supporter of this bill. I'm a conservative, former police officer, federal firearms licensee, independent Baptist who has a King James Bible on my nightstand. That may scare some people here today because I remember when the Twin Towers were hit, I was teaching 7th grade English class. Some may assume I took the opportunity to try to indoctrinate my students to my beliefs that day, but I only taught the daily curriculum. I firmly believe parents are in charge of their children's education, not indoctrinated to another person's direction. That was attempted to me, thank God, not to today's levels, but my children's were exposed to it at today's levels. I do not believe any school has the power or right to not inform parents of any aspect of their child's education, health, or try to indoctrinate their moral, gender, or religious beliefs upon them. That is a parent's job and a parent's right. By taking God out of school, this is part of the outcome. I think the way to fix this is to remove children from public school until the parents are heard if this bill is not passed. Thank you.
Thank you, sir. And the chair recognizes Brian Hawkins with Stephen Scare up beyond him.
Thank you, Mr. Chairman. For the record, Brian Hawkins, representing NEA New Hampshire. Today, we represent more than 17,000 educators across the state, including many of the local education associations for many that are in many of your districts. And I am here to testify in opposition to House Bill 10 today. And I will try to hit just the points that I tried to see where the similarities between the original bill and the amendment, and also not to repeat a lot of what has been said. We have several concerns with this piece of legislation. First and foremost, including the stated penalties of the bill. This is similar to our opposition of the bill last year, which were actually at least some of those were taken out when it made it over to the Senate. Some of the overbroad language that are tied to those violations, as well as the numerous areas that are at least duplicative or confusing. So first, with the penalties, the bill states that any person who violates any provision of this chapter shall be guilty of a Class A misdemeanor. Violations of a bill such as this resulting in criminal penalties are unacceptable. I think, especially as was noted earlier, we're in an educator shortage. We are desperately trying to find teachers, paraprofessionals, other staff who work in the school. And so what kind of message does it send when the legislature is passing bills such as this that criminalize, I think was referred to earlier, criminalizing education? So I don't see any point to that other than to create a climate of fear and intimidation among employees in the school. One of the other paragraphs related to violations also seemed confusing. I think it was originally paragraph 3.
You now have 15 seconds to
Oh
wrap
boy,
it up.
okay. Where it refers to a certified educator being found guilty of violating any section of this law shall have their teaching credentials suspended. Confusing on how this would work, because does this mean that they are found guilty by the school district, by the DOE? The sentences mixes credentialing and their employment, which are handled by different entities. So if you're a credentialed educator, that means you have a license that.
Okay, you've gone way over, and thank you for your testimony. Yes, please. The chair recognizes Stephen Scare with Cassandra Sanchez on deck. Microphone, please, sir.
Good afternoon. I'm Stephen Scare of Nashua, and I'm here to speak in favor of this bill because parents need to protect their children from the belief systems that have become the established religions in public schools. Transgenderism teaches that children that they're born with gendered souls or gender identities, and these, not their bodies, are their authentic selves. Those who claim that it isn't an ideology cite its recognitions by professional medical associations, but it's a mistake to think these professionals are less vulnerable to dogma than anyone else. For example, Jeremy Coswell, the director of gender services at Boston Children, said, "A child will know they are transgender from the moment they have any ability to express themselves. We have parents that tell us their children knew from the minute they were born practically. Signs a toddler is trans include refusing to get a haircut, trying to stand to urinate, refusing to stand to urinate, trying on a sibling's clothing, playing with, quote, the opposite gender toys. There's nothing scientific in claiming that a newborn with no concept of sex or gender has an immutable identity which is expressed through gender stereotypes, even though these stereotypes vary among cultures and eras. These ideas can only be understood in a religious context, and religion doesn't belong in public schools. Excluding cases of abuse when children are young, they understand that when someone tells them to keep secrets from their moms and dads, they're up to no good. When they enter adolescence, they push back against the parents. Activists are using the school to drive a wedge between their parents and children during this vulnerable stage. Regarding the suicide stats you've heard, they come from online solicited surveys on LGBT sites. We know that the real rate is less than 0.1%, and autism and anorexia have higher suicide rates. Thank you.
Thank you, sir. Chair recognizes Cassandra Sanchez with Lily Tang Williams to follow.
Good afternoon, Mr. Chairman and committee members. Thank you for your time. For the record, Cassandra Sanchez, child advocate for the state of New Hampshire. I, much like others, had prepared testimony for the bill as introduced, so I will share that written testimony with you today, and I will follow up with an email with additional testimony that further covers some of the additions in the amendment. So as many of you know, the Office of the Child Advocate is an independent, impartial state agency that is tasked through statute to ensure protections for all. And I say all very clearly, not some, all New Hampshire children. And that includes our LGBTQ plus community, and that includes all children that could be affected by this bill, because there are others that have not been discussed before us today that could absolutely be impacted by this bill. I spend much time meeting with children in the community. And I also want to clarify for some that there has been misinformation shared here today. There are absolutely children who are abused when they disclose their gender identity to their families. My office reviews these on a daily basis. We also spend a lot of time meeting with these children, most of which end up in residential facilities, many ending up out of the state of New Hampshire, with minimal oversight and minimal trusted adults to check in on them. These children matter, and we need to protect these children. I have respect for parental rights, but they should not come before the safety of our children. I also believe that this bill leaves room for interference in law enforcement and DCYF investigations. As many had come before and mentioned, trusted adults are very important for disclosures for children. By severing that or the liability over the heads of those trusted adults and concerns for them to be able to protect those children and report, we understand that children are at risk of not disclosing abuse in the home, including as far as sexual abuse that can be occurring, that they will not be disclosing that abuse, and therefore it will not either get to law enforcement, or if shared with law enforcement and the school is then tasked with sharing with a parent, it could interfere with the law enforcement investigation in this regard. So lastly, as I had mentioned, I meet with these children in residential facilities, and what I hear from these children, and the voice I want you to hear today from my office, is that these children want to have adults that care for them. They want to be in safe environments, but they unfortunately understand that that is not always going to happen.
Thank you so much for your testimony. The chair now recognizes Lily Tang Williams with Allison Yeager to follow. And Lily Tang Williams is here. I was asked if I ever met you to say hi from Peter Boyles to you. I was on his radio show for 20 minutes every other week for 2.5 years, and he says to say hi. So anyway, hi. Yep.
Press the button you're on.
It's like radio. You got to have the button on.
Yeah.
And it makes it red.
Is that better?
Much better.
Thank you, Chairman, and thank you, committee members. My name is Lily Tang Williams. I am a Chinese immigrant, American citizen by choice. I am here as a mother of 3 and to strongly support Parental Rights Bill HB 10. Grew up in China during Mao's regime. I never heard of concept of parental rights. And every child in China, even today, belong to the government. And I remember when I was growing up, I'm totally subject to the whims of central plannings and centralized education and forced indoctrination. I was a young pioneer, Red Guard, and throughout my school years. And the CCB is still controlling all education. I was forbidden to see my own student file. Think about, I brought my picture of my middle school portraits here, okay? You will see. Every year as a student in schools, I have to take a portrait to put into my secret student file, and my parents were not allowed to see it, and I was never allowed to see it. You know why? Because it only belongs to the state. The government and the future employers can see it, but not my parents. I came to America 1988, seeking freedom and individual rights. I got involved in education because my kids were going to public schools 20 years ago. What concerned me is what I see today in America kind of remind me of my personal experience in China under a communist regime. The fact I have to come here to defend parental rights is very, very concerning. I think this bill right now is absolutely necessary in today's political climate. And it clarifies and protects one of the most ancient natural rights of human beings, parental sovereignty.
15 seconds to go.
The deepest human bond is between parents and their children. If you oppose to this bill, I wonder what has America become. And also, today, you see this national things going on all over the country. I feel like we have more opposition today than supporting parental rights.
Thank you, Ms. Williams. We appreciate your testimony. You've gone well over, and now the chair recognizes Allison Yeager with Anne Marie Banfield next. You can.
Hello.
You may go.
My name is Allison Yeager, and I have been transitioning for 2 years. And I had spent 8 years prior to this year in the closet. One of those years I had spent being a jerk to everybody I knew because of how much I thought that they would never accept me. So, I've been doing my best to make amends now that I'm able to be happy. So, thank you for your time, and that is all.
Thank you for your testimony. And the chair now recognizes Anne Marie Banfield with Chris Urchel up next. Yeah.
Thank you. Honorable members of the Children and Family Law Committee, my name is Anne Marie Banfield. I'm a parental rights advocate in New Hampshire, primarily focused on academic excellence in education, which is why I'm normally in front of the Education Committee. I do urge you to vote ought to pass on HB 10. I'm just going to briefly summarize what I'm saying, or what I was going to say is I will highlight some of the more glaring problems that pit parents against schools. This can also drive a division between parent and child. School administrators are not following federal law and ethical codes of conduct by assessing and treating mental health of students when they are treating the mental health of students without informed consent by parents. Children attending some of our public schools have had their mental health data shared with outside organizations like Plymouth State, Antioch University, and Keene State. This is a violation of the school counselor's code of ethics. School counselors are to maintain privacy on those records, but that is not happening in our public schools. Parents have been shocked to hear this sensitive data is leaving the district without any informed consent. I'm happy to expand on that if you would like. So who's being targeted right now? School Board Policy JBAB, if you're not familiar with it, was developed by the New Hampshire School Boards Association. The policy included a provision that told staff that they must lie to parents now. So under the privacy policy JBAB, it reads, school personnel shall not disclose information that may reveal a student's transgender status or gender nonconforming presentation to others, including parents. So parents are actually the ones that have been targeted in these schools. The New Hampshire School Boards Administration did finally withdraw their support for JBAB after a lawsuit was filed in Manchester. This case is being taken to the Supreme Court and is currently pending there. This parent was never given due process, which is a lot of what I'm hearing today. A lot of guilty parents with absolutely no talk about due process to them. We now have policies in place that require school personnel to lie to loving parents. This child was transferred out of the Manchester schools and now going to a charter school. Statements from those against parental rights paint parents as abusive or neglectful with no due process. Even cases of sexual abuse that happen by school personnel and teachers go through due process first. We don't paint all teachers as possible child molesters. Anti-parent policies drive families away from their public schools. So when this is happening, what I'm seeing is parents are pulling their kids out of the public schools.
You got 10 seconds to wrap it up.
Okay. I do want to mention that the FERPA law does require that, or does allow for parents to review their child's records. So that's already in law. So I'm not sure how there's policy in place that says that you can lie to a parent. JBAB clearly violates FERPA.
Thank you for your testimony. Appreciate it. Chris Urchel and Karen Hill, I can read it here, is next.
Thank you, Chair Pearson. Thank you, members of the committee. It's been a long day. Bear with me. My name is Chris Urchel. I'm an attorney with GLBTQ Legal Advocates and Defenders, better known as GLAD. I am here to talk exclusively about page 4, lines 4 through 9, subsections W, X, and Y. Other people have done a great job testifying about other aspects of the bill, but I'm here to speak in opposition to those specific provisions. Teachers at public schools come into contact with information about students' identity development in countless ways. That might include, for instance, say a Muslim student who decides she doesn't want to wear her hijab in class anymore. Is it a teacher's obligation to disclose that information to a parent? Maybe it is, maybe it isn't. Maybe the circumstances are dependent. What this bill does, which is unusual and untenable, is it singles out one characteristic of student identity, and that's a student's gender identity, and says that's subject to a different standard for teachers. This bill could easily say that whenever information is requested by a parent about any aspect of a student's development at school, that the teacher or school personnel must tell the truth. Instead, the bill doesn't do that. It singles out transgender students because of their gender identity, and that's it. That's the only identity aspect that's identified in here. And that's a huge problem. That's unconstitutional. It singles out a group of people for different treatment under the law, and that's not what the law does, and not in New Hampshire and not in the United States. I also want to flag that subsection Y, which refers to the right to know about what extracurricular activities or clubs a student is participating in, is especially problematic for students who are questioning their identity and are looking for a safe space to join a club, to talk to their peers in a safe space. And I know you've heard countless people talk about this today, but it cannot be underestimated how critical that can be for a child's safe and healthy development. It doesn't mean the kid's not going to talk to their parents. It means the kid is having a moment where they need to be able to go into a safe place. And that access to that place isn't
10
going
seconds.
Okay, access to that place, a kid is not going to feel comfortable going in there if they know that it's going to be broadcast to other people, even back home. So in conclusion, schools work in partnership with parents. I think that's great. I think it's bad that this bill singles out transgender people.
I got a question. I have two. Back to the hijab. If a Muslim parent asked a teacher, is your child wearing one? Would you be comfortable with the teacher giving the truth?
This bill says nothing about
I'm
that.
not asking that.
Yes. If any question is asked about student development, I think the teacher should. Honestly, I don't think teachers should ever be giving misinformation to parents or lying to parents about any aspect of a student's development or a student's identity. This bill could address that potentiality by prohibiting it, but instead it singles out one aspect of student identity and says that's subject to a special version of scrutiny. That's what's untenable about
Well, I
the
know
bill.
you brought us back to that just
Mhm.
now. Very well done, by the way. You're welcome. But you opened the door because you broadened it. What about? And you used that example. So I just
Mhm.
wanted to see if the teacher.
So you're setting up a hypothetical.
Yes, it is.
So setting up a hypothetical
And
where
that's
a
an
concerned
amendment.
parent comes to school
Mhm.
personnel and asks the question: "Is my kid wearing her hijab in class?" And if a teacher were to say, "No, I mean, yes, your kid is wearing a hijab just like you expect," and that's not true, that would be very unusual. I've never heard of a teacher blatantly lying to a parent upon an inquiry like that.
Okay.
But if that did happen, I wouldn't be here opposing a law that would prohibit that. I'll just say that.
Okay, and my other question is, suppose one of my grandchildren, in spite of you do everything you can, decides to join the Confederate Army Club,
Mhm.
and they go through battles and they tweak them so their guys win, and everything that went behind that.
Mhm.
And I thought some little strange things were going on at the house, and I said to the teacher, did my kid join a Confederate Army club at school? Would you be comfortable with the teacher saying, yes, he did?
Actually, I think clubs are a special case. I think where students want to engage with, who knows why the kid is attending that club, right? Teacher doesn't know why. The parents probably have a better idea than anyone about why. And I think that's an excellent opportunity for a teacher to say to that parent, excellent opportunity for the teacher to say to that parent, to engage with that parent and say, this is a conversation you really need to be having with your kid. What support can we give you as a school? We have school counselors, school psychologists, guidance counselors, and social workers. What support can we give you to make you able to have this conversation at home with your kid about the things that are concerning you? I think that is a totally appropriate response, but I don't necessarily think that joining a club, especially a Pride Club or a GSA, I don't think that information should be made available ever.
Thank you.
Thank you. Any other questions?
They want me to go to law school. I'm trying to resist.
Thank you
Okay,
to the
next,
committee.
thank you. Next up is City Councilor Karen Hill from Lebanon, followed by Merrick Finn. Is Merrick Finn here? Merrick was called once before, don't see. Kevin or Kerry Coventry here? You? He's gone. Okay. Well, anyway, we have Councilor Hill.
Great. Thank you very much. My name is Karen Leo Hill. I'm an 18-year Lebanon city councilor and mother to 2 children, one of whom is here with me today and is also on your list to testify. I'm 44. I was born in 1978. As a child growing up in a small, charismatic evangelical church, I remember that homosexuality was a taboo topic. I remember when I was around 10 years old, the pastor of the church had recently discovered that his teenage son was gay, and he rebuked his son in front of the congregation and made him leave the sanctuary. A couple years later, my best friend's older brother was outed to his parents, and they made him move out. Most parents love their children and want to have open and honest communication and loving relationships. But unfortunately, that is not always the case for all families. As legislators, you are being asked to consider those circumstances when people don't have the safest home situation. That's what this legislation is about. Unfortunately, these stories that took place 30 years ago are not relics of the past. Some families today still cannot accept their children and will not allow them to freely express themselves at home. And for some children, the only place they may be able to express themselves freely is in school. To me, this bill is about safety and health and what's in the best interests of our children. We know that teenagers are facing a mental health crisis. We know that queer teenagers, especially trans youth, are at the greatest risk of harming themselves. This legislation has the potential to put many New Hampshire youth in traumatic and stressful situations, like the ones experienced by my pastor's son, by my best friend's brother, and even my own uncle. We have a chance to make the world a better place for today's kids, at least our beautiful, independent, freedom-loving corner of the world. In the interest of the health and safety of Granite State children, please vote this ITL.
Thank you, Councillor. Stephen LaFond here or gone? Andrew McPherson? Janine Babert? I'm sorry? Gone. Zoe Hill? Zoe Hill. Also from Lebanon. Do you know City Councilor Hill?
I've never met her in my life.
She and I go back, it's got to be 5 minutes.
Good afternoon, representatives. My name is Zoe Hill. I am a 16-year-old junior at Lebanon High School. I'm here today to oppose HB 10. This bill will not directly affect me because I am lucky enough to have parents who support me and my identity as a trans kid. But I know multiple people who could face true harm if this bill passes. They are out in school, but not necessarily at home because their families would not accept them if they found out that they were trans. If this bill passes and their parents did find out they are trans, then their homes would become an even more dangerous place for them. In conclusion, please oppose this bill for the sake of trans kids all across the state of New Hampshire. Thank you.
And thank you for coming. Heather Mullins? Deborah House? Kendra Ford? Kendra Ford? Hi, Kendra Ford.
You just speak up.
Oh, I'm sorry. You
I
are.
haven't got the microphone yet.
I didn't think you were Kendra Ford. I can somewhat remember occasionally.
That's fine. I haven't been before your committee before, so it's my first time.
Deborah House.
Yes, Deborah
Yeah,
House.
Deborah House.
Good evening. I think
Welcome.
it is after 5. Okay. Thank you. Thank you, Chairman Pearson, for hearing my testimony. Yep, you got your watch. Great. Okay, my name is Deborah House. I am president of the American Federation of Teachers New Hampshire. We represent about 4,000 pre-K through 12 teachers and other school staff, university faculty, and public employees across the state of New Hampshire. And I'm here today to oppose this bill. It's not that we don't want to be working with parents. We actually understand and really crave the ability to work as a support team with parents, but we know that that does not happen in all situations. Sometimes there are situations where we cannot be on the same side with parents all the time. But with this specific bill, I want to make a few quick points. The penalties in this bill are problematic, where you could lose your license for violating any part of the bill. There's some vague wording here about each parent directing their own child's education, which sounds lovely, but when you have a classroom of 20 kids and each individual parent wants something different for their child, how do you manage to teach all of those children in the classroom? That's a concern, but the biggest thing is that in a public school, teachers and school staff are responsible for making sure that each and every student is welcomed and feels safe at school. We are responsible under our code of conduct for treating them with respect. And the parts that have been pointed out here would require discriminating against some of our students. And we can't accept that. I mean, that's why we're opposing this bill. We will not treat some of our students with, discriminatory practices as this bill will call for. And you put us in a position of possibly losing our license and our job if we violate that position, or violating our code of conduct, which also comes with loss of license and job. It's not a great position to be in, and you are in a shortage of educational staff in this state in all positions. So it really is not the best thing for our students who need teachers in the classroom to educate them.
I have
That's why
no
we oppose
idea
it.
how long you've been testifying because I wasn't looking and he left, but you made a great presentation. I'll give you 15 seconds more if you want it. Or you're
That's
good.
about all I want to say.
You're good.
Otherwise,
Okay.
I would have to go on to another topic, and it would be more than 15 seconds. I could say more, but I think, in
All right, would you-
recognition of the lateness of the day and your patience.
Would you believe in 16 years of teaching graduate school, all of my students wanted individualized curriculum too?
I'm sure they did.
Thank you very much. It gets worse the older they get. All right, Kendra Ford, please. Kendra Ford? No, Kendra Ford. Don Johnson. Don Johnson? No, Don Johnson. You know I run a loose committee. I'll take much more of that. Rusin Chester.
Thank you, committee chair. Thank you, committee members. I'm going to keep this very brief, partially because I was not in here for a lot of the testimony, and I don't want to repeat anything. But I'm here today for two people. One was a trans kid, and the other was her mother. I was the case manager. She was an abused young child. The mother did the appropriate thing and protected her child. She went on to school. She was part of the One Trusted Adult program. She came out to at 12 years old, she came out to a teacher, and it was kept from the mother. They started her on transitioning with hormones in the school system without parents' knowledge. They so at 12 years old, they started transitioning her. At 16 years old, she took her life. But she took her life because she wanted to detransition, and she didn't feel like she had anyone to talk to. But more importantly, as the case manager, I hold some responsibility, and that's why I'm here for Desi today, because Desi was being abused sexually by that one trusted adult. The bottom line is predators exist in our world today. Secrets are what predators rely on. Unfortunately, predators are going to go where their resources are, which is our school systems. Same thing with, there's bad people in every profession.
You got 15 seconds to wrap it up.
So one of the things I heard a lot about today is we're criminalizing educators. The other side is we're criminalizing parents. This is not okay. This should not be about us and them. We should be working together collectively, and that's why we need a parental bill of rights. I call it parental right to know. Thank you.
Thank you so much. You have a question. You may ask your question.
Thank you, Mr. Chairman, and thank you for indulging me. You said that a school district put a child on hormonal medication without informing their parent. Where was this?
That's correct. Here in Concord, New Hampshire.
When?
Desi's been gone 2 years. So 16, she started at 13, 4 years ago.
I guess I'm struggling to understand how a school district has prescription abilities.
Unfortunately, the way our systems are working right now is through our behavioral health programs. Many of our behavioral health programs in the schools are run by Planned Parenthood, and they have the ability to give kids these prescriptions.
Okay.
Thank you.
A politician that I remember once said, "Trust but verify." And I don't say you're giving false information. I'd like to have more direct documentation, and if you could mail it to the committee, I think that would help your testimony along. So thank you for testifying before us. And the chair recognizes Eliza Tweedy.
Good evening now. Thank you so much for your time. My name is Eliza Tweedy. I'm the pastor at First Church Congregational in Rochester, New Hampshire. I am also a mother of 3, all of whom have been educated in New Hampshire public schools. One of the first things I learned as a parent is that my children are their own humans, whether I like it or not. My faith tells me that they are not my creation, but God's. I have the privilege of guarding and caring for them, but that is enough, because through them I can see the fullness of God's creation. Who they are, how they live their life, may or may not follow my values or morals, and that's okay, because God's love is bigger than my understandings. It is normal for a child to push back against their parents to create a sense of self separate from their parents, to explore, experiment, and learn. That is normal and natural and good for those of us who want our children to become members of society capable of critical thinking and thoughtful engagement. If my children do not trust me enough to include me in their lives, their questions, and their explorations, that is a failure on my part to be a person that they trust. That is a me problem. When I was a young person, there were many adults in my life who guided and loved me. I could express to them my sense of self with less anxiety than I could to my generally very supportive and loving parents, because losing that adult would have been less traumatic than losing my family. And they gave me the courage to live into my truth. They saw the image of God in me and helped me see it in myself. I want the same for my children, and I am grateful to the teachers and other adults in their lives who have allowed them to become the individuals that they are becoming. This bill does not speak as much to parental rights as it does to parental control. It takes away a child's ability to explore their sense of self outside the family unit in ways that feel safe to them. And whatever you want to believe, this bill disproportionately affects LGBTQ+ students who may have been perfectly safe at home while closeted, but will be targets of psychological, emotional, spiritual, and possibly physical abuse if their identity is disclosed. My faith tells me to stand firmly on the side of those who are most likely to be harmed. The removal of safe spaces to be themselves is not a question of parental rights, but of emotional, spiritual, and psychological control.
And you have
often
15
in the name
seconds
of
to
religion.
wrap it up.
Yes, sir. It is correlated strongly with increased depression, anxiety, suicidal ideation, and self-harm, which is not the outcome anyone wants for their children. Because that first lesson I learned remains, I can do my best to love my children and try to guide them, but I cannot change who they are or force them to trust me. I can only hope that the beloved community will. I pray that there will be someone else who can see the fullness of God in my children until I can get out of my own way and see it myself. Thank you so much.
Thank you so much. Raymond Breslin, we may have called him this morning and the card got back over here. So if somebody else is named Raymond Breslin, I guess not. And we're getting to the end here. Christine Perez. Do we have a Christine Perez? We are Christine Perez-less. Was that?
Yes.
Wow. Okay, David Kendall. David Kendall has not testified yet.
No. Good evening. I was the 14-year-old runaway, homeless, trans kid that has been referred to here many times today. I'm torn because I'm a gay man. I was trans for over 20 years. And I know that place. And so I'm torn. But I'm not as torn to oppose this bill. Why? Because I was a transgender woman for over 20 years. I was a member of the LGBTQIA gender movement for over 30 years. I have lived, breathed, and I have been this movement. I didn't live a lie, I became the lie. With very graphic, sexualized books making their way into schools, classrooms. You cannot tell me there's not an agenda. Digital analyzers said nearly 350 K through 12 educators have been arrested on child sex crimes in 2022. I loved my teachers. Parents must be the only ones making the decisions on whether or not their children are reading, viewing, or being taught about same-sex sex, opposite sex, or any sex at all. All of these terms, all of these cis, CIS, gender, these were coined by scientists. These are theories that were coined by scientists, John Money, Alfred Kinsey. These men were documented pedophiles. Documented pedophiles. I have heard the parents after their sons or daughters have tried to take their lives. I'm actually the one that they call. They've been secretly and aggressively been told by teachers and counselors that they will willingly hide crucial information, which only tells these children that it is okay to deceive, to lie to, and to hide things from their parents. The parents are the sole decision makers when it comes to their children. I was targeted. I was groomed. I was molested my entire childhood. I ran away from home because I couldn't be trans. And I lived on the streets of Philadelphia, where I started hormone therapy. I sit before you, a 50-year-old gay man. I'm LGB.
You've got 20 seconds to finish up.
I have osteoporosis, which is an elderly woman's disease, and I've had it before the age of 30. I've also been sterile since before the age of 30. So these are the concepts that are leading children into so much darkness. And we need a medium, because honestly, I don't know whether to oppose or to affirm the bill, because there's no medium, and there must be one. Thank you.
Would you take any questions if people
Yes,
have any?
absolutely.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for your bravery today in speaking with us. Would you please email to us your testimony today?
Absolutely. I have copies right here as well.
Thank you.
I can hand them out.
If you could hand them out,
Absolutely.
please. Thank you.
Thank you.
Before you do, is there, I really don't know the answer to this. I'm not, pretending I don't. Is there a group or a movement of people who went trans and
Yes,
regretted it
I'm
and
what
has
they
come
call,
back?
I am
and-
what they call a detransitioner.
Okay.
And there are thousands of us out there.
What percentage, to your knowledge, of those people, those folks, have had massive hormonal injections and or surgery?
All of the detransitioners that I know have went through hormone therapy and or surgical procedures.
And they regret it?
Absolutely.
Thank you. Any other questions? Anybody other questions?
Thank you.
Seeing none, thank you so much. And we did it, as Representative McMahon said, while we were yet young. This concludes the hearing on House Bill 10. It will be exec. We will meet next Tuesday. We will have the hearing and the executive session on 475. We will exec everything that's left. This is crossover week next week coming.
Mr. Chairman?
Oh, excuse me. I'm sorry. Representative, excuse me for that too. Attorney Head, I'm looking at your card. I'm clearly not a head case, though many would deny it. Come on up. I'm sorry, everybody. I'm looking right at it.
If you can, after you've called the hearing, I don't know if you can actually. Bang the gavel again.
I'm going to have to bang my head with the gavel.
Mr. Chairman,
Mr. Chairman, I have a question just to clarify. The ones that were on our agenda to exec today, we didn't get to, will be next week. Is that correct?
Next week.
Thank you. I appreciate it.
Or you can stay late, but I'll be leaving.
nothing like being the last witness after 4 hours. Thank you, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I come with a request for what I think is a technical amendment, and I'll reference both on the bill as introduced. It's page 3, line 13 to 15, In the amendment.
Of
it's-
the amendments.
if we go by the amendment, it's page 4, line 28. And what I've handed out is the proposed amendment. And then the second page of what I've handed out is the statute that is referenced in the bill. And I'll explain the reason why I'm asking for the amendment. The statute, so this section of the bill starts, this section shall not. And it identifies what that section does not apply to. And B is it, the section shall not prohibit a court of competent jurisdiction, law enforcement officer, or employees of a government agency that is responsible for child welfare from acting in his or her official capacity. What we're asking is that there be a period there because the rest of it would result in this paragraph having no meaning, because it then goes on to say within the reasonable and prudent scope of his or her authority pursuant to RSA 186.11.9C. 186.11.9C is a duty of the Department of Education. So none of the entities listed in this paragraph are the Department of Education. Actually, I'm sorry, this is a school district obligation relative to the State Board of Education. So because none of the entities, including what I care about is a court, has any duties under this statute, they would never be acting pursuant to it. So therefore, this exception doesn't exist as it's written. So what I'm asking for, and I briefly spoke with the speaker and the representatives who introduced the bill about striking that. I didn't think it was an issue, and I don't think it is, but I just wanted to flag it for you. It just simply gives the paragraph the meaning I think it was intended to have.
So this has nothing to do with ideology, wearing a hijab, belonging to a club. This simply has to do with getting the statute cited right.
Need a little technical amendment.
Wow.
Otherwise, no position on the bill.
Thank you.
Thank
All
you.
right. To anybody's knowledge, is there something else I'm supposed to do? Has everybody with a pink card been heard? Yes. Have you sold all your Girl Scout cookies? Good. Okay. We are now officially done. Thank you. My cookies.